GMCPC fresh matters all from Monday. Give it on seniority. Wait. GMCPC first ಕೊಟ್ಬಿಡಿ. Wait, 2:30. Wait, sir. Many mentioning. Please wait. GMCPC ಆಯ್ತಾ ಅಲ್ಲ? ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಆಯ್ತಲ್ಲ? ಓಲ್ಡ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ಟೂ 2001 ಡೈರೆಕ್ಷನ್ ಏನು 2001 ಟೂ ಮಧ್ಯದಲ್ಲಿ ಮಿಸ್ ಆಗ್ಬಿಟ್ರೆ ಏನು? Wait, yes. You want to come here? Then wait, yes. Next Thursday, give it, sir. Yes. ಅದ್ರಲ್ಲಿ ಏನಾಗಲ್ಲ ಕೊಡಿ. ಏನ್ ಮಾಡಿ ಒಂದು ಮೆಥಡ್ ಇದೆ ತಾನೆ, ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರ್ತಾ ಇದೆ ಅಲ್ವಾ, ಕೊಡಿ. ಏನೀಗ ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಖಾತಾ ಚೇಂಜ್ ಇಲ್ಲಾಕ್ ಬರುತ್ತೆ? ಏನ್ನ ಆಯ್ತು ಕೊಡಿ, ನಾಳೆ ಕೊಡಿ. ಯಾಕೆ? ಪರವಾಗಿಲ್ಲ, ನಾಳೆ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಅದು ಅರ್ಜೆನ್ಸಿನೇ. ಯಾಕೆ? ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಯಾಕೆ? ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಯಾಕೆ? ಆಲ್ರೆಡಿ ಅನ್ ಬೇಯಿಲ್ಲ. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಮಂಡೇ ಏನ್ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಯು ಆರ್ ಇನ್ ಡಿಫಾಲ್ಟ್, ಅದಕ್ಕೆ ಏನ್ ಪರವಾಗಿಲ್ಲ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಯು ಆರ್ ಇನ್ ಡಿಫಾಲ್ಟ್, ಅದಕ್ಕೇನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಎಲ್ಲಿವರೆಗೂ ಇವೈಡ್ ಮಾಡ್ತೀರಾ ಡೆಪಾಸಿಟ್? ಎಸ್, ಈಗೇನ್ ಯಾವಾಗ ಕೊಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್ ಸರ್. ಮಂಡೇ ದೇರ್ ಆರ್ ಆಲ್ರೆಡಿ 500 ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್. ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಅದು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ಅಲ್ಲ ನೀವೇ ಹೇಳಿ, ಹಳೆ ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ಸರಿ, ಅವರು ಅಲ್ಲೂ ಇದೆ ಆ ಥರ ಫೈನಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ನೀವು ಹೇಳ್ಬಿಡಿ ಹಳೆ ತಗೊಳ್ಳೋದು ಬೇಡ, ನಮ್ದೇ ತಗೊಳ್ಳಿ ಅಂತ. ಸರ್, ನಾನು ಏನೋ ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಡೋಂಟ್ ಬೆಗ್ ದಿ ಕ್ವಶನ್, ಗಿವ್ ಅನ್ ಆನ್ಸರ್. ಹಳೆ ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ತಗೋಬೇಕು ತಾನೆ, ಕೊಡಿ. ಎಸ್, fresh matters you give, it will only be according to seniority. What urgency? Evidence started. It's okay, give it. Yes, no, adu seniority mele. Yes, it will come Monday or Wednesday, definitely will come. Why? What for? What for is for tomorrow. ಅಷ್ಟೇ ತಾನೆ. ಏನು 711 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ? 2:30 ಏನು ಅರ್ಜೆನ್ಸಿ 711 ಅಲ್ಲಿ? ದಟ್ಸ್ 711 ಹಾಕದೆ, ಅದಕ್ಕೆ ಇರ್ಲಿ. ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ? ಕೊಡಿ, ಗಿವ್ ಇಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ. ಏನಾಗಲ್ಲ ಬಿಡಿ, ಆಯ್ತು. 2:30 ತಗೊಳ್ಳಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? 2:30. ಈಗ ಏನಾಗಿದೆ ಹೇಳಿ ಸರ್? ನೀವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ 1950 ಬೇಕಾಗಿಲ್ಲ, ಇವಾಗ ಏನಾಗಿದೆ ಹೇಳಿ? ಅದೇ ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು, ಕೊಡಿ 2:30. ಎಸ್, ಗಿವ್ ಇಟ್. ಟ್ಯೂಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ, ಗಿವ್ ಇಟ್. ಎಸ್, ಆಗ್ಲಿ ಬಿಡಿ. ನಿಮ್ಮ ಮೇಲೆ ಯಾಕಾಗಿದೆ ಮತ್ತೆ? ಗೊತ್ತಿಲ್ವಾ? ಒಂದು ನಿಮಿಷ, ಒಬ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, ನಾಳೆಗಾಗಲ್ಲ. ಸೊ ವಾಟ್ ಸರ್, 19th ಯಾವತ್ತು? 19th ಯಾವತ್ತು? ಸೋಮವಾರ ಏನು? 14th ಅಲ್ವಾ? 14th ಇಸ್ ಬಿಫೋರ್ 19th. ಎಸ್, ಅದು FR ನಂಬರ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಬರೋದು. ಎಲ್ಲೇ ಬಿಡಿ ಯಾವ್ದಿದೆ ಎಲ್ಲ ಕೊಡಿ, ಎಲ್ಲ ಬಿಡಿಎ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಡೆಸ್ಪೈಟ್ ಏನಿಲ್ಲ ಕೊಡಿ. ಯುವರ್ ಡೆಸ್ಪೈಟ್ ವಿಲ್ ನಾಟ್ ಗೆಟ್ ಇನ್ ರೆಸ್ಪೈಟ್, ಗಿವ್ ಇಟ್. ಎಸ್, ಗಿವ್ ಆಲ್ ದಿ ಬಿಡಿಎ ಮ್ಯಾಟರ್ಸ್. ಈಗ ಏನ್ ಬೇಕು? ಯಾಕೆ ಇರ್ಲಿ? 2:30 ತಗೊಳ್ಳಿ. ಎಸ್, give it, no problem. There is a stay already. Leave it. Yes, that's a different thing. Yes, auction cannot take place if there is an interim order. Yes, next. What is for tomorrow? Auction. What is auction then? No. Give it. Yes, let it come. Yes. No. Yes. ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಎಲ್ಲ ಕೊಡಿ ಮಂಗಳವಾರ. ಅಲ್ಲನೂ ಇಲ್ಲ ಏನಿಲ್ಲ ಕೊಡಿ. ಎಸ್, ಏನಿಲ್ಲ ಆಗಲ್ಲ ಕೊಡಿ, ಏನ್ ತೊಂದರೆ, ಏನೂ ಆಗಲ್ಲ. ಮುರಳಿ ಬಾಬು ಮೂವ್ ಮಾಡ್ತೀರಾ? ಕೋರ್ಟಿಗೆ ಬರೋದೇ ಇಲ್ಲ. ಮೊನ್ನೆ ನೀವಿಲ್ದೆ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು, ಕೊಡಿ. ಎಸ್, ನಾಟ್ ಲಿಸ್ಟೆಡ್. ವಾಟ್ ನಾಟ್ ಲಿಸ್ಟೆಡ್? ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಮ್ಯಾಟರ್ ಮೊನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಾಟ್ ಟು ಡಿಸ್ಪೋಸಸ್ ಅಂತ. ಇವತ್ತು ಮತ್ತೆ ಅದಕ್ಕೆ ಮೆಮೊ ತಗೊಂಡ್ಬಂದಿದ್ದೀರಾ. ಬಿಕಾಸ್ ಯು ಡೋಂಟ್ ನೋ. ಕೋರ್ಟ್ಗೆ ಬರೋದೇ ಇಲ್ಲ, ಮೂವ್ ಮಾಡೋದು 2:30ಗೆ ಕೋರ್ಟ್ಗೆ ಬರೋದೇ ಇಲ್ಲ. ಏನ್ ದಟ್ ಡೇ ಓನ್ಲಿ ಯು ಕೇಮ್? ಐ ಗ್ರಾಂಟೆಡ್ ಅನ್ ಎಂಟ್ರಿ ಮಾಡರ್ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸಸ್, ಅದನ್ನೇ ಮತ್ತೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಏನಾಗಿದೆ ಅಂತಾನು ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ. ನಾಟ್ ಬಾದರ್ಡ್. ಕೊಡಿ ಸರ್, ಎಲ್ಲ ಕೊಡಿ. ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಎಲ್ಲ ಕೊಡಿ, ಏನ್ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಯುವರ್ ಡಿಸ್ಪೋಸಿಷನ್ ಐ ಹ್ಯಾವ್ ಸೀನ್, ಕೊಡಿ ಸರ್. ಗಿವ್ ಇಟ್. ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಸರ್, ಗಿವ್ ಇಟ್. ಎಸ್, ಗಿವ್ ಇಟ್. So what? Monday, give it. 15th is before 14th is before 15th. Give it. Yes. Correct. Yes, that's why. Kodi. Wednesday. Yes.
And another memo, my miscellaneous appeal as against an ex parte decree was dismissed, as against which I filed a CRP. There is an
CRP is Thursday. Give it.
Yes. Monday,
GMCPC
is concerned Monday.
GMCPC will come on.
Memo for withdrawal matter, separate withdrawal
petition. When do you want? 11:30?
Tomorrow it may be.
Give it. Yes.
Memo for withdrawal.
Lordships kindly, on 24th of April, my lord, your lordships had granted an interim order in a surfacey matter.
Surfacey matter?
Please, my lord. We went to deposit the amount, my lords. They are not accepting it, my lord.
ಇಲ್ಲಕ್ಕೆ ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ ಸರ್. No.
For modification, I filed an IA.
No. ಈಗ ಅಲ್ಲಿ ರಿಮೈಂಡ್ ಮಾಡ್ತಾರೆ ಅನ್ಬಿಟ್ಟು ನನ್ನ ಹತ್ರ ಬರ್ತಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ. For modification, I
No modification.
an IA, my lord.
Nothing. Move that court. No.
Doorstep to take physical possession, my lord. Kindly have it.
Nothing. ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ. Move the GM courts.
No, my lords. In fact, I was directed to move it before your lordship.
Who said, sir?
Because I have
Who
filed
said?
an IA for modification of your lordship's interim.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿಫಿಕೇಶನ್ ಇಲ್ಲ. ಎಸ್,
Kindly, my lord. Reporting a settlement.
ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕಿ. ಇವತ್ತೇ ಬೇಕಾ? ಆಯ್ತು, 2:30. ಅದು ಎಷ್ಟು ಸರಿ ಮೂವ್ ಮಾಡ್ತೀರಾ? ಅಯ್ಯೋ ಬರ್ಲಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ದುಡ್ಡು ತಾನೇ ಬರ್ಬೇಕಾಗಿರೋದು ನಿಮ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಹಾಕಿಸ್ತೀನಿ.
Application to
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. Wait. 2:30. Yes. GMCC. Give it. Fresh matters, please give, sir. Please give. GMCPC fresh matters, please give. Fresh matters, please give. Give it, sir. Fresh matter alva. 2013 matter. CRP. Give it. No, Thursday it will come, give it, yes. 2013 matter ಯಾವ್ದು ಹಾಕಿ ಮೇಡಮ್. ಕತೆ ಹೇಳ್ಬೇಡಿ, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳಿ. 20 ಅಲ್ಲ 2013 ಅಂದ್ರೆ 2013 you said? You have written 23. Oh, I know. It will come. Don't worry. No, don't worry. It will come. Yes. Don't tell the date of the suit. Yes, give it. Land acquisition.
Land acquisition. CPC I will file a suit for partition in separate position.
ಈಗ ಯಾವ ಅಪ್ಲಿಕೇಶನ್ ತೊಂದರೆ ಆಗಿದೆ ಸರ್?
GMCPC ಅಲ್ಲಿ ಆರ್ಡರ್ 39 ರೂಲ್ 1 and 2 ಅಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
ಸರಿ, ಏನಾಗಬೇಕು ಅದು?
230 ಸೈಟ್ ಕೊಡೋದು.
230.
Objected application but in the execution dismissal, threat of dismissal.
ನಿಮ್ಗ ಯಾವ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೊಡಿ. Yes, no problem. Monday.
Matter pertains to a pontiff of a Met, my lords. There has been an interim order which has been obtained ex parte, my lords, before the courts below by stating that my lords, he is not a pontiff of the Met at all, my lords.
Give it, sir. No.
And I have made an application, my lords, for vacating of the interim order. So now the auspicious month of Chaturmasa begins, my lords.
Yavaga, sir?
I am being dispossessed, my lords. Already it has begun.
No problem.
The month of Chaturmasa.
No problem, it will come.
I am being dispossessed.
Wednesday or Friday it will come, give it.
My lords, sir.
No, sir. Give it.
My lords, at least.
No, tomorrow, sir. Yes.
CRP
Extreme
matter.
urgency.
By
Extreme
quoting,
urgency.
ಏನ್ ಪಾಂಟಿಫ್ don't ತೊಂದ್ರೆ ಇಲ್ಲ.
by quoting,
Serious issue. Don't worry, sir.
Your lordship's back.
No problem. Wednesday ಬರುತ್ತೆ. Yes, Wednesday.
by quoting my survey number, my lord, the other party has obtained an.
No problem, give it, sir. Yes.
Kindly. 230, my lord.
No 230, sir. Give it.
Yes.
ಏನ್ 230 ಏನಾಗಿದೆ ಅದರಲ್ಲಿ?
My lord,
CRP
none-
ರಿಜೆಕ್ಟ್ 711 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಅದ್ಲೇನ್ ಅರ್ಜೆನ್ಸಿ ಕೊಡಿ ಸರ್.
ಅಲ್ಲ, they are not allowing me to enter my own property.
Thursday, yes.
ಅಲ್ಲ, ಆಗ್ಲೇನೆ ಇದಾಗಿದೆ sir.
List on Thursday, give it, yes.
My lord, permission of
Kindly, at least tomorrow, my
No,
lord.
sir. No, Thursday you want to take it or next Thursday, yes.
permission application to file the written statement is
ಏನಾಗಲ್ಲ
rejected,
ಕೊಡಿ.
my lord. Application to file the written statement is rejected, my lord.
Correctly rejected. Give it, yes, no problem. No urgency ಅದರಲ್ಲಿ.
The evidence has been
No problem. Yes. Evidence stage ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅದೇ ಆಗೋದು. Yes.
2009 FTP membership, 1991 OS by last.
ಈಗ ಯಾಕೆ ಹಾಕಿ? ಮ್ಯಾಂಡಮಸ್ ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. No problem, give it, sir. No issues, give it, sir, give it. Give it, sir. No, sir, yes, no problem, give it, yes. No, sir, give it, Wednesday or Friday, next Wednesday or Friday, give it, yes. No issues. What were you doing till now? Give it, sir. So this year began in January, sir, yes. No, nothing, yes. List after 2 weeks ಅಂತ ಮಾಡಿ ಅದು. ಮತ್ತೆ 2001 ಅಂತ ಇದ್ರೆ 2021 ನಿಮ್ಗೇನ್ ಬರಲ್ವಾ? ಮತ್ತೆ ಕೊಡಿ.
Right, CPC.
ಡೇಟ್ ಇಲ್ಲ ಕೊಡಿ. ಕೊಡಿ ಸರ್. Don't tell me stories unless there is urgency, give it. Yes. ಏನ್ urgency is there? ಅಷ್ಟೇ ತಾನೆ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಬರುತ್ತೆ ಬಿಡಿ. No Monday, Tuesday or Thursday it will come. Yes. ಒಂದು ನಿಮಿಷ ತಾಳಿ, ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು ಕಾಣಿಸ್ತಾ ಇಲ್ವಾ? ವೈ ಹರಿ? Heavens are going to fall? Trial court ಇದು. Yes.
CRP for Monday.
CRP won't come on Monday, give it. Give it, it will come on CRP day, give it. ಏನು ಮಾಡಕ್ ಈಗ ನಿಮ್ಮಿಂದ ಕೊಟ್ಟಿರೋ ಮೆಮೊಗಳನ್ನ ತಗೋಬಾರ್ದಾ ಹೇಳಿ? ನೀವು ದಿನ ಫ್ರೆಶ್ ಆಗಿ ಮೆಮೊ ಕೊಟ್ರೆ ಅದು ಹಿಂದಿನೆಲ್ಲ ಬಿಟ್ಬಿಡ್ಬೇಕಾ? ಇಲ್ಲ ತಾನೆ, ಸುಮ್ಮನೆ ಇರಿ. ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. Yes.
GMCPC, my lord. Creative has bought export order and stopped my construction, my lord.
Give it.
My slab is stopped.
Vacating stay ಹಾಕಿದ್ದೀರಾ? Vacating stay ಹಾಕಿದ್ದೀರಾ?
Stay ಆಗಿದೆ, but objection post ಮಾಡಿದ್ದಾರೆ. It is not.
ಬರಲಿ, vacating stay ಅಲ್ಲಿ ಬರುತ್ತೆ ಬಿಡಿ.
CRP, my lord, it was directed to.
If you have filed vacating stay, it will come. Yes.
CRP, my lord, it was directed to be listed today. It was
Next Thursday, give it.
next Thursday.
Media matter, my lords, my allotment is.
VDA, give it, sir.
RP pertaining to the earlier Justice Sanjay Gowda's judgment, my lord. has to be performed.
RP ನಾಳೆಗೆ ಹಾಕಿ ಅದು. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್.
pending, my lord, stay is granted, my lord, he is more than 80 years old. my lord.
Give it, madam. Vacating stay hakide. Have you filed vacating stay? It will come, leave it.
One
Yes.
more matter, my lord, order 6.
Give it. Vacating stays alla kodi.
I have been moving memos, my lord.
We'll post vacating stays on Wednesday. Give it.
My lords, a CRP, my lords.
Give. Short accommodation. ಇಲ್ಲಿ ಸರಿ ನೋಡೋಣ ಬಿಡಿ. Yes, next. Sir, what to do? Previous memos should be ignored, is it? It will come according to seniority. Give it. ಯಾವ memo ಕೊಟ್ಟಿದ್ರೆ ಅದ್ರ pending ಅಲ್ಲಿ ಬರುತ್ತೆ.
Service matter.
Service matter.
The last bench was made as a not before me. Then this bench was heard. I am given a date on 18th. On 18th, we have engaged the senior counsel, he is not available. Can you have on 17th? We have already informed the other side.
Let it come, we'll see.
17th.
List ಆಗಿಲ್ಲದೆ ಇರೋ matter move ಮಾಡ್ಬೇಡಿ. Yes, next.
Please, my lord. In 59th matter, the petition.
No adjournment. Yes, wait.
Kindly fresh matter tomorrow, my lord.
ಏನು?
14th ಗೆ trial court
ಏನಿದೆ? ಯಾಕೆ?
Submit of evidence. ಅದು unregistered document with possession that is been permitted for collateral purpose ಅಂತ how.
Correct, it is correct only.
For that, my lord.
It is correct only.
No, my lord, they are totally relying on those documents. It is
Correct only.
It is plain.
Yes.
Plainings ಅಲ್ಲಿ ಇರೋದ್ರಿಂದ.
ಏನ್ suit for what?
Suit for declaration. They are relying on that.
Monday.
Tomorrow, my lord.
ಏನ್ ಪರವಾಗಿಲ್ಲ
ಅಲ್ಲ,
ಕೊಡಿ
Monday trial court ಅಲ್ಲಿ
So what?
mark ಮಾಡ್ಬಿಟ್ರೆ purpose
ಆಯ್ತು ನಾಳೆ ಕೊಡಿ.
Lords, CRP, my lords, for 230, my lords.
230 CRP. Wait.
Please, my lords, since 2009, my lords, I am there for rent, my lords. Now they have, Work Tribunal has passed the eviction order. my lords.
711 application reject ಆಗಿದೆಯಾ?
No, my
Small
lords.
causes ತಾ?
Please, my lords.
ಕೊಡಿ. Lots. 230 ತೊಗೊಳ್ಳಿ.
There is a delivery warrant in this. Delivery warrant has been issued, my lord. Today 2:30, my lord.
Yes.
At least tomorrow, my lord.
We'll see tomorrow ತೊಗೊಳ್ಳಿ ಡೆಲಿವರಿ ವಾರಂಟ್. ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್? FR number ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ. ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
Mallards, right to CPC, Mallards.
ಹೇಳಿ ಈಗ.
FDP 2010 matter, Mallards. Now the trial court has allowed the impleading applicants, third parties, Mallards.
ಕೊಡಿ.
There is a-
Subsequent purchasers.
No, Mallards.
Then who are they?
They are family members ಅಂತ ಹೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ ಈಗ.
ಕೊಡಿ. Yes.
ಮಲ್ಲೆ ಮತ್ತೆ.
Next date ಯಾವತ್ತು?
Next week ಅಲ್ಲಿ ಇದೆ, Mallards.
Date.
16th, Mallards.
ಇದು next week ಅಲ್ಲಿ ಹಾಕಿ. Date ಕೊಡ್ಬೇಡಿ. Yes.
Mallards, 16th ಇದೆ, Mallards.
It will come. 16th it will come, leave it. Yes. Call the cases.
Being spoken.
ಕಾಂಕ್ರೀಟ್ ಅರ್ಧದಲ್ಲಿ ನಿಂತೋಗಿದೆ. ಕಾಂಕ್ರೀಟ್ ಅರ್ಧದಲ್ಲಿ ನಿಂತೋಗಿದೆ ಮೇಡಮ್.
ಕಾಂಕ್ರೀಟ್
ಎಕ್ಸ್ಪರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡು ಕಾಂಕ್ರೀಟ್ ಅರ್ಧದಲ್ಲಿ
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದಿರಲ್ವಾ?
ಹಾಕಿದೀವಿ.
Wednesday ಬರುತ್ತೆ. No, not tomorrow.
May I repeat, my lord? First petitioner has died, my lord, and
ಯಾವ್ದ್ರಲ್ಲಿ?
no, they are given
Which matter?
59, my lords,
Wait.
and they are given a proposal for settlement.
We'll adjourn it when it is called. Yes.
Pardon, my lord?
When it is called, we'll adjourn it. Yes, next, call the case.
Being spoken to still number 1.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
Petition ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ನಿಲುವಿಗ ಎವಿಡೆನ್ಸ್ ಕೊಡಬೇಕು ಅಂತ ಆಗಿದೆ. ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್.
ನೀವೇ ಕನ್ಸೆಂಟ್ ಆರ್ಡರ್ ತಾನೇ ಇದು?
ಏನಾಗಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನು ತೊಂದರೆ ಇಲ್ಲ ಸರ್.
ಮತ್ತೆ
ಲಾಸ್ಟ್ ನಲ್ಲಿ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 12, my lord. Inspection and submission of the report shall conclude within 4 weeks from the date of receipt of this order ಅಂತ ಇದೆ.
Correct.
ಈಗ ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಈಗ ಎವಿಡೆನ್ಸ್ ಕಮೆನ್ಸ್ ಆಗ್ಬೇಕು. ಟ್ರಯಲ್ ಮುಗಿದ ಮೇಲೆ ಅಂತ ತಾವು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರಿ.
ಟ್ರಯಲ್ ಮುಗಿದ್ಮೇಲೆ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ? ವಾಟ್ ಟ್ರಯಲ್? ನೋ. ಎಸ್.
ಅಲ್ಲಿ ಈಗ ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆ ಸರ್. ಈಗ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮುಗಿದ ಮೇಲೆ ದಿಸ್ 4 weeks ಅನ್ನೋದನ್ನ ತಾವು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರೆ ದಟ್ ಶಲ್
it can go on parallelly, my lords.
Yes, ಇನ್ನೊಂದು ಆಡ್ ಮಾಡ್ತೀನಿ. The direction and the trial shall go hand in hand. Right?
ಎರಡು
ಏನಾಗಲ್ಲ.
ಕಮಿಷನರ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ್ಲೂ ನನ್ಗೇನ್ ಪ್ರೊಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದಿಲ್ಲ.
4 weeks ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ.
ಆಫ್ಟರ್ ಕನ್ಕ್ಲೂಷನ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ಆಗ್ಬಿಡಿ. That is the.
No, that will change the entire order itself.
Please.
That won't. That I will not.
That is one. The other grievance is, my lords, kindly come to page number 6. The dispute is last alle ಹೇಳ್ತೀರಿ, ತಾವೇ ಹೇಳ್ತೀರಿ. The dispute is with regard to whether there is a kaldari or not is to be noticed.
Correct.
That also, my lords, every one of us agreed.
ಮಲ್ ತಾವಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಇನ್ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ ಟೋಟೋ ಇಸ್ ಅಲೌಡ್ ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ದಿ ಅಪ್ಲಿಕೇಶನ್ ಮೆಲಾಡ್ಸ್. ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ the relief sought is local investigation and to ascertain the constructions put up on scheduled property. My lords may kindly clarify it. Revenue authorities ADLR ಹೋಗಿ ascertaining the constructions ಅಂದ್ರೆ
ಅಲ್ಲ, he will ascertain in terms of the application. Application ಏನ್ ಹಾಕಿದ್ರು?
Application ascertain the constructions to be put on scheduled property. That is in page number 91 paper book ಅಲ್ಲಿ.
Yes sir.
May I submit, my lords? My lords, the application was
We'll take it tomorrow. Wait, let's tomorrow in the same stage.
great.
Orders number 2.
Filing an memo for dispensation of notices to some of the respondents.
Some of the ಅಂದ್ರೆ how many of the?
So.
And who are they?
Respondent number 16, 19 to 23, 25.
ಅದು ಹೇಳಿದಿರಾ ಅಥವಾ ಮೆಮೋಲ್ ಬರೀ some of the ಅಂತ ಹೇಳಿದಿರಾ?
ಇಲ್ಲ ಬರ್ದಿದ್ದೀನಿ.
ಸರಿ. The counsel for the petitioner files a memo seeking dispensation of service notice, same Vijay.
Submission. We have filed an IA number 1 seeking for stay of further proceedings in the
Post next Thursday for admission. Next. FPF. 2 weeks time is granted to do the needful.
Memo is ready.
For what?
First case for dispensation of notice.
ಮಾಡಿ ಕೊಡಿ.
ಇಲ್ಲ ಕೊಡ್ತೀನಿ.
ಯಾರಿಗೆ?
First second respondent.
R2
R2.
Counsel of the petitioner files a memo seeking dispensation of issuance of notice to the second respondent in terms of the memo at the risk of the same. Yes.
One more submission, my lord. In all the 3 cases, delay may be condoned.
Delay. Learned counsel for.
Has to be allowed, my lord.
ಯಾವುದು?
Petition itself has to be allowed.
ಹೌದಾ? Why?
Because, my lord, there was an order in 2020 where they sought to withdraw the suit with liberty to file a fresh suit. They did not give the liberty, but they gave them a permission to amend the plaint. In pursuance of that, they have amended the plaint, which was rejected. They came to the High Court. High Court permitted the amendment. So, a lot of water has flown since 2020 to now. Now it appears that the presiding officer has said that in 2020 the suit was permitted to be withdrawn, and therefore you cannot proceed without that order being set aside.
Then we'll allow this.
Should be allowed.
All.
The only request, my lord, is that the suit itself is a harassment for me because I have been there.
So we'll direct the suit to be concluded within outer limit.
Suit any time frame.
16 suit and the 6 months outer limit.
1 year water.
And that I submitted.
Allowed. Yes.
All the 3 of them.
All 3.
Great.
That will be the order.
Please.
Delay condoned. Vijay, no objection to condone the delay ಅಂತ ಹೇಳಿದ್ದಾರೆ. Condone for the reasons once. Next. Yes, next.
4.
Two weeks time to do the needful. Yes, next. After service of notice upon. What is that?
That's inter-modus there.
Inter-modus
Served
notice once. Yes, next.
next one is
Emergency adral. Yes.
6.
the inter-modus lords.
2025 matter.
In the interim order, instead of same relief, earlier suit was filed for the same relief, but in the interim order, it's typed the same cause of action.
Final order correct mark. Yes. Next.
6.
For the respondent, my lords.
No representation behalf of the petitioner. Finally, a week's time is granted to comply with the office objections and do the needful. In the event the same is not complied or done by the next date, the petition would stand. The interim order subsisting would get automatically
My
vacated.
lordship, interim order was vacated on the last day.
Vacated. The petition itself would get dismissed. Yes. List on next Thursday. Next Thursday, 17th, 24th. Yes.
7.
2 weeks time to do the needful. Interim order continue ಮಾಡಿ.
8.
Lordship, I am for the petitioner. We filed the acknowledgement on Tuesday.
Learned counsel submits needful has been done. Office to verify. Next.
Interim order may be extended, Your Lordship.
Interim order subsists. Interim order will continue.
Obliged.
9.
9 first list, sir. ನೀವ್ ಯಾರಿಗೆ? ಆ ಲಿಸ್ಟ್ ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಬನ್ನಿ. ಯಾವುದು ಇದರದು? 9 is ಇದು ಮೇಡಮ್. 8 ಅಲ್ಲ. ಏನಾಗ್ಬೇಕು 8 ಅಲ್ಲಿ? ನಿಮ್ಗೇನು ಗೊತ್ತಿಲ್ವಾ? ಸರಿ ಬರುತ್ತೆ ಬಿಡಿ ತೊಂದ್ರೆ. ವಕಾಲತ್ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡಿ ವಕಾಲತ್ ಹಾಕ್ಸಿ. ಎಷ್ಟು ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ ಹೋಗಿ. ಎಸ್ ಹಾ ಎಲ್ಲಿ ಏಜಿ
Lord, he's on his way. Maybe passed over, my lord.
ಪಾಸ್ ಓವರ್.
ನಾಳೆ
ಪಾಸ್ ಓವರ್ ಕಷ್ಟ.
ಪಾಸ್ ಆಗೋದು ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ ಟುಮಾರೋ.
ಹಾ ಈಸ್ ಹಿಯರ್. ಎಸ್ ಸರ್.
In fact, if your lordship see the prayer in the petition, your lordship.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಾನು ಒಂದು ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಹಾ ಹೇಳಿ.
Please, please.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್, review is a problem.
ಅದಕ್ಕೆ ಅದ್ರ ಮೇಲೆ on that point itself, I will not, may I bring to lordship kind notice, not exactly on the similar issue where an order is passed, not based on the undertaking, not given by the state. If not, may I just not bring to lordship kind notice. The effect of not that undertaking being not correct, not whether review is maintainable, that fell for consideration of the Honorable Apex Court, not in this 2005 Part 4 SCC, not. 89, 90 and 93 may not make any decision. Paragraph 89, not at page 764. More particularly, para 90, 90. Not but for the undertaking may not being given by the state. Your lordship would have considered may not our prayer on merits. Apex Court says, in that case, review is maintainable. Not may I just may not now come to the prayer.
ಆಯ್ತು ನೋಡಿ ನಾಳೆ ತಗೊಂತೀನಿ. Look into this. Let him see.
I'm not on law is correct.
You're not on maintainability.
No, on
maintainability andra adukoskara
law is correct. The question is what is undertaking given, as I pointed out, undertaking is.
I'll help you. ನಾನು ಅದನ್ನು ತೋರಿಸ್ಬಿಡ್ತೀನಿ. But I'll be not fair to the court.
ಆಯ್ತು ನಾಳೆ.
They're not saying it's not fair, but my point of view is.
All of you are fair to the courts.
Please. Bless.
I've never come across any council being unfair till now. Yes.
Please. Interim order to continue.
That will continue.
Please.
ನಾಳೆ same stage.
Please.
10.
Rectification of office objections. A week's time is granted to do the needful.
11.
ಇದು ಏನಿದು?
ಅದು ಕನೆಕ್ಟೆಡ್
ಗೊತ್ತಾಯ್ತು. ಆನಂದರಾಮ್ ನೀವು ಇದ್ದೀರಾ ಈಗ?
ಹೌದು, ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ they have indicated last time.
ಅದೇ ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್
ಅವ್ರೇನ್ ಹೇಳಿದ್ರು?
ಏನಾಯ್ತು ಈಗ?
ಹಣ ಎಲ್ಲ ಇದೆಯಾ ಅಂತ ಕೇಳಿದ್ರು.
ಅದೇನಾಯ್ತು?
ಅವರು ಇಲ್ಲ ನಮ್ಗೆ ಹಣ ಇಲ್ಲ ಕಟ್ಟೋದಿಲ್ಲ ಅಂತ ಈ ತರ
ಕೊಡಿ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ ಎರಡರಲ್ಲಿ, ಇನ್ನೆರಡರಲ್ಲಿ ಹಾಕ್ಬೇಕು. You have to seek recalling of order because they said they will not construct. Court has taken a serious view there.
I filed the modification of the order, Lords.
Because they.
Reconstruction ಅಂತ ಇವರು ಕೊಟ್ಟಿದ್ದಿಲ್ಲ. I will permanently permit them to be there. ನೀವೇ reconstruct ಮಾಡಿ.
ಅಲ್ಲ ಇದೆ, ಚೆನ್ನಾಗೇ ಇದೆ ಸ್ವಾಮಿ. ನಾವು ಇವಾಗ ಹೇಳ್ತೀನಿ, ನಾವು ಅಲ್ಲಿ ಬಿದ್ದು ಸಾಯಕ್ ನಾವು ಬರೋದಲ್ಲ, ಚೆನ್ನಾಗೇ ಇದೆ ಪ್ರಾಪರ್ಟೀಸ್. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು ನೀವು ಯು ಆರ್ ಟೇಕಿಂಗ್ ಎ ಬ್ಯಾಕ್. ದಟ್ ಇಸ್ ವೈ ಸೀರಿಯಸ್ ವುಡ್ ಬಿ ಟೇಕನ್. ಎನಿಹೌ ಐ ಲೀವ್ ಇಟ್ ಟು ದಿ
bench for restoration of WP. ಇದಾ?
ಅದನ್ನ ಹಾಕಿದೀನಿ.
ಹಾಕಿದೀರಾ ಭಯ್ಯ?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ, ಅದು ಬಂದಿಲ್ಲ ಇನ್ನು.
This matter on Tuesday, the registry to put up the application so filed by the petitioner seeking recalling or seeking restoration of writ petition 1005 of 2022.
Court has taken a serious view there. You can't.
I will also take the same view.
You can't take the court for ride ಅಂತ ಹೇಳಿ.
I filed the
modification ಈಗಲೇ rejected just now.
ಅದನ್ನ
reject it now.
Construct ಅನ್ನೋದು delete ಮಾಡಬೇಕು ಅಂತ.
Impose construct ಅನ್ನು delete ಮಾಡಬೇಕು.
Delete ಮಾಡಬೇಕು.
If
exemplary costs.
No,
yes.
if we are constructed, Lord, we have not stated we are constructing the building, Lords. There is no fund is available for the construction.
ಹಾಗಾದ್ರೆ ಇವರೇ ಇರ್ತಾರೆ ಬಿಡಿ.
Yes.
ಕಂಟಿನ್ಯೂ ಆಗ್ತಾರೆ ಅವರೇ. ನೀವೇನ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಬೇಡಿ, ಅವ್ರಿರೋ ಕಡೆ ಅವ್ರು ವ್ಯಾಪಾರ ಮಾಡ್ತಾರೆ.
Condition, Lord, at any moment.
ಏನ್ ಮಾಡ್ತೀರಾ? You will raise it to the floor and keep the vacant land, is it?
Yes, my lords.
ಹೌದಾ?
We-
ವೈ
we
ಪ್ಲೇ
put
ಗ್ರೌಂಡ್
up-
ಮಾಡ್ತಾ
We
ಇದ್ದೀರಾ?
put up the compound wall and.
ದೇವಸ್ಥಾನದಲ್ಲಿ ಪ್ಲೇ ಗ್ರೌಂಡ್ ಬೇಕಾ?
No, building
ಮತ್ತೆ?
itself dilapidated condition.
ಅದೇ
my lord, it
dilapidated
may-
condition building na raise it to the ground and do what?
No, we will put the compound wall and we will
And what
just-
ಒಳಗಡೆ ಏನ್ ಪ್ಲೇ ಗ್ರೌಂಡ್ ಅಂತ ಕೇಳಿದ್ದು ಅದನ್ನೇ.
No,
ಮತ್ತೆ?
not like that, my lord,
Then
but
what?
building is dilapidated.
ಅಯ್ಯೋ ಸರಿ
condition.
ಅದಾಯ್ತು, you raise it to the ground, I'll give you permission. What do you do, tell me? ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ ಅಲ್ಲಿ?
ಅದು ಕಾಂಪೌಂಡ್ ಹಾಕಿ ಬಿಟ್ಬಿಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಹಾಕಿ ಬಿಟ್ಬಿಡ್ತೀರಾ?
ಫಂಡ್ ಇಸ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಲಾಟ್ಸ್.
ಅದಕ್ಕೆ ಇವರು ಪೂರ್ ಪೀಪಲ್ ವ್ಯಾಪಾರ ಮಾಡ್ಕೊಂತಾರೆ, ಬಿಡಿ ತೊಂದ್ರೆ. ದೇವಸ್ಥಾನ ತರ ಆಡ್ಬೇಕು, ಕ್ಯಾಂಟಂಕರಸ್ ಲಿಟಿಗಂಟ್ ತರ.
No, building stability certificate also produced, my lord. On that
ಬೇಕಾದ್ರೆ
basis
independent
only your
ತಾವು
lordship
ಒಂದ್ಸಲಿ-
pass the order, my lord, on that day. There is a building stability certificate. On the basis of photos also produced, my lord. On that basis only order has been
ಅದಕ್ಕೆ
passed. my
ರಿಪೇರ್
lord.
ಮಾಡಿ. ಇಲ್ಲ ರೀಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರಲ್ಲ ಅವತ್ತು, ಅದಿದ್ರೆ ಐ ವಿಲ್ ಪರ್ಮಿಟ್.
No, we are not given any undertaking, my
ಅದಕ್ಕೆ
lords,
ಡಿಸ್ಪೋಸ್
but
ಮಾಡಿದ್ ನಾನು. ಇನ್ ಕೇಸ್ ಯು till you reconstruct, they will have the right. Once you reconstruct, they will have the first right. That is what I have told.
if we are constructed, definitely we are ready to give, my lords, but there is no fund is available to reconstruct, my lord. For that reason.
ಯಾರು
we
ಏನ್
are-
ಯಾವ ದೇವಸ್ಥಾನ ಇದೆ?
ಕರಕಲ್ಲ ಆಂಜನೇಯ ಸ್ವಾಮಿ.
ಆಂಜನೇಯ ಸ್ವಾಮಿ ಟೆಂಪಲ್,
ಅದು
ಚಾಮರಾಜಪೇಟೆ.
ಯಾರು ನೋಟಿಫೈಡ್ ಟೆಂಪಲ್?
ನೋಟಿಫೈಡ್.
Who is the executive officer there?
Arvind Babu, my lord.
The executive officer of the temple, which temple adu?
ಕರಕಲ್ಲ ಆಂಜನೇಯ
So and so temple be present before the court at 2:30 PM on Tuesday.
Much.
We will have an independent assessment done.
Yes.
Yes, next.
Well,
My lord, these matters are connected.
Clifton, what is this?
My lord, sum and substance is this. Both the
Lord.
petitioners, my lord, were Bagarukum.
Some or substance, ಎರಡು ಈಗ ಬೇಡ. Preliminary hearing ಹಾಕ್ತೀನಿ. List the matter on Tuesday in preliminary hearing.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಮನು ಲಾರ್ಡ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್. ಲಾರ್ಡ್ ಈ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ರೆಡಿ ಲಾರ್ಡ್, ಮೈ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ನಾಟ್ ರೆಡಿ.
ಒಂದು ವಾರ ಬೇಕಾ?
ವಾರ ಬೇಕಾಗುತ್ತೆ.
Finally, 22 matter. Connected with 24 anyway. Learned Counsel H.L. Pradeep Kumar seeks 10 days time to file statement of objections. List the matter on 22nd. Objections, if any, by then. It is made clear no further time would be granted for filing of statement of objections. Next.
Interim orders, my lord.
Interim order subsystem.
Appearing on behalf of the respondent number
Yes,
4.
sir. What's your submission?
My lord, I have filed my, I've submitted my objections to both the petitioner as well as the state. I did not get an opportunity to file it in the counter. May I provide it in the open court?
Nodidara, madam?
No, my lord, I got it just now while waiting here.
My lord, I was able to.
Why I told you to serve it the previous day?
I was able to prepare it only by today morning, my lord.
We'll take it tomorrow?
Very
Nodidara?
well, my lords, tomorrow.
My request for Monday, my lord, not any other day. Monday, my lord. I'm only requesting
Monday, lot of matters. We'll take it on Tuesday then.
My lords, Tuesday and Wednesday, I have some difficulty. Next Thursday.
Thursday, all right.
Very well.
My lord, I have one submission, my lord. The entire land is acquired, my lord. They have not
But
produced.
then let him withdraw the memo.
Yes, I will withdraw them. Maybe rejected.
Aitala?
But
My lord, but I have my contentions. I've produced my statement of
I will
objections.
file a rejoinder.
One minute. The learned HCGP on AGA, na? HCGP on instructions would submit that the entire land is acquired and would seek to withdraw the memo that is placed before the court, which indicated that 29 guntas of land was left over after the acquisition. The submission is placed on record. List on Thursday.
One notification is not produced in the petition, my lord. So that has led. One notification of the
ಅದಕ್ಕೆ
date-
ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕೆಲ್ಲ. ಎಲ್ಲ ಹರಿಲ್ ಮಾಡಿದ್ರೆ then what she said is correct.
Yes, they have not produced that notification.
My lord, my contentions may be kept open, my lord.
Kept open for what, sir?
My lord, on the previous occasion, my lords mentioned that I will not.
All right.
I'm so grateful.
Now it is over. Indication was given that state is supporting you. State is also not supporting you because its entire land is acquired. Where did you get this 29 guntas from? And how did the court pass an order giving you mutation entries changing of a land that is already acquired?
My lord, that is the subject matter of my objections.
No, whatever his objection is
Please,
that the officer.
Compensation is not received, my lord. That is my precise.
All right.
Possession is not taken. Compensation is not provided. And my lord.
Anyway, Thursday, yes.
Please, my lord.
You
And it is the subject matter.
You cannot get relief in the petition filed by the others.
My lord, my only contention is that here, the subject matter of the acquisition land itself is before a coordinate bench of this honorable court. It is. 2002 writ petition is still pending before this honorable court.
Thursday, yes.
My lords, there are
I'm
only
grateful.
two
I'm
ways we
grateful.
can get a right under 24(2). If there's lapse or denotification, none of those apply here. Acquisition is affirmed right up
No,
to
no,
the
I
Supreme Court.
adjourned it only because of the memo that the state
Yes,
filed.
yes.
Now the state is withdrawing it, nothing. Yes. Thursday.
I will file it in the counter.
Thursday, sir. File
Please,
it.
please.
Serve it on madam and then file it, yes.
It is served, my lord.
Interim order may kindly.
Interim order will continue till the disposal of the petition. Yes.
Grateful, my lord.
14.
Proposed respondent. Like the senior has been met with a severe accident.
Huh?
So kindly, senior met with a severe accident, Swami.
Who's your senior?
SRP. S. Raj Prabhu.
SRP?
Raj Prabhu Associate.
Available.
The petition, my lord.
Non-compliance of office objections, IA3 zones.
Kindly place for 3 weeks time.
Needful be done by the next date. Interim order idea?
Interim order ಇದೆ.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. List the matter after 2 weeks. Needful be done by then. IO extended. Next.
Interim order may be.
15.
IO and that is extended.
My lord, I have served upon the counsel for the plaintiff before the trial court. I have filed the acknowledgement, however, it is not put up.
Where? Idhar error.
They have not entered appearance.
Counsel for the petitioner submits that he has served upon the counsel representing the respondent in the trial court. CRP na?
No, my lords, it's a date.
List on
My lords,
Wednesday.
tomorrow is the date before the
ಏನು?
trial court. The
What
only-
date?
Tomorrow, my lords. Before the
What? For what?
My lords, it is for cross-examination of PW1.
What is the order? What have you challenged?
My lords, I had filed an application to treat additional issues as preliminary issues. One on the issue of court fees, whether the court fee paid is sufficient or not. My lords, what has happened? They have sought for a declaration of title. However, my lords,
List the matter on Friday, the next. The concerned court shall defer its proceedings till the next date of hearing. Next.
same, my lords, next one.
Same.
17.
16.
Representing.
16 alla?
16.
Madam, is the first list.
My lord, 16, my lord, I undertake to file wakalat on the respondent, my lord. Respondent one.
Madam, name the 14 year back. Adjana.
My lord, I make a submission. Serial number 16, my lord. I
Learned
undertake
counsel
to-
so and so undertakes to enter appearance for the
Respondent number
2
one.
to 4.
Respondent number 1, my lord.
1.
Please.
Registry to print the name of so and so as appearing for respondent number 1.
In both the matters,
Same.
15 and 16.
My lord,
ಎರಡರಲ್ಲೂ ತಗೊಂತೀರಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿಲ್ಲ, ಕಾಪಿನೂ ಸರ್ವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲ,
ಕಾಪಿ ಸರ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಪ್ಲೀಸ್ ಟಿಲ್ ದೆನ್ ಇಂಟರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಟಿಲ್ ದೆನ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕಾ?
ಕನ್ಸಿಡರ್ ಮಾಡಿ
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಅದಕ್ಕೆ ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡಿಕೊಡಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಪ್ಲೀಸ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಸೇಯಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಿ ಅಂತ.
ಅಲ್ಲಲ್ಲ, ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ನನ್ನ ಒಪಿನಿಯನ್.
ಆಯ್ತು. ಫ್ರೈಡೆ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
17.
The caveat, matter pertains to impleading application, order passed on impleading application.
Non-compliance office objection.
In fact, there are 4 different types of litigations pending, my lords. One being an acquisition
no.
proceeding.
Accepting the submission of the council, office objections stands overruled. List on Monday in plenary.
Yep.
Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದೆ.
List number 2 orders. Sorry, being spoken to, still number 1.
ಏನ್ ಸರ್? ನೀವು ಯಾರ ಸಚಿನ್ ಮೂವ್ ಮಾಡೋದಿರ್ಬೇಕು. ಯಾಕೆ being spoken?
Petitioner has.
ಓ ಇದು ಇಂಟ್ರೆಸ್ಟ್ ಡ್ಯಾಮೇಜಸ್.
Damages, 1983 by law, 40 years, more than 40 years. Forgotten to mention the damages, even when it is in my prayer. 82, they have farmed the road
ಅಲ್ಲ.
without acquiring.
Along with all applicable interest and damages. ಅದನ್ನೇ ಹೇಳ್ತೀನಿ.
ಯಾಕಂದ್ರೆ
The learned counsel for this court on
acquire ಆಗಿದೆ ಅಂತ
one ನಿಮಿಷ.
damage
The
ಕೊಡಲ್ಲ, competition.
learned this court on 3rd July 2025 disposed the subject petition by the following order. The learned counsel for the disposal was on account of a memo filed by the respondents of acquisition of certain pockets of lands belonging to the petitioner. The acquisition for formation of road has admittedly taken place 4 decades ago. and compensation was not paid. Therefore, the petitioner is before this court seeking a direction for consideration of a representation towards payment of compensation. After the disposal, the petitioner has moved the matter, saying that, moved the matter on the score that applicable interest and damages as necessary in law is to be observed in the at paragraph 6 in the order. Therefore, the paragraph 6 would now read as follows. Lastly, same cause of action admale, the petitioner would become entitled to applicable interest and damages as is obtaining in law.
Orders, bill number 2.
My lords, petitioner has filed a memo for withdrawal.
My
You have
lords,
objections?
Matters.
we are for the petitioners.
All right, you have objections?
No, man. I'll submit.
In terms of the memo. Yes.
Much.
What have you said in the memo?
The parties are ready for out of the court settlement.
Yes, in terms of the memo.
Number 3.
Unserved covers postal shara.
My lord, petitioner, my lord.
Huh?
Petitioner, my lord.
Oh,
Notice, my lord, refused also.
refused.
Also.
Registry to print the names of R2, 4, 6 and 7 and show them as served in the light of the fact that they have refused notice from the hands of this court. Interim order, yeah?
Interim order, yes.
List after 4 weeks, interim order subsisting would continue to the next date of hearing. Next.
Number 4.
Oh, 21, the madam. List on 5th August anta madiri. Sorry, 6th August. 3rd. Seal number 3, list on 6th August. Yes, next.
Number 4.
Non-compliance of office objection. Learned counsel for the respondents, comma, all in unison seek time to file statement of objections. List the matter after 3 weeks in objections, if any, by the respondents by then. Interim order subsisting would continue to the next date of hearing.
5.
For respondent in this case,
My lord, some
application for vacating
respondents have
interim
not
order.
been served, my lords. I just come on wakalat, I'll take out hand notice on, I'll serve the trial court lawyers, my lords.
My lordships, in this case, my lordships, first appellate court granted interim order, this honorable court granted interim order. Further proceedings in first appellate court is stayed, my lordships. And they are alienating the
In
properties.
39, 39, 1 and 2.
39, 1 and 2 has been rejected by the first appellate court, my lords. They have not challenged that particular order, my lords. The trial court, my lords, on 15th of April 2025 rejected the trial order, my lords. They have sought for injunction during the pendency of first appellate order. However, my lord, that has been rejected, my lords. I've just come on wakalat, my lords. I'll look at the papers and come back, my lords.
List the matter on Friday the next at the request of the counsel appearing for the petitioner. Then is awaiting service.
Yes, my lord. May I serve, my lords?
In this case, my lordships, I have filed application under 39 rule 1 and 2. That application was rejected on the ground of maintainability by the first appellate court in view of the interim order granted by this honorable court. My lordships, they have not obtained any stay in the first appellate court, my lordships. Decree is in my favor, my lordships. They are alienating the properties, my lordships. And
They are alienating.
They are alienating the properties.
How do you know?
I have filed application, my lordships. They have converted the property and farmed the layout and obtained the.
ಯಾವಾಗ ಆಗಿದ್ದೆಲ್ಲ?
ಇದೆಲ್ಲ recently.
2021, my lords, first
ಯಾವಾಗ
application.
ಆಗಿದ್ದೆಲ್ಲ?
29/11/2024, my lordships, they have obtained approval from the Kuda, my lordships, KJF Development
I'll
Authority.
just cross check, my lords, because that is not
Look
pertaining
into
to
it.
this.
List the matter on Friday
Please, my
the
lordships,
next.
interim order, my lordships, may be modified, my lordships.
No, my lords.
Further,
Today I do not.
final hearing of the first appellate
Without,
court.
without hearing ಏನಆಗಲ್ಲ. Next we'll see. Yes, list on Friday. Deceased R14 ಯಾರು? ಅದ್ಯಾದ್ ಬೇಡ ಅಂದ್ರೆ ಮೆಮೋ ಹಾಕಿ.
I'll file it, lords. I'll take it.
This is not the way. Yes. List the matter finally on Friday. In the event steps are not taken, the interim order subsisting would get automatically vacated.
May I serve the trial court
Steps are
lawyers?
not taken or needful be done, the interim order would get automatically vacated. Yes.
May I serve the trial court advocates, my lords?
The petitioner is at liberty to serve on the counsel who represents the unserved respondents before the concerned court. Yes,
Yes,
next.
May be posted in the preliminary hearing, my lordships. May be posted in the preliminary.
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
Your lordship, I apologize, lordship. Serial number 4, lordship. Interim order may be
That
extended.
will continue, sir. Please, yes.
Interim order, much
Continue. 6 withdrawal in terms of memo.
7.
Non-compliance of authorized. A week's time is granted to comply with the office objections qua this statement of objections. Next.
8.
That's appearing for petitioner, my lords, the covered by my lords, same OS and FDP has been stayed and matter was remit. Here, my lords, invoice.
One ನಿಮಿಷ respondent ಇಲ್ದೆ ಅವೆಲ್ಲ ಆಗಲ್ಲ.
First respondent.
Covered
Covered ಇಲ್ಲ ಇದರಲ್ಲಿ.
Lords,
ಅದರಲ್ಲಿ ಏನು
ಇದ್ರಲ್ಲೂ same
she is a pendant litter purchaser. Final decree has been drawn. She is a pendant litter purchaser of a party who is participating in FDP proceedings.
Not participating.
His vendor was participating. During the pendency of the FDP proceeding, he purchased the property.
So what is the application now?
Now, finally, they have filed an application.
41 rule 5 application.
ಆರ್ಯ ಹಾಕಿದ್ದಾರೆ. ಆರ್ಯದಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ they have come before this court.
will ಕೊಟ್ಬಿಡೋಣ ಇಲ್ಲಿ. ಕೊಟ್ಟಿದೀವಿ ಅಷ್ಟೇ ಇಲ್ಲಿ.
ಇಲ್ಲ ಅಲ್ಲೇ emergent. They are parties to be ಅಲ್ಲಿ
same order I will pass if you want. Otherwise I will grant stay now.
FDP is
same FDP same OS, my lord.
Drawn FDP.
ತೊಂದರೆ ಇಲ್ಲ. ಇದು order 41 rule 5, the interpretation of the coordinate bench. If you say it is not there, I will grant stay.
ಅಲ್ಲ ಇದಲ್ಲ. It has been already direction to dispose of the appeal also. Same in the layer.
ಅದನ್ನ ಆವಾಗಲೇ ಹೇಳಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು. Yes, same order, same parties.
Same parties, different parties, but same OS and different appeal.
Same OS.
Say OS and FTP is same, but appeal is
So the
different.
appellant in that petition, he is a purchase of pendant litter from that party.
Same copy paste. Next.
For early disposal also, my lords.
ಅದರಲ್ಲಿ ಏನಿದೆ?
ಇದೆ. Much obliged.
ಇಲ್ಲಿ earliest disposal ಅಂತಾನೆ.
ಇಲ್ಲ
early ಇದೆ.
ಅದರಲ್ಲಿ ಏನಿದೆ ಅದು ಸರ್?
Yes, next. Post immediately after service of notice upon respondent 1 to 7. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. ಇದರ ಅದನ್ನೇ continue ಮಾಡಿ. Yes. Non-compliance.
My lord, the only compliance is with due to oversight, the date has been mentioned wrongly, my lord.
Compliant, yes.
My lord,
in the event office
arrest warrant has been issued, my lord.
ಮತ್ತೆ comply ಮಾಡ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ, my lord, objections file ಮಾಡಿದಿರಿ, saying that we don't have
arrest
means to
warrant.
satisfy. My lord,
Why arrest warrant?
because without conducting enquiry, they've issued arrest warrant, my lord. As per order 21 rule 40.
Arbitration.
Yes, my lord. It's an execution petition, my lord.
ಎಷ್ಟಿದೆ?
17 lakhs. They've seized my lorry and they've sold it also, my lord.
ಶ್ರೀರಾಮ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್.
Yes, my lord.
ಅಲ್ಲಿ ಲೋನ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು, my lord. They've seized the lorry. He was a lorry driver. The only source of livelihood was his lorry, my lord. That has been seized and sold, my lord.
List. ಈಗಲೇ comply ಮಾಡಿ. Learned counsel of the petitioner submits that he would comply the office objections in the course of the day.
Yes.
The learned counsel submits that the petitioner ಒಂದು ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
Yes, my lord.
ಮತ್ತೇನು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್?
My lord, the next date is 17/7, my lord.
17/7. ಓಯ್ ಇಲ್ಲಿವರೆಗೆ ಒಂದು ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lord, it was listed.
ಲಾರಿ ಸಿಗ್ಲಿಲ್ವಾ? ಮತ್ತೆ comply with the office objections list on next Friday.
My lord, I'll do it, my lord.
Do
17/7
Monday. 16th in preliminary hearing. ಈಗಲೇ ಮಾಡಿ.
Much obliged.
7, withdrawn.
In terms of
12.
week's time to comply with the office objections.
13.
Wakalat respondent 30, 31 and 33, please. Today morning I filed wakalat.
Respondent ಈಗ ಈ ಕಡೆ ಬನ್ನಿ.
Respondent 5.
Learned counsel so and so submits that he has entered appearance for the unserved respondent 30, 31 and 33. Therefore, the service of notice as on date stands complete.
But there is one more connected writ petition, not that.
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಇಲ್ಲ.
ಸರಿ ಬಿಡಿ. Yes.
For respondent 5, a copy may be direct to be served on. I have not received a
copy. The learned counsel for the petitioner to serve set of papers upon the counsels, upon the respondent's counsels, if not already served.
Lord, in the final decree proceedings, 2 applications have been filed. This is in one respect of one application.
ಈಗ merits ಮೇಲೆ ಬರಬೇಡಿ. Yes, list the matter.
Connected matter. It may be connected, Lord, because the service of notice may require.
So Lordship, this matter arises out of IA number 1.
ಕೊಡಿ. Tag this petition along with
19/4.
Tag this petition along with the.
ಅಲ್ಲ, if I may make one submission, my lord. ಅದರಲ್ಲಿ there is the matter has not even come up once. That may have to be argued. ಅದಕ್ಕೋಸ್ಕರ ಯಾಕಂದ್ರೆ
ಸೊ ಆರ್ಗ್ಯೂ ಮಾಡಿ, ಸೊ ವಾಟ್?
ಅಲ್ಲ, ಸೊ ಅದಿನ್ನೂ ಒಂದ್ಸತಿನೂ ಬಂದಿಲ್ಲ, ಇದ್ರ ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಇಲ್ಲ, ಇದು ಈ ಪಿಟಿಷನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್, ಅದು ಇನ್ನೂ ಒಂದ್ಸತಿನೂ ಬಂದಿಲ್ಲ. ಅದರಲ್ಲಿ some submissions may have to be made. ಅದಕ್ಕೋಸ್ಕರ
ಬರ್ಲಿ.
there were two different IAS. One,
don't worry, ಇದು ಯಾರು respondent? You are for the petitioner in this also?
Yes.
No, I have not filed it. There was another advocate who has filed it. ಅದು ಇನ್ನೂ ಬಂದಿಲ್ಲ fresh matter.
This matter, objections ಎಷ್ಟು ದಿನ ಬೇಕು?
1950 matter.
Counsel, so the respondents would seek 2 weeks time to file statement of objections. In the event objections are filed, list this matter on 25th.
If I may make one submission, my lord, there will impleading application.
Not a subsisting.
There is one impleading application that is filed in this that has not been put up.
Registry to put up all the pending applications on the next date. Yes, next.
Please.
2 weeks time granted to do the needful.
Lordship.
ಏನಿದು 8, 9, 10, 12
I'll furnish PF and take out notice.
intermodal ಇದೆಯಾ?
Intermodal.
2 weeks time is pass over.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ, ಇಲ್ಲಿ ಬಂದು ಎಂಟ್ರಿ ಮಾಡರ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
Vacating entry model.
ಪ್ಲೀಸ್ ಮೇಲೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್.
Lord, may I submit one submission? Only after filing the case did we get to know that the court does not have pecuniary jurisdiction.
Then I tell
Yes, yes, I agree. But there were 65 acres of land which is due to be sold, and sale agreements are produced before your lordship at page number 115 to 253.
Seek appropriate prayers before the appropriate court.
Your lordship, the senior division in that particular place takes about 10 days to scrutinize the file and put it up. Between that time, they would have sold the property. I only request protection be given to me, so I have liberty to approach the jurisdictional court.
Pass over.
Kindly pass.
Yes, next.
This case, I represent the petitioner, madam.
Weeks time is granted to do the needful.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್.
Furnishing PF.
ಅಲ್ಲ, ಅದ್ರಾಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ರಾಂಗ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ನ ಇದ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು, ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ.
ಅದರಲ್ಲಿ yes, correct. The stamp duty use ಅಲ್ವಾ?
Yes, yes, ma'am.
List on Monday in preliminary hearing.
Till that
the
period,
indication intermodal they already
please.
Till the indication of non-furnishing of PFs shall be deleted as the contesting respondent is the government. Yes. Copy.
I'll furnish me.
ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ಅವ್ರು ಹುಡ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ, ಅವ್ರು ಸಿಗ್ಲಿಲ್ಲ, ಇವತ್ತು ಕೊಡ್ತೀನಿ.
ಗವರ್ಮೆಂಟ್ ಹುಡ್ಕೊಂಡು ಹೋದ್ರ?
ಹೋಗಿದ್ದು ಅವ್ರು ಸಿಗ್ಲಿಲ್ಲ ಅವತ್ತು, ಅವ್ರ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
ಚೆನ್ನಾಗಿದೆ. ಎಸ್.
Today I'll furnish. Much of.
Non-filing of acknowledgements. Post immediately after service of notice upon the respondent. Entry order subsisting will continue. Next.
For the petitioner, my lord, there is some correction in the judgment, my lord.
Correction.
Interim order, my lord. Your lordship has stayed the, my lord, OS proceeding, my lord. I'm seeking for only stay of the MA order, my lord. So next year, G, my lord.
Learned counsel for the petitioner submits that the interim order reflects that the entire proceedings are stayed and what was sought for is only
Next year, G, my lord. In MA number.
What was sought for is only an order passed by the first appellate court. In MA
4 of 23.
In MA 4 of 2023. In that light, the interim order shall be restricted to the stay of proceedings before the first appellate court. Post immediately after service of notice upon respondent 192. Next.
Much of.
Acknowledgement Ellie.
Acknowledgement already produced, madam.
Yes, next. 2 weeks time to do the needful. Interim order subsisting will continue to the next date of hearing.
19.
Happy for the petition.
Post immediately after service of notice upon respondents 2 to 8.
My lords, 2 to 8 are the defendants in the trial, my lords.
So
service
what?
of notice may not be pressed on them.
Memo okay.
Please, my lords. I shall.
Yes, file a memo.
Please, my lords.
Eagle.
Right.
2 to 8 dispensation. Yes, next.
20.
Furnishing of PF.
PF
R2 to R4 ಯಾರು?
appear ಆಗಿದ್ದಾರೆ ಅವರು.
ಎಲ್ಲಿದ್ದಾರೆ?
I appear
R2 and R4.
3. I appear for respondent number 1.
1, 2, 4.
3. I appear for 3 minutes. 1 and 3 is appearing before the court.
1 and 3. Who is 4?
4 ಗೆ
We have served the
Yes,
the letter.
objections? Objections you want to file?
Objections, I'll file my lords on this.
Yes, list on 25th, objections, if any. By then interim order subsisting will continue to the next date. Next,
Anyone?
same order. Same under 18 lane I thought.
22?
Post immediately after service of notice upon respondents 1 to 3.
Interim order.
Enter.
23?
Filing acknowledgement served trial court.
File it in the registry. Yes, yes. You are representing
Respondent
whom?
number 1 month.
ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? 2
R1.
R1 is here.
R2 notice may be ordered.
ಅದಕ್ಕೆ PF ಕಟ್ಟಬೇಕು ಅಂತೆ. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಆಗಿದೆಯಲ್ಲ.
ಇಲ್ಲ.
Emergent notice to the second respondent. Yes, next.
Please. Interim order may be extended.
Interim order subsisting would continue to the next date of hearing.
24?
Yesterday, I have paid deficit court fee, my lord. The objections I will complete in 2 days, my lord.
Learned counsel submits needful has been done, office to verify. In the event it is done, list the matter on Monday.
My lord, interim order.
Interim order
Lord,
ಇದೆ. List.
I have filed wakalat for
Learned counsel
R7.
so and so submits that he has entered appearance for
R7.
R7 registry to print the name of so and so is appearing for the 7th respondent, 25th.
I pray
Next.
for 2 weeks time to file objections, my lord. It is
25th.
a regular appeal. Aye.
Interim order,
Objections if-
interim order.
that is- Objections if any by the next date. Yes, next.
Oblige.
25?
The petitioner, the tag matter has finally come on board.
Oh, it has come.
Yes,
Yes. Yes, Anusha.
I need some time, my lord. A short accommodation, my lord.
ಆದ ತಕ್ಷಣ ಏನಾಯ್ತು problem?
Alla, senior counsel.
Alla,
some
on the last day,
inconvenience-
the learned senior pointed out that 13 days of stay was in operation.
Now another 3 days.
In fact, I should be obliged to my learned senior friend for pointing out to this court that the period of stay is obstructing the prosecution of the suit. Lord, if that same sense of urgency and time consciousness was shown in the conduct of the suit,
Today,
the
my
suit
lord.
would not have gone on for 2 decades. I am serious in
One
prosecuting the
complaint
suit.
list ಆಗಿದೆ, ಅವ್ರು ಇನ್ನ compliance ಮಾಡಿಲ್ಲ.
Compliance
Let
is
them
already
comply,
complied with,
my
Lord.
lord.
Your Lordship, our urgency towards it last day because of the stay. I am ready to argue it. 3 dates have come ahead.
ಯಾವತ್ತು ಬೇಕು?
My lord, 15th.
They are not serious in prosecuting their own suit. I am serious, not. I want to go and prove my case there.
Yes, 15th finally, 16th finally.
Lordship, I have this in the preliminary hearing board.
ಇದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಬಂದಿದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ, we have-
Learned counsel for the petitioner submits office objections have been complied with, office to verify. In verify, list the in the event they have stood complied, list the matter on 16th in preliminary hearing.
So great.
16 Saka, madam.
26?
I appear for the petitioner in this matter, my lords. I seek for a short passover, my lords.
Short passover, no?
My lords, senior counsel is held up in another court.
What's the matter?
Rejection of plaint application not has been rejected.
Oh, rejection of
Commercial-
plaint.
Commercial court not.
Commercial court.
Commercial court.
Rejection of plaint
On the ground
application
not-
is rejected.
Mainly limitation. The court will not have said it's a misquotation of law and fact. Pertaining to not dissolution of partnership firm and distribution of assets.
Then Chinnapad.
Please.
Where is he?
He's held up in another court, my lord.
Should I pass it over?
But it's there, not in the trial court only today. Not only for hearing on IEM, not. It's already adjourned to 16th, therefore Lordship may have it.
Then we'll,
Because today is a very heavy.
we'll take it on 16th.
Very, not
Yes.
16th, there is some difficulty, but 15th, Lordship may have.
15th is not CPC. Then second list will baratte. List on 15th. Yes.
But some difficulty on 15th minute from my instructing counsel, 17th minute. It's only one for argument on IA, therefore not.
18th is
18th.
Friday. Yes.
Great.
List on 18th.
Huh?
Copies. Yaar, who are you?
To R6, my lord.
I'll serve a copy.
Why not served?
My lords, they've entered appearance last date. They were not on cable.
Learned counsel for the petitioner to serve set of papers upon counsel representing R3 to R6. List on 18th. Yes, next.
27? My lords, I appear for the petitioner. My lords. My lords,
It's R2 and R3 may kindly be dispensed with, my lords.
Memo.
Of having, my lords, I have filed it, my lords.
Dispensation memo could be made.
My lords, I'll file it, my lords.
File it, yes.
Please, my lords.
We are for R1, you are granted 10 days time for filing.
Learned counsel
objections.
seeks 10 days time to file statement of objections. Counsel for the respondent seeks 10 days time to file statement of objections. Counsel for the petitioner files a memo. Yarige?
My lords, 2 and 3, my lords.
Dispensation of notice to R2 and R3, same. Dispense with the risk of the petition. Yes, next. Yes,
Interim order may kindly be extended, my lords.
yes, next.
Great. 28.
Developed land in lieu of the consent.
General award, my lord, questioning of general award.
Non-compliance.
Only objection is, my lord, copy has not served. Bardilla anta.
Counsel for
I
the
served
petitioner
already.
submits that the office objections are complied with service of the copies upon the counsel representing the KIDB. ನಿಮ್ಮ ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ?
ಅಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಮಾಡ್ರಿ.
ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದ? ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ.
General award matter, my lord.
ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಡಿ. ಅಲ್ಲಿ ಹರ್ಡ್ ಸೋನ್ಸ್ ಒಂದು ಮಾಡಿ. HL Pradeep Kumar is permitted to file his wakalat with in the next 4 weeks ಅಂತ ಮಾಡಿ same order.
Grateful, my lord.
29.
Because I've taken steps today. This is that Quatley kitchen matter.
But may I make one submission, my lord? Your lordship had granted an interim order insofar as petition is concerned. But insofar as whatever episodes, my lord, they have already shot, not with the first defendant before, my lord, the interim order was granted against first defendant. But insofar as airing that, my lord, there cannot be an issue. But insofar as, my lord, continuing to shoot, that my lord,
we'll have to answer that.
that my lord, your lordship, because they cannot aid and abet, my lord.
Matter may be finally decided next week. Whatever.
But in the meanwhile, they should not continue to
No.
aid and abet, my lord, in terms of violation of the
interim order ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Alla, insofar as
modification I have to hear and do it.
Yes, my lords.
I'll pass it over if you want, not a problem.
Maybe had next week, my lords. Even in this matter, I'm being led by
at least, my lord, insofar as episodes that I have no difficulty, my lord, with the episodes which are already, my lord, they have shot,
Raghavan,
not naturally.
I'll take it on 18th. The other matter also you're here. We'll take this on 18th and no adjournment will grant. We'll decide it on that. List the matter on 18th finally.
Grateful.
May I make one request, my lord? Your lordship had said it is obvious that it continues insofar as D1. If your lordship could at least clarify that, my lord, so that they should not take advantage of that.
Without hearing then.
Alla, insofar as D1,
they need to
first defendant is
appear.
That's correct.
that your lordship may just
Appear, my
say so, my lord, that-
ಹೇಳಿದ್ದೀನಲ್ಲ already.
Alla, your lordship had only said insofar as
Petitioners
I had not made a request. Your lordship may say so explicitly, my lord, because your lordship knows how they will play around, my lord, with the wordings, my lord.
Interim order granted earlier. It is obvious that the interim order subsisting shall continue to the next date of hearing. It is obvious that the interim order is qua the first defendant.
And shall not affect the continuation of the order insofar as D1 is concerned. That's the.
Yeah, which D1?
The first defendant, my lord, who is not before your lordship.
Correct.
They are not party.
It's very clear from the order. My lords,
So
only applies
I
to
clearly
the
said in
petitioner.
I don't need any further clarification. Better.
Not needed, my lords.
Interim order as granted earlier stands extended till the next date of hearing.
It's already been granted after hearing. It's not
Correct.
until the next date of
Aಷ್ಟೇ,
hearing.
nothing else.
Yes.
Because we had said we had objections.
18th. Objections
Hey,
ಹಾಕಿದ್ದೀರಾ?
my lord,
Let them file their objections as well.
Not
my
filed.
lords.
not yet, not
They've
yet.
not
Filed,
filed.
sir. I thought you have filed.
May-
your
may-
object-
Not filed, my lords.
This is a matter, my lord, on an ex parte order, my lord, when one of the parties has come, perhaps.
They don't want
your
to
lordship
file,
would
let
dispose
them
of.
not.
Send it back.
May I request on Monday, my lord, if your lordship could kindly.
Monday ಕಷ್ಟ ಜಾಸ್ತಿ ಇರುತ್ತೆ. Wednesday I'll take or Friday.
Wednesday, I have some personal.
Maybe on 18th.
Thursday, my lord, may.
18th.
Thursday again.
Very
CRPD
good.
Gets
Very well.
Grateful.
ತಗೊಂಡ್ರು I'll take it in second list. It may reach. or may
Very
not
well.
reach.
Your lordship may have it on 18th itself.
18th.
Grateful.
This one preliminary hearing. Number 18.
Appear for the KDB acquisition.
Yes, sir.
2006 notification. No award till date, no proceedings have taken.
They covered ಅಂದ್ರಲ್ಲ.
But
Covered ಅಂತ ಹೇಳಿದ್ರಿ.
covered according to the, I have given the.
Yes, sir.
citation.
Let's para 19 of their awardment, they only say that award is passed. I have a copy of the award here. It is passed in 2009. Para 19, page number 14 of the writ petition. The final notification at annexure C was issued as early as 13/1/8/2006. And as award is passed on 6/3/2009, which is not passed within reasonable time. The honorable court in the case reported so and so as
The
held as
award
follows.
is passed.
Award is
Let's, I have a
passed, but
copy
no
of the award
possession
here.
is taken. ಅಲ್ಲ, copy ಇದ್ರೆ ಒಂದು ಕೊಡು.
Copy ಇದೆ. But I have one request, my lords. I want to ascertain whether the 12-2 notice has been issued and the amount is deposited.
Participation ಆಗಿದೆ ನೋಡಿ.
Huh,
Yes.
that one. That one issue I'll ascertain. My lords may give me a short.
Heard the learned senior counsel Shri Ashok Harnally appearing for the petitioner. The petition is premised on the score that, the submissions are premised on the score that the award was not passed. The learned counsel for the respondent takes the score to paragraph 19 of the petition to demonstrate that the averment in the petition itself is that the award has been passed. The learned counsel for the respondent would now seek time to ascertain whether proceedings under 12(2) has taken place and the petitioners have participated in the inquiry. The learned, therefore, the information be sought by the next date, list the matter on 22nd in preliminary hearing.
Their award is not passed for 17 years.
Yes. That's independent move ಮಾಡಿ. Yes, next. ಆಯ್ತು ಮೂವ್ ಮಾಡಿ ಅವ್ರದ್ರಲ್ಲಿ ಮೆತ್ತಗದೆ.
Oblige.
19. My lordship is vide cancellation of allotment. This I verify order passed by this honorable court. This only for submission is without notice.
That will continue. Interim order will not.
I verify.
Yes, sir.
Order passed by this honorable court.
Correct, sir.
Only my submission without notice serve the petitioner. This conduct kindly annexure is my lordship.
Nothing. Supreme Court has said it goes.
The petitioner was not aware of the cancellation of due extinction of the service.
No, sir.
That is, the no opportunity the cancellation of hearing, my lordship. That's considered only for service reason. Cancellation of site was without proper notice service.
No, sir.
This kindly.
All that ground, all those submissions have negatived here.
Without notice to be cancelled.
Ex-serviceman new ex-serviceman na. Yes. Anything else?
Without notice, my lordship. That's ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಲೆಕ್ಚರ್
ನೋಟಿಸ್ ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಸಿ ಅನೆಕ್ಷರ್ ಈ ಮೈ ಲರ್ಶಿಪ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂತಾರೆ.
ಅದು ನಿಮ್ಗೆ ನೋಟಿಸ್ ಬರೋದೇ ಇಲ್ಲ ಅದು. ಈಗ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ ನೋಟಿಸ್ ಬಂದಿದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಪ್ರಾಪರ್ ಆಫ್ ಇದು ತಾವು
ಯಾವಾಗ ಸರ್ ಕೊಟ್ಟಿದ್ದು ನಿಮ್ಗೆ? ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ?
85.
Anything else, sir?
87 timely representation given to the
3 years time was granted.
representation ಕೊಡ್ತಲೇ ಬಂದಿದೀವಿ ಆದ್ರೂ
ಎಲ್ಲಿದೆ ಸರ್
representation ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್ 2000 so many representation
ಎಲ್ಲಿದೆ ಸರ್
89 annexure page 12 1213 annexure C
ಆಮೇಲೆ
annexure C1 C2 C3
ರದ್ದತಿ ಆದೇಶ 95 ಲೇ ಆಗಿದೆ
C5 and C7 ಕಂಟಿನ್ಯೂಸ್
ಈಗ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ ಇವೆಲ್ಲ.
ಯಾಕೆಂದ್ರೆ ನೋ ಥರ್ಡ್ ಪಾರ್ಟಿ ರೈಟ್ಸ್ ಅಲ್ಲ, ಯಾವ್ದು ಖಾಲಿ ಇದೆ ವೇಕೆನ್ಸಿ ಇದೆ. ವೇಕೆಂಟ್ ಸೈಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ has said so, sir.
ಅಲ್ಲ ವಿತೌಟ್ ನೋಟಿಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
No. Anything else? The petitioner is before this court seeking the following prayer. The petitioner
ready to pay full payment my lordship.
10 times ಆದ್ರೂನು ಇಲ್ಲ. The petitioner heard so and so. The petitioner is said to be, petitioner submits an application seeking allotment of a site in HBR first stage, second block. Accordingly, the petitioner's application is answered and an allotment is made on 6/11/1987. Thereafter, the petitioner is said to have represented once or twice for issuance of a possession certificate. The BDA has issued certain notices with regard to non-payment of the entire amount that was to be paid in terms of the letter of allotment. The payment does not come about, then comes the cancellation in the year 1995. The petition is preferred on 15th November 2016, calling in question a cancellation that has happened on 17/9/1995 on the score that the order of cancellation has never reached the doors of the petitioner. The learned counsel would take this court through a plethora of representations submitted from 1996 to 2011 and would further contend that if notice had been issued, if the order of cancellation had reached the doors of the petitioner, he would not have submitted the representations even. The learned counsel for the respondent, housing board or BDA would submit the notices or the order of cancellation has been served upon the respondent, and even the notices calling upon the petitioner
It's not
to-
served, my lordship.
to make the payment. The learned be those submissions as they are. In identical circumstances, projecting identical plea, this court, following the judgment of the apex court, has held as follows. Para 3 in the end of that. The apex court observes that the persons who have been allotted sites and defaulted in payment have now sprung back by filing writ petitions before the High Court, and the High Court, showing misplaced sympathy, has directed collection of penalty and allotment to be finalized, has only given rise, has only come about in the light of the value of the property going tenfold high. The apex court further directs that whoever has deposited the amount shall be refunded by the BDA with interest at 7% per annum from the date of deposit till the actual payment thereof. In the light of the issue standing answered by the apex court, which is followed by this court as quoted supra, the petition does not deserve indulgence for the prayer that is sought, but however, in terms of the order of the apex court, the petitioner shall be refunded with the amount that he has deposited at the time of allotment, along with 7% interest from the date of deposit till the date of its repayment, ordered accordingly. Yes, next.
20.
The compromise is entered behind my back and I'm supposed to have given up 83 lakhs. It is awarded to me.
Covered either.
Yes, covered.
It is not covered, my lord. I have to
Well,
file
idea
my
what is
objection.
this?
It is covered, my lord, by, yes, ma'am.
ಮತ್ತಿಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ ನಾನು ಬೇರೆ ಅನ್ಕೊಂಡೆ ತಪ್ಪಾಯ್ತು.
ಹಾ.
It is covered, my lord. The
ಎರಡು judgment ಇದೆ.
My lord, I will see the judge. However, my lord, I will file my objections.
Copy.
Learned counsel for the petitioner to serve. Counsel for the petitioner submits that the issue in the list stands answered by two judgments rendered by two different coordinate benches. In that light, the learned counsel for the respondent seeks time to go through the judgments and make his submissions, or file a statement of objections as the case would depend. ನೀವು ಅವ್ರು ಹಾಕೋದ್ ಬೇಡವಾ? 25th, yes.
Please. Only slightly ahead because gentleman's terminally ill. My lord, may I submit, my lord? Gentleman terminally ill.
They filed MFA, my lord, challenging. The
Yes.
MFA.
Objections ಹಾಕಿ sir.
Please,
25th, yes.
please.
My lord, I request for a passover, my lords.
No opportunity. I will send it back to be heard.
No, Millets, there is no Millets. They have not moved the division
I
bench.
hear ಮಾಡಿಬಿಟ್ಟು ಮಾಡಿದ್ರೆ
Millets 96 crores is what is payable to me.
ಇಲ್ಲ revision move ಮಾಡಿಲ್ವಾ?
Illa Swami. It came up before the Leonard register Millets. Thereafter, it was not complied. Now it has not come up before the division bench. Millets, I have an award for the past Millets 11 years. They have
11
not.
years.
Millets, Millets. The dispute started in 2014. Award was in 2019. Millets, 6 years is the date, the period of the award.
If
There
no
was
order,
pending
division
void
bench has
appeal
not passed any order,
Millets, no orders has
then
been
this
passed.
would,
There is-
interim order would vacate, sir.
No, Your Honor, kindly pass over.
This court on 30/6/2025
award.
had passed the following
One, sir.
order. The learned counsel for the respondent submits that no order is passed by the division bench as no effort is made by the petitioners to move the division bench. In that, the indication was that the interim order would stand vacated in the event appropriate orders would be passed. In the event the division bench would not pass orders, the petition would not merit any consideration in the list tomorrow in preliminary hearing.
Yes, the matter before the trial court is also tomorrow. But
So,
tomorrow. Millets.
yes, next.
Great.
22.
Counsel for the petitioner, my lords.
So what's wrong with the additional issues, sir?
My lords, the defendant number one, who's assailing in this petition, has categorically raised in his written statement that one, there has been a devaluation of the suit scheduled property and proper court fee has not been paid. That has been addressed in the issues which has been formed by the trial court. But whereas the question comes as to the maintainability of the suit with
OS
respect
of
to
2007.
Yes, my lord.
ಯಾವಾಗ ಹಾಕಿದ್ದು application?
My lords, the application is filed on
28/6/24.
my lords, 10/2/2025, my lords.
You filed the application.
Yes, I filed the application challenging.
Anything else?
My lords, the pecuniary jurisdiction does not get maintained, my lords. I have provided the valuation report at page number 44. And I had also raised this issue with the written statement. It was the duty of the
When
court.
did you file the written statement?
My lords, written statement was filed in 2009. In 2009, at para number 5, my lords, if a lordship could be at
What
page
were you
num-
doing till now, sir?
My lords, after that, the plaintiff passed away. They got their legal heirs on record. No, I mean, my lords, the delay was not only contributed from my side, even from the plaintiff's side also before the trial court. They
15
should-
years passed by.
No, my lords. Let me, my lords, my intention is I have to mention this in the written statement, my lords. I have raised this in the written statement. Because
Raising it in the written statement and keeping quiet for 15 years.
Yes, that is
Anything
correct.
else, sir?
Well, apart from this, see, the real issue in question is as far as the suit pertains to the scheduled property, I have already enjoyed the decree in another case. This is a subsequent
Project
case which is.
everything there, sir, not in.
And my lords, if the suit is going to be decided without pecuniary jurisdiction at the end of the day, my lords, it's not going to do any good for the plaintiff in the hands. Because my lords, I have produced at page number 44. If my lordship could see 44, this is the valuation as per the guidelines value.
Now, why is it rejected?
My lords, there is no detail.
What? No detail.
The document is not produced. I have not demonstrated before the trial court that why does it does not have the pecuniary jurisdiction.
Yes, sir.
Page number 44, my lords. This is the guide. The suit scheduled property comes within the area of serial number 11, your lords, Ashok Nagar.
Anything else, sir?
And the trial court's only observation is that we have not demonstrated before the trial court the documents that is required to demonstrate why this does not come before the pecuniary jurisdiction, my lords. But at the end of the day, if the trial court goes to hear on the decree or passes the decree without having any pecuniary jurisdiction, it is not going to do any good for the parties, my lords.
What is issue number 4?
Court fee, my lords. At page number 36 is the issue.
Anything else, sir? Anything else?
Page number 5 is 4 is yes. Court fee is paid as proper, my lords.
Anything else? Dismissed. Next. 2007 suit ಎಲ್ಲಿವರೆಗೆ ಎಳಿತೀರಾ? Yes. Next.
When I am for the respondent contest petitioner.
Partial decree.
But this is a specific performance suit. They want
Partial
a
decree readiness and willingness.
Without proof of readiness.
I show to my lords 2-3 paragraphs in the written statement and one document. Then I leave it to my lords consideration.
Yes, sir.
But, the trial court has held that the entering into agreement is not disputed. The only question is the readiness. Agreement between the parties is not in dispute. That's what the honorable trial court says. It only says readiness and willingness is the issue.
Correct.
Lords, kindly come to my lords para 24 in the written statement. My lords would get at page 111.
111. Ashte.
Lords, this is with respect to my averments in para 23, my lords. The plaintiff was worried as defendants had not registered the agreement to sell and the power of attorney executed by them, and further on the insistence of the plaintiff, T. Sudhakar had organized a meeting in Kolkata between the defendants and plaintiffs, and still further the defendants assured the plaintiff that they have executed the necessary papers and get them registered are all false. This is what they say. Then my lords, kindly come to page 112, middle paragraph.
Yes.
Further, defendant number further humbly submits that the meantime before fixing up a meeting with the plaintiff, defendant number 1 was issued a legal notice dated so and so by the plaintiff against the defendant number 1, when it was clearly mentioned by the plaintiff that the agreed sale price was rupees 1,25 lakhs for the share of first defendant in the scheduled properties, and further that the said agreement was entered into in consideration of an advance amount of rupees 1,50 lakhs, out of which 50 lakhs was paid by way of demand drafts, and falsely claiming that the balance of rupees 1 crore being part of the advance of rupees 1.5 crores was also paid. The plaintiff further in the said legal notice issued stated that defendant number 1 would hand over the documents pertaining to the partition of properties along with the family members to avoid any hardship to the plaintiff. The defendant number 1 humbly submits that this legal notice issued by the plaintiff clearly evidences the extent of first defendant share in the sold to be sold to the plaintiff, and the same was agreed at a sale price of rupees 1,25 lakhs. Then let us kindly come to para 34. My lords,
yes, sir,
get
this is
that
not enough. This was not enough.
The question is, admittedly there are two agreements. One is for 50 lakhs per acre, another is for 1 crore 25 lakhs per acre.
Yes.
They are disputing the agreement of 1 crore 25 lakhs per acre. But in the reply, they admit 1 crore 25 lakhs per acre. And they paid me only 50 lakhs. It is my case. They don't have capacity to pay the balance consideration. Total extent of land is 32 acres. And without even proving readiness and willingness, my lord, suit for specific performance cannot be decreed. That is the law of, kindly see, my lord.
That is there. Yes.
Yes, my lord. Therefore, trial court has rightly rejected 12 Rule 6 application on the ground that they have to still prove, even if the agreement is admitted, they have to still prove readiness and willingness before the court by leading evidence. So therefore, my humble submission, my lord, this can't be decreed under 12 Rule 6 merely because I have admitted the agreement. Even assuming that I have admitted the consideration, my lord, but still they have to show from the date of agreement till the decree, they have the sufficient resources to pay the balance consideration.
OS 2008 I
Yes, my lord. And it is filed in 2024. Once it is dismissed for default, they filed an application for the recalling.
Yes, sir.
Submission is this, my lords. 50 lakhs per acre is the agreement under a registered instrument, which is registered before the sub-registrar. They are setting up an agreement for 1 crore 25 lakhs. That agreement has not seen the light of the day. They're producing only a photocopy. That's the submission, my lords. My submission is, my lords, when they have admitted.
The second agreement is not registered.
Not registered. No. Second agreement is not seen. According to them, there is that. It is not registered. The agreement on which the suit is filed, my lords, is a registered sale agreement.
That's the 50 lakhs.
50 lakhs agreement. Let's kindly see, my lords, page 112, my lords. No, not page 112, my lords. I will show, my lords, page 118. Their intention is evident from here. Page 118, my lords, last but one paragraph. Defendant number 1 most humbly submits that the plaintiffs in the first place has got the own way of interpreting facts and suits his convenience, and further that the plaintiff has based his entire submission in the plaint upon his wrong interpretation of facts. Defendant number 1 submits subsequently.
Where is the agreement of sale?
Lords will find that agreement of sale at page number 66, my lords, annexure C.
This is the registered agreement.
Yes, my lords. And the agreement that they are relying upon is at annexure F, my lords.
Page,
my lords, at page 123. Which is unregistered.
And where is the admission of 40%?
Lords, in both the agreements, my lords will see 40% is the share to be sold. Both the agreements. Both the agreements.
In the registered agreement?
40%, my lords. My lords will find at page 72.
70?
72. And page 73. He owns 70%, and in Roman capital 4 he says his share he is going to sell. Thus the dispute arose, my lords. We are saying the agreement is for entire 36 acres, not just his 40%. His daughter and son also agreed, wife and daughter. Therefore, we said insisted upon execution of entire 36 acres sale deed. Therefore, we filed the suit for specific performance. He said, my share only I am going to sell. Therefore, we filed the suit for specific performance because we said we are not happy with only getting 40%. Now that, my lords, the other persons have denied, and now he is agreeing.
That is why 12 Rule 6.
12 Rule 6. Only in so far as his share must. The suit will continue in respect of the remaining share.
One submission, but they only replied to the legal notice where they have admitted 1 crore 25 lakhs.
That's again, that notice, my lords, let him produce the original, my lords. That is a dispute.
Kindly see
that we have disputed. That original has not seen the light of the day. This agreement.
Their own advocate.
Why did you admit this?
No, we have not admitted.
This is your reply.
No, we have said it is not our reply.
No
such
same
reply was
advocate
given.
issues
Let him
two
produce the
replies.
original, my lords.
Therefore, it's a matter of evidence, my lord, whether really this notice or the reply was issued or not.
That is with respect to, again, my lords, 100% shares.
Kindly see two judgments. Kindly see in the first judgment, my lord, para 26, my lord.
2016.
2011.
Readiness and willingness.
Yes, my lord. There, the court says, even if the defendant is absent, court shall not decree the suit unless readiness and willingness is proved.
Second judgment in.
Second judgment is same, Lord. Here also is division bench judgment where court says readiness and willingness, it is the burden is heavy on the plaintiff to prove.
Paragraphs.
Paragraph, my lord, head note itself, my lord.
Head note.
Yes, my lord.
Paragraph andre head
My
note.
lord, para 34, my lord.
Ah.
Yes.
34 to
You see
38.
this one document, my lords.
Kodi. Heard
6/5/2008. Court of-
reserved. Heard reserved. Next.
My lord, suppose your lordship, my lord, dismisses, let there be a direction to the trial court to dispose of the
Learned
suit, my
friend
lord.
is assuming that
2000
my lords will dismiss.
2008 suit, my lord.
Suppose.
My lord,
That I will do. 2008 suit,
Eight suit.
definitely we will direct the court to conclude the proceeding.
Yes,
The evidence has to start yet, my lord. It's at that stage.
Whatever, in accordance with laws.
The 6/5/2008 is their own letter, my lords, which is not disputed.
Yes, yes.
From this, it is evident that they are not only asking 1 crore 25 lakhs, they are asking for 1 crore 30 lakhs. My lord.
Yes, we'll see. Next.
Please.
Yes.
Interim order, may kindly.
Interim order to continue to the next date.
Great.
much of.
Right. Last date, my lord.
What last date? Deletion.
Yes.
25 ವರ್ಷ ಆದ್ಮೇಲೆ.
Subsequent we are all residing therein.
All subsequent.
And ನೀವು ಯಾರು?
My lord, we are all, my lord, purchasers. Houses are constructed, we are residing therein for the
Revenue
last 7
layout.
decades.
ಯಾವಾಗ purchasers when?
My lord, some of these, my lord, 4 purchasers are prior to the preliminary notification.
Only 2 persons are the prior to the
I have
preliminary
produced a
notification.
sale deed, I have just.
All others were 2015, 2021, 2003 is
But
the
I am not
notification.
challenging the acquisition proceedings, my lord. We have given a representation, requesting them to consider our representation for deletion. Well, till then they should not, this is what I have.
What right you have? Nothing.
Lord, we are residing therein, my lord, for.
Yes, Krishna.
Let them consider the representation, my lord. I have given representation.
Notifications are 2003. These persons are claiming they have purchased.
ಅಲ್ಲ ಇಬ್ರೇನೋ ಮುಂಚೆ ಇದಾರಲ್ಲ.
ಅವರಿಗೂ ಬರೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ my lord, this is pertaining to further extension of Vishweshwara layout. There, my lord, in the this honorable court, my lord, granted 3 months time, my lord, 2 months plus 1 month. Thereafter, my lord, we have also a fixed date as a 31/12/2014 as the last cut-off date for the revenue site holders to file the application. Thereafter, some persons are filed, but we have sought the permission from the state government to permit them to consider. The state government said, my lord, after 31/12/2014, no application cannot be entertained by the.
In fact, kindly.
No, sir, and your subsequent purchases.
Lord, I am only praying, my lord. Let them consider our, I have given the representation, my lord. Consider in time frame, my lord, because they have not taken possession. Award is not yet passed till today.
No, award
Till
is
today,
passed.
my lord. A possession is not taken.
Just another round of litigation ಅಷ್ಟೇ ಇನ್ನು. ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಮತ್ತೆ ಬರ್ತೀರಾ.
Just only direct them to consider, my lord.
Yes.
I have given the representation. Kindly see the.
Consider
Keep
the
the time frame and
Without
pass
expressing
orders.
any opinion.
That is correct. The petitioners are before this court seeking the following prayer. The petitioners are said to be residents of certain properties which has now come within the notification issued seeking acquisition of the land for formation of Sir M. Vishweshwaraya layout.
Further extension of server.
Further extension of Sir M. Vishweshwaraya layout. The learned counsel for the petitioner submits as on today, the petitioners are residing in the property and no compensation is paid for having constructed the houses and constructed the houses in the property that is now become subject matter of the aforesaid acquisition. The learned counsel appearing for the respondent K. Krishna would submit that the petitioners have no right whatsoever as they are all subsequent purchasers of the property subsequent to the acquisition, subsequent to the notification date of the year 2003,
Yes.
which was for acquisition of 2003 for acquiring lands for formation of this aforesaid layout. But however, would submit that if no opinion is expressed by this court, the representations would be considered in strict consonance with law and appropriate orders would be passed.
Annexure J series are represented.
So and so. Yes. The learned counsel, in the light of the said submission, the petition stands disposed with a direction to the respondent to consider the representation submitted by the petitioners - annexure J series as appended to the petition with an outer limit of
8 weeks.
Outer limit of 8 weeks from the date of receipt of the copy of the order. It is made clear, no opinion is expressed by this court on the right of on even a semblance of a right of the petitioners. The direction is only to consider the representation simpliciter in accordance with law. Yes.
Till then, well, they should not precipitate.
ಏನ್
Other cases,
ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿಲ್ವಲ್ಲ ಮತ್ತೆ 23 ವರ್ಷದಿಂದ ಏನು ಮಾಡಿಲ್ಲ, ಈಗ ಮಾಡ್ತಾರ? ಎಸ್ ನೆಕ್ಸ್ಟ್. ಹಂಗಾರೆ ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಿದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಮುಂಚೆ ಮೂವ್ ಮಾಡಿ ಪ್ಲೀಸ್. ಎಸ್ ಆರ್ಡರ್ಡ್ ಅಕಾರ್ಡಿಂಗ್.
I will take notice for 2 and 3.
ಯಾರಿಗೆ?
2 and 3.
ಪ್ರದೀಪ್ ಕುಮಾರ್ ಜಾಗದಲ್ಲ?
ಅಲ್ಲ earlier matter.
ಕ್ಲಿಯರ್ ಅಲ್ಲ ಅಲ್ಲಿ ಅದು ಚೇತನ್. Learned Counsel K. Krishna is permitted to file his wakalat in the next 4 weeks for respondents 2 and 3. Heard admel heard ಅವ್ರದ್ದು ಹೇಳ್ಬಿಡಿ.
First respondent is the state.
One AGA, HCGP. Yes.
Therefore, petitioner, my lords, the acquisition is challenged on the ground that we are not notified, though we are the owners, prior to the preliminary notification.
Preliminary notification ಯಾವತ್ತು sir?
Preliminary notification is 2/6/22.
Oh, by then you had purchased the lands in 2020.
4/10/2019.
No revenue records, my lord, standing as on the date of my lord, the issuance of
They were all
notification, either my lord
converted in
final,
2019.
either preliminary or my lord final. ಎರಡು issue ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರ records.
ಆಯ್ತು, objections ಹಾಕಿ.
Lord, now he is saying that my lord, he wants to award compensation.
I have submitted before the authority that if they give me compensation, I do not want to challenge the acquisition, but they have ignored my documents which are prior to the preliminary notification. Even now, if they say that they are willing to
Always,
award,
my lord, he is entitled based on.
He is entitled for compensation at best, yes.
Once award is passed, my lord, if there is dispute, my lord, we will have to, my lord, refer the
Let
matter
us
to
see.
the.
If whatever you want to file, you file. If you want to file, list the matter on 25th. Objections, if any, by then.
No, ಸ್ವಲ್ಪ.
ಆಯ್ತು, list the matter on 30th. Sorry,
Let them not take any
29th.
Let them not take
Objections,
any
if any,
further
by then,
steps.
the respondent shall not precipitate the matter till the next date.
My lord, he is not pressing the acquisition. He wants, my lord,
Then leave it,
compensation.
yes. So list the matter on 29th.
There's no point in granting interim order. He wants, my lord, compensation.
ಏನಿಲ್ಲ, 29th ಅಷ್ಟೇ.
My lords, if they proceed to pass the award in the name of the previous owner, then it results in another dispute.
Lord,
Therefore, they should be stopped. I am ready to accept the compensation even today. If they submit, I am ready to.
Lord, it takes another, my lord, 1 year to, my lord, pass award, my lord.
29th ವರೆಗೆ ಏನಾಗಲ್ಲ.
My lords may kindly give some protection. The third time I am before my lords on this matter.
No, nothing will happen. What award?
Award pass ಮಾಡಿದ್ರೆ
Lord, you will
ಆಮೇಲೆ
ask-
civil
you will ask
court
him-
ಅಲ್ಲಿ deposit ಮಾಡಿ
you will
ಅಲ್ಲೋಗಿ
ask-
petition
you
ಹಾಕಿ
will ask him,
ಕಳ್ಸಿದ್ರೆ
my lord,
it's,
you will ask him to say that, my lord, the award, my lord, the
That is always
compensation.
subject to the result. That's a different thing.
no, but if
Compensation release
30
ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ಬೋದು ಅವನು. I don't have
The
that.
respondents shall not release compensation without the leave of the court to the next date. Yes.
26.
Page 85 covered, ah?
Please, my lords. Same 28/3 order, my lords.
Yes, Pradeep Kumar.
ಅಲ್ಲ, objection ಹಾಕ್ತೀನಿ, ಯಾವ್ದು ನೋಡಿಲ್ಲ.
25. The learned counsel for the petitioner submits that the issue in the list stands answered by page 85 on the number haki. So the learned counsel H.L. Pradeep Kumar seeks 2 weeks time to file statement of objections. Objections, if any, by the next date, list on 25th. ಅವತ್ತಲ್ಲ ಅಂದ್ರೆ close ಮಾಡಿ. Interim order subsisting will continue to the next.
First time.
There shall be an interim order of stay for as prayed for till the next date.
Next date
Covered
ಹಾಕ್ಬಿಡು,
ಅಂದ್ಮೇಲೆ
ಮುಗಿಸ್ಬಿಡು.
ಮುಗೀತಲ್ಲ.
ಮುಗಿಸ್ಬಿಡು.
ಆಯ್ತು, 18th ಗೆ ಹಾಕಿ ಹಾಗಾದ್ರೆ. List on 18th.
Interim order.
ಯಾಕೆ ಇರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ, 18th ಗೆ ಹಾಕಿ interim order ಬಂದು ಮುಗಿಸ್ಬಿಡೋಣ ಅಷ್ಟೇ, ಮತ್ತೆ ಅದು vacate ಮಾಡ್ಸೋಣ.
18th.
ಆಗಿ ಬೆಳೆ ಇದೆ ಸರ್.
ಅದಕ್ಕೆ ನಾವೇನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ, ಯಾವತ್ತೂ ಮಾಡಲ್ಲ.
There shall be an interim order as prayed for till the next date of hearing. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಮುಗಿಸ್ಬಿಡೋಣ. List on 18th ಮಾಡಿ, 25th ಬೇಡ. Next.
Lords, I appear for the petitioner in 27.
File an appeal, sir.
Lords,
File an appeal.
no, my lords.
What are you challenging?
I am challenging the order passed by the trial court. my
What
lord,
order?
Which is not a designated commercial court.
Not a designated commercial court?
Yes, my lord. The dispute arising out of a commercial instrument, that is power purchase agreement, my lords, which is at Annexure C. And the subsequent
Where is the
agreements.
respondent? Shahbaz Hussain?
Lords, I have served copy on the
I appear
respondent.
for the respondent number 3, your lordships. Bestcom,
Yes.
the distribution licensee, we are a formal party in the matter.
Formal party?
Please, your
Who is the
lordships.
contesting respondent, sir?
Respondent number 192, my lords. Lords, I
1 minute. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀನಿ, they outrightly denied accepting the petition.
Leonard, where is the affidavit?
My lords, I have sent it through RPAD and the
The
notice
learned
to R2
counsel
is served.
for the petitioner submits that the respondents 1 and 2 have declined to accept the notice as directed by this court. Therefore, the registry to print their names and show them as served in the cause list. List the matter on 25th. There shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Interim order as prayed for till the next date of hearing. Yes.
Grateful.
Next. Yes, sir.
Your Lordship, before London Senior starts, there's a caveat.
There's no caveat, my lords.
Your Lordship, there's a caveat in the matter, and the order they're challenging is 23/2025
Let me make
dated.
my
on the-
submission.
Yes, sir.
Lords, they may be asked to serve me a copy.
Yes, sir.
Lords, they kindly see Annexure L, my lords, at page 107. 111, my lords, page 111. My lords, these are the listed foreign direct investments which are permitted.
What is under challenge, sir?
No, lords, I sought, the witness admitted that she has obtained permission from Reserve
What
Bank
is
of India.
under challenge? Rejection of what?
My lords, the challenge is to the order dated
20th March
summoning
2025 on IA number 22. Where is it?
Please, my lord, summoning the RBI permission which they have obtained.
Where is it? Where is the order?
That page, my lord, it's at 144. Your lordship will kindly see at page 156. The evidence, the PW admits, the plaintiff admits, I have made investments in India. It is not true to suggest that I have not obtained previous permission from Reserve Bank of India for investments made in India. My investments made in India is foreign direct investment. Now the investment, my lords, is they send some money to the defendant directly, foreign currency, ask me to purchase some land in Benami name. In Benami name. Later, 10 years later, they'll come back to India and take shares in the company.
Oh, agreement. Where is the agreement?
The agricultural lands.
Where is the agreement of that kind?
There is no agreement. There is no, they say it's all oral. Now, your lordship will kindly say, my lords, under page 111, the permitted investments.
Permitted investments, FDI.
It is not FDI because your lordship will kindly see this sketch, my lords. FDI, foreign direct investment, would mean investment in shares and securities. And that would be in the
You file your
company.
objections.
In the company.
The learned caveat, you're on caveat?
There's a
They are
caveat,
not
your
on
lordship.
caveat.
The learned counsel for the learned counsel so-and-so submits that his
Your lordship,
filed caveat.
it is not put up. We also filed wakalat.
Submits that is already entered appearance for the respondent. Registry to print the name of so-and-so as appearing for the respondent. List the matter on 18th, objection if any to the objections if any by the respondent by then. Yes.
In 15th, it is set down for the other two, in the evidence, my lords, the witness says that she does not know any of the defendants. There's nothing to submit on behalf of the defendants.
Will only stay the cost imposed if you want and nothing else.
Please, ma'am.
There shall be an interim order of stay only of the order only insofar as it imposes cost of rupees 10,000. Yes. First list ಅಲ್ಲ? First list. ಮಾಡಿ correct ಆಗಿ ಹಾಗೆ ಮಾಡೋಣ.
This is for, correct? My lord, company not being made an accused.
El Jagdish,
Tejas.
Tejas, covered.
Covered.
Del D'Souza.
Please, I have given, my lord. Your lordship has followed that in Mitchell Van der Maat's case.
Put it.
that is- I've given it's on record. Last date. And 25 of Contract Labor Act itself. Any other copy, may not put. Sir,
Court of.
court of.
The petitioner is before this court, calling in question the proceedings in CC
1777.
1777 of 2015, registered for offences punishable under section 23 of the Contract Labor within bracket Regulation and Abolition Act 1970, hereinafter referred to as the Act for short. They heard the learned senior counsel Murthy D. Nayak appearing for the petitioner and the learned HCGP representing the state. The petitioner, facts in brief, Chairman. A complaint comes to be registered against the petitioner alleging offences punishable under section 23 of the Act before the concerned court on the score that the petitioner has undertaken contract work through 70 contract laborers on 8/3/2015 without obtaining license and thereby violated section 12(1) of the Act, and therefore it springs as an offence under section 23 of the Act. The learned senior counsel submits that the complaint so registered suffers from a threshold bar, as the company is not made a party while making the petitioner the managing director,
CEO.
While making the petitioner the chief executive officer of the company as a party to the proceedings. The learned counsel would submit that the issue in the list stands answered by plethora of judgments rendered by the apex court as followed by this court. He would particularly place reliance upon the judgment rendered in ILR
SCC
2023 SCC Online Karnataka 467. Paragraph, sir.
I have flagged that, my lord, because this was my
sorry.
copy. Sorry.
The last, anyway.
Yes, that is, your lordship follows Dale D'Souza.
Yes.
This is a
So,
comprehensive.
ಇದನ್ನ ಎಲ್ಲಿಂದ ಕೋಟ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ತೀನಿ. Allowed, quashed on the same lines.
Great.
Yes. Your name is still not shown?
No, Lord.
You've not entered.
For the petitioner, Lord.
Yes, Madhukar.
A3 squashing petition.
Voluntary statement, no corroboration.
There are corroboration.
There are
There is
corroboration.
discovery as well as corroboration.
Discovery.
Lord, let me just
Yes, you do
set
it.
the framework
Yes,
of my
yes,
case, then
sir.
my learned senior friend can respond
Yes,
accordingly.
yes. No, I asked him. Yes, tell
Yes.
me.
I've gone through their objections as well.
Ah.
Lord, there is a charge sheet in which I'm arraigned as A3. In that entire charge sheet, let me fairly disclose to your lordships what is the incriminating material against me, A3. Lord, A3, Lord, there is a confessional statement which the NCB relies on. That's point number one. That was my statement recorded under 67. There's a confessional statement. The other incriminating material is a statement of the co-accused, that is A2, in whose possession and in his house there was ganja and other substances that were seized. He says in his statement that I went and procured these drugs to be sent on courier on the instructions of A3. So there are essentially two incriminating materials, my own confessional statement, and the other statement is the statement of A2, a co-accused. Now, Lord, my entire submission since day one, Lord, when this matter had come up, are both premised in two propositions of law. Therefore, the response also should be an engagement with the proposition of law and not a reiteration of the factual history. Lord, the first proposition is my 67 statement is something which is inadmissible on account of Tufan Singh. So that goes out of the question, Lord. The other statement, which is statement of accused number 2, Lord, on account of 315 CRPC, Lord, accused is competent to give testimony only as a defense witness. He can never be brought in the box as a prosecution witness unless he turns approver, and that is not their case at all. Their entire case, therefore, must engage with my two propositions of law, that my own confessional statement is not admissible in law, And second, A2 is not an admissible witness at all. He cannot enter the box. 315 bars him from entering as a prosecution witness. Therefore, not the statement of objections all I've seen on the previous date, Chetan Bembalikar's case was cited. There's nothing not in their objections which tries to link this to Chetan Bembalikar at all. I don't understand why that was submitted not. But therefore, not from their objections, I have not said anything other than what is pointed out in their objections as well. That the parcel was purchased and then couriered on instructions of A2. Nothing is recovered from me. No seizure. I was not the recipient. I was not the sender. So on all fronts, there is no admissible material at all against me, and therefore, my responsibility should be quashed.
Really?
My lord, charge has been framed, my lord.
Yawaga?
2022 charge has been framed. Then 2 witnesses have been examined. Once the charge is framed, my lord, the scope of trial changes, my lord. Prior to the charge, my lord, the burden of proof, the reverse burden of proof would not kick in. Once the charge is framed, my lord, the burden of proof, what is contemplated under the act, my lord, would kick in. Then the scope of investigation in the light of Noor Aga Khan judgment, my lord, would change, my lord.
Charge frame agovide.
Yes, charge has been framed. 2 witnesses have been already examined, my lord. PW1 and PW2. My submission is that, my lord, the burden is not on me. Foundational facts have been proved, and on that basis, charge has been framed. The burden is on him now.
I'll respond to that.
Charge frame again.
No, if I've sought for quashing of a charge sheet, subsequently there are charges that have been framed.
No,
but if I'm hitting at the very root.
Subsequent adre tondre illa. If you have sought quashing and subsequently charge is framed, definitely no problem.
Look, the standard at the discharge stage is one of suspicion. If I can show that even on all materials, admittedly, if it's taken No, I know there's a defect in the prayer now that there are charges.
It goes contrary to the principle that I every day follow, that once charges are framed, I will not.
If there are charges framed, then unless I amend my petition and then ask for
482.
There is one more recent judgment, my lord, with reference to NDPS. That is Justice Pardiwala, after framing of charge, what is the scope of discharge?
This 482 alva?
In this case, it is discharge, my lord.
Discharge is rejected, is it?
No, discharge, they have not filed the discharge. Directly, they have come to 482.
All right.
I request my lords to kindly take second page, my lord. The scope of section 216 of CRPC, the earlier CRPC, my lord,
that is
discharge
discharge,
provision,
yes.
that has been discussed with reference to the charge as well as the burden of proof, my lord. I request my lords to kindly take page number, my lord, digital page number 109, my lord, para 151. The discussion regarding the framing of charge and discharge that has been discussed from para number 151 to 155, my lord.
Deleted of the accused discharge under 216.
But if charges are framed, then I'll have to withdraw this petition.
That's what I
I
generally
am not
do.
aware that charges have been framed. If charges have been framed, then
ಅವತ್ತೇ ಹೇಳಿದ್ರೆ ಅವತ್ತೇ ಮಾಡ್ತಾ ಇದ್ರು.
Sorry, my lord. ನಾನು ಹೇಳಿದ್ಮೇಲೆ ನಾನು ನೋಡಿರೋದು ಅಲ್ಲಿವರೆಗೂ ನೋಡಿಲ್ಲ.
ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕಾಗಿತ್ತು?
Charges are framed, then
The
I have not even
learned-
filed a discharge application.
Correct. The learned counsel appearing for the respondent NCB submits that the charges have been framed on 15/6/2022 and places on record the order of framing of charges. In that light, the learned counsel Angad Kamath submits that he would seek to withdraw the petition and avail of such remedy as is available in law.
So great.
Deserving such liberty, the petition stands disposed.
Pardiwala judgment.
ಇರ್ಲಿ ಬಿಡಿ, ನಾವು ಓದ್ಬಾರ್ದ? Yes. Unless Madhukar, you want to give it to some other court now. Yes. I appear for 31. Yes, sir. ಆಮೇಲೆ
ಅವರು ಫೋನ್ ಕಾನ್ವರ್ಸೇಷನ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಹಾಕಿದ್ದಾರೆ.
ಫೋನ್ ಕಾನ್ವರ್ಸೇಷನ್ ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
Yes, sir.
Find all the, along with the 65B affidavit, my lords, I
All
filed
right.
all the transcriptions, which in detail demonstrate what respondent number 2 has said, what respondent number 3 has said, what is the demands that is being made, what is the harassments that's being made, what is the cruelty that has been induced. Everything is there. Everything is there, my lords.
Oh.
It's when such is the depth of this significance, I don't see, my lords, this court should entertain a 482. my lords.
Oh, we'll see what I'll see.
Yes, my lords, please. Should. My lords, the file, it was filed on,
Yes, sir. ನೋಡಿದ್ದೀರಾ?
8/7.
ಏನು ಇಲ್ಲ.
ಏನು ಇಲ್ವಾ?
Point out. Let him point out.
yes,
ಪೇಜ್
sir.
ನಂಬರ್ ಹೋಗ್ಲಿ, ಅದು ತೋರಿಸ್ಲಿ, ಇಲ್ಲಿ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರು, ಇಲ್ಲಿ ಕೊಟ್ರು, ಕೇಳಿದ್ರು ಅಂತ ತೋರಿಸ್ಲಿ.
ಇದೇನು ಸೆಕ್ಷನ್ 7 PC ಆಕ್ಟ್ ಅಲ್ಲ ಡಿಮಾಂಡ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಗೆ.
ಅಲ್ಲ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲ ಅವ್ರು ಏನು ಡೌರಿ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರು, ಡೌರಿ ತಗೊಂಡ್ರು ಅಂತ. Let him point out.
ಹೇಳಿ.
Ink page number 10, my lord.
Ink page number 10 ಯಾವ್ದ್ರದ್ದು?
This is on 8/7/2025. I have filed.
8/7 is it?
Yes, my lords. I filed all the additional documents.
2/7.
Page number 9 and 10, my lords.
There is 2/7, there is no 8/7.
Document.
My lords, I filed this document and one moment. Should be a part of the file, my lords.
8/7, yes, sir.
The ink page number 10. ಫಸ್ಟ್ ಲೈನ್ ಮಾವ ನೇಣ ಆಗ್ತಿದೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಮ್ಮ.
ಒಂದು ನಿಮಿಷ
ಯಾಕ್ರಿ?
ನಾನೇ ನೋಡ್ತೀನಿ ತಾಳಿ, ನಾನೇ ಓದ್ತೀನಿ. ಏನೇನೋ ಇರುತ್ತೆ ಅಲ್ಲಿ, ಓದ್ಬೇಡಿ. ನೇಣ ಹಾಕ್ಬೇಡಿ.
ಅದು ಪೂರ್ತಿಯಾಗಿ ಓದ್ಕೊಂಡ್ ಬಂದ್ರೆ ಅರ್ಥ ಆಗುತ್ತೆ.
ಒಂದ್ ನಿಮಿಷ. ಈ ಡೌರಿ ಡಿಮಾಂಡ್ ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ ಪೇಜ್
Lordship, ink page number 20, my lord. Ink page number 19 also. Ink page number 19, first line. Rupa, the petition respondent number 2. Now first ನಮ್ಗೆ ನಾವು ಬಂದಾಗಲೇ ತಾವು ಡಿಸೈಡ್ ಮಾಡಬೇಕಿತ್ತು ಇವರು ಬಡವರು ಬೇಡ ಅಂತ. ನಾವೇನು ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಏನು ಹೇಳ್ತಾ ಇಲ್ವಲ್ಲಯ್ಯ?
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ink page number 20. ಮಧ್ಯದಲ್ಲಿ ಸ್ವಾಮಿ ಮಾವ ನಮ್ಮ ಹುಡುಗನ್ಗೆ ಯಾಕಿಲ್ಲ, ಯಾಕ್ರಿ ಫೋನ್ ಮಾಡಿ ತೊಂದರೆ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳಿದ್ರೆ ಒಡವೆ ಕೇಳಿದ್ರೆ ಇವ್ರದೇನು ಹೋಯ್ತಂಗೆ ಅತ್ತೆ.
ಆಯ್ತು ಅದೆಲ್ಲ ಅಲ್ಲಿ ನೋಡೋಣ. ಜಗದೀಶ್ ಸರ್ ನೋಡಿದ್ದೀರಾ?
Also, lords, the last sheet also, from the direct message also, my lords, where they demanded the money.
There appears to be more of threatening than actual assault. But he ಹೇಳಿರೋದು what the allegation 498A 3 and 4.
3 and 4, yes, my lords.
Yes, sir.
There is absolutely nothing in this entire conversation.
Yes.
All that they discussed was.
We will not go into conversation.
ಮದುವೆ ಆದ್ಮೇಲೆ ಅವ್ರ ಮನೆಯಾಗ ಇದ್ದಾಗ ಅಳ್ತಾ ಡಿಸ್ಕಸ್ ಮಾಡಿರೋದು. ಮದುವೆಗೆ ಎಷ್ಟು ಖರ್ಚು ಮಾಡ್ಬಿಟ್ವಿ, ನಾವು ಅಪ್ಪ ನೀವು ತೊಂದರೆ ಕೊಟ್ಬಿಟ್ರಿ, ಇದು ಗ್ರ್ಯಾಂಡ್ ಆಗಿ ಮದುವೆ ಮಾಡ್ಕೊಡು ಅಂತ ಬರೀ ಇದ್ರ ಬಗ್ಗೆ.
ಬರೀ 498A 34 ಅಲ್ವಾ?
3 and 4.
DP is there. That is without DP 498A ಬರೋದೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಮೊದಲು
ಎಸ್ ಜಗದೀಶ್ ಸರ್ ನೋಡಿ
ಫೋಟೋಗ್ರಾಫ್ ಹಾಕಿದ್ದಾರೆ.
ಡಿಮಾಂಡ್ ಇದೆ. File discharge.
I have filed discharge. This is precisely what.
Second discharge.
Discharge rejected.
Rejected. Two times.
Part of their own petition.
Two times.
First, my lord, I filed a discharge.
Filed a discharge.
One second.
Hey, wait. ನಿಮ್ದು ಆಯ್ತಲ್ಲ, wait. ಇನ್ನೇನಿದೆ? Yes.
It was rejected. Holding that, my lord, complaint averments are sufficient. But I filed a revision petition. That was also rejected. I approached this honorable court. My lord remanded the petition back, saying that.
Remand alla, discharge hogi.
My lord remanded the matter back to the trial court, saying that to consider afresh the application which I filed for discharge.
Again the same thing.
Again same thing, my lord. Again he rejected my petition, saying that FIR contents are enough to hold that, my lord, the trial is enough. On the contrary, my lord, I filed a discharge application saying that there is absolutely no evidence whatsoever. Because, and moreover, I produced, my lord, certain documents. And my lord, the trial court holds that, my lord, these documents cannot be looked into at all. And on the contrary, my lord, there is judgment of the Supreme Court, which says, my lord, that the documents produced by the accused, lord, shall be considered at the time of, my lord, discharge application.
I will not send it back again.
Again, please. Now, what happened, my lord, is she filed 2 complaints. This is
Well,
the 3rd complaint.
You will,
So first 2 complaints, my
first
lord,
2 complaints ಏನಾಯ್ತು?
there is absolutely no allegations. And
When?
NCR, I filed, my lord, the memo, where, my lord, have considered and recorded, my lord, in the last date of order sheet 1. Please be seen.
Yes, sir.
Yes. Kindly see, my lord, the memo that I have filed, lord, contains 8 documents. What is it?
Memo itself speaks about demand of
Memo.
Which memo? List of documents.
List of documents. Yes. This is, my lord, 8 documents I filed before the trial court, along with my discharge application. And, my lord, the trial court says, my lord, that these documents cannot be looked into at all at this stage.
No problem.
On the contrary, my lord, the Supreme Court and this honorable court has also said that the documents which are relied upon by the accused shall be considered at the time of discharge application.
Face trials. Yes.
And, my lord, please see, my lord, the judgment of the Supreme Court.
ಅಯ್ಯೋ ನಾನೇ ಕೊಡ್ತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ. ಬೇಕಾದ ಜಡ್ಮೆಂಟ್ ನಾನೇ ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ, ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡ್ಬೇಕು ಅಂತ.
ಖಂಡಿತ
ನೋಡಿಲ್ಲ ಅವರು.
ತೊಂದರೆನೇ ಇಲ್ಲ.
ಅಲ್ಲಿ ನೋಡಿಲ್ಲ ಅವರು, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Kindly see, my lord, the
No,
impugned
sir.
orders.
No, having seen the conversation, I will not.
ಕಾನ್ವರ್ಸೇಷನ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ.
ಅದ್ ನಿಮ್ ಪ್ರಕಾರ ಏನು ಇರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಏನ್ ತೋರಿಸಿದ್ರಿ ಈಗ ಬರೀ?
ನಾನು ಏನ್ ನೋಡಿದ್ದೀನಿ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. Yes.
My lord, I also read, my lord. There is nothing, absolutely
Nothing. Anything else?
First 2 complaints, my lord, I read. First 2 complaints may please be seen.
Not necessary, ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ, ನೋಡ್ಬೇಕು ಅಂತ.
No, sir, I will not. We will not. This, sir, 482, I will not interfere. You have demanded dowry 498A 3 and 4 ಮಾತ್ರ ಇರೋದು. There is a demand for dowry.
In the first 2 complaints, there is absolutely nothing.
ಪರವಾಗಿಲ್ಲ.
My lords have seen that. Kindly see, my lord, the first complaint. At page number, my lord, 16. In page 16. Which was filed, my lord, on 22nd November 2019.
ಅಯ್ಯೋ ಅಲ್ಲೂ ಇದೆ, ಹೀಳಾಯಿಸಿ ಮಾತನಾಡಿ ನನ್ನ ದುಡ್ಡು.
ಈಗ 1 ವರ್ಷ 2 ತಿಂಗಳ ಹಿಂದೆ ತುಮಕೂರು ಮಾಡಿಕೊಳ್ತಿದ್ದು. ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರಗಳು.
See, if there is nothing, then definitely we can. But there are so many things here.
ಅಲ್ಲ, ಇಲ್ಲ ಇದರಲ್ಲಿ.
All this, no, I will not interfere. All these you have to be tested in trial.
So can you see, my lord, the petition number 3?
If you want me to refer to everything, I will definitely refer to everything and reject it. That may cause grave prejudice to you.
Third petitioner.
Third petitioner ಯಾರು?
Sister-in-law. My lord, what is the allegation against her, my lord? She is unmarried lady.
You should also not.
Unmarried lady.
Mother-in-law.
Mother-in-law, my lord, the second petitioner.
No, the first and second we will allow.
No, my lords, in general cases, I do understand that they would have made them as a.
ಇದರಲ್ಲಿ ಏನಿದೆ ಇವ್ರ ಮೇಲೆ?
But in the conversations, my lords, if my lords could read, even she has been a part in that, in kind of.
Been a part ಇಲ್ಲ. You hold the axe to grind against your mother-in-law and husband. Yes, Jagdish. Third petitioner we will. Yes. Then you withdraw the petition insofar as 1 and 2 is concerned. 3 we will allow.
That's 3.
ಸಾಕು ಇಲ್ದರೆ ಎಲ್ಲಾನು ಅಲೋ ಮಾಡ್ಬಿಡ್ತೀನಿ. ನೋ ಏನ್ ಅಲಿಗೇಷನ್ ಇದೆ?
Fine, my lords. I'll leave it to your lordship.
ಏನ್ ಅಲಿಗೇಷನ್ ಇದೆ? ಸಾಕು.
Right, my lords. Leave it to your lordship.
The petitioner, learned counsel appearing for the petitioner after arguing the matter at length, would seek leave of this court to withdraw the petition insofar as the petitioners 1 and 2 are concerned. The submission is placed on record. Insofar as petition number 3 is concerned, the offence alleged against the petitioner is the one punishable under section 498A and 3 and 4 of the IPC. The third petitioner is the sister-in-law of the complainant, the wife of the first petitioner. The learned counsel for the petitioner strenuously contends that a perusal at the complaint or the summary of the charge sheet would not indicate any offence against the sister-in-law, the third petitioner, much less the ingredients of cruelty or demand of dowry on such cruelty against the third petitioner. A perusal at the complaint and the summary of the charge sheet would vindicate his statement with regard to only sprinkling offences against the third petitioner, the sister-in-law, which would undoubtedly not meet the ingredients of section 498A or 3 and 4 of the Dowry Prohibition Act. In the light of the judgment of the apex court in the case of Kashkan Kaushar versus so and so 2022 SSC online SC 162, the proceedings que the third petitioner, if permitted to continue, would become an abuse of the process of the law. In that light, the proceedings que the third petitioner alone stands quashed. In the more so in the light of the withdrawal of the petitions by the petitioner 1 and 2, who are necessarily to come out clean in a full-blown trial.
Instructions could be given for them to face the full-fledged trial.
Huh?
Time could be fixed, my lord.
For what, sir?
Trial, my lord, 2020.
2020 since the issue is of the year 2020, the concerned court shall endeavor to conclude the proceedings as expeditiously as possible. Next. Ordered accordingly.
32. My lord, may kindly pass over, my lords.
Yes.
Pass over, my lords.
Pass over. CRP.
Yes, Your Honor.
Yes, sir.
Condoning the delay of 9 years, 23 days, that honorable court condoned, so that against that order, Your Honor,
Stay kottidivalla.
stay.
Yes, madam.
My lord,
It's
may kindly pass over, my
2020.
lords. Senior is held up in some other court. He'll be back, my lords. Kindly pass over.
I passed over to next Thursday. Yes. Passed over to 24th. Yes. Interim order subsisting will continue to the next date of hearing.
The petitioner in this case, Your Lord. Eviction before the court below. 33. Eviction before the court below, Your Lordship. Without giving proper opportunity, I have been evicted. An order of eviction is passed.
Proper opportunity ಅಂದ್ರೆ ಏನು?
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, Your Lordship may kindly appreciate the judgment is passed within 4 months itself.
ಮಾಡಬಾರದು ಅಂತಿದ್ಯಾ?
Definitely, I have on that point. I am not. But fair opportunity is not given. In spite of.
What do you mean fair opportunity?
Like, Your Lordship may kindly appreciate the.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದೀರಾ? ರೆಂಟ್ ಎಷ್ಟಿದೆ?
ಇಲ್ಲಿ ಏನಾಗಿದೆ, Your Lordship, now I have vacated the premises.
Vacated.
What has happened? The landlord, I was staying in ground floor. To cause hardship to me, the landlord has started putting up the construction at first floor. Lot of seepages were there and I vacated. My movable properties are there in the same premises. It is my contention, but now the landlord has taken out, and now with respect to the claim of rent is concerned, there is a dispute, Your Lordship. Kindly with regard to that one, the present case may be remanded.
The petitioner is before this court, calling in question the order dated 11th November 2019 passed in SC 15171 of 2019. Heard so and so. The respondent has remained continuously absent. This court on 5/6/2025 had passed the following order. The respondent was not present on the said date. Again, on 19/6/2025, the matter comes to be adjourned. On 3/7/2025, the counsel for the petitioner was heard and there was no representation on behalf of the respondent. In that light, the observation is as follows. 3/7 court made. Therefore, the petitioner, learned counsel, even today, there is no representation on behalf of the respondent. Therefore, the counsel for the petitioner is heard. The petitioner is the tenant, the respondent, the landlord. A suit comes to be instituted by the respondent, the landlord, seeking eviction of the petitioner. During the subsistence of the suit, it transpires that the petitioner has vacated and delivered vacant possession of the property. The issue is not with regard, thus the issue is not with regard to eviction. It is with regard to the payment of arrears of rent. The concerned court, on hearing the parties, has passed the following order. Para 10-2.
Damages also claimed before the court below.
10 to 7. The learned counsel for the petitioner submits that the petitioner was not afforded adequate opportunity to submit his defense before the concerned court. A perusal at the aforequoted order would indicate that the petitioner was indeed not granted sufficient opportunity to present his defense. The paragraph with regard to Exhibit P3, that is paragraph with regard to Exhibit P3 as quoted herein above, would clearly indicate that the petitioner had his defense and was not permitted to submit his defense. In that light, they afford one opportunity to the petitioner. For opportunity to the petitioner, the matter stands remitted back to the hands of the concerned court to grant to hear the petitioner afresh and pass necessary orders in accordance with law. The aforesaid reasons following allowed cost remitted back. Next.
34.
For the respondent defendant,
Yeah,
your lordship will
Ishwanda.
recall. Those are unnecessary. No orders have to be passed on that. Your lordship will recall on the previous date, we had raised a preliminary objection as to the maintainability of this petition under section 115. Your lordship had asked them to prepare and respond accordingly.
Yes, sir.
Their objection is
Objection.
as to maintainability. One finally maintain ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. It is 115 CPC ನಾವು ಹಾಕಿರೋದು correct ಇಲ್ಲ. I am filing a memo. Lord, this petition CRP will have to be considered as one under section 18 of Small Causes Courts Act.
Now that my preliminary objection is sustained, Lord, your lordship may please have the Small Cause Courts Act.
Could he?
Just one submission, then my learned senior friend may come. Lordship may have the Karnataka Small Cause Courts Act, because this is a civil suit for recovery of money that was
Yes.
not tried before a regular
Oh,
civil
this is
court.
that State Bank of India. Yes, sir.
Now, this is a civil suit for recovery of 80,000 filed in 2018. Just please see the
Yes, sir.
scheme of the Civil Courts Act, the Small Cause Courts Act.
We will dismiss it. State Bank of India 80,000. 20 ವರ್ಷ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, there's a very interesting question of law involved.
It's not about quantum.
Very interesting question of law.
Dismiss ಆ ground ಅಲ್ಲಿ dismiss ಮಾಡೋದಾದ್ರೆ I have no submission. My lords, all that I would like to say is non-disclosure of cause of action. I can show from the plain. Now that every possible contention is taken, I will meet whatever the contention raised. If 80,000 CRP ಹಾಕ್ಬೇಡಿ ಅಂದ್ರೆ then I have no voice in the matter. The wrong signal, my lord, bank will.
Oh,
go
no
for-
problem, sir. We'll take care of the signals. Don't worry. Yes.
Yes,
Then
but
on the
if your lordship were to
contention
see
raised
section
I will
19.
answer the contention raised by the other side. 80,000 ರೂಪಾಯಿ ನಾವು CRP ಹಾಕ್ಬಾರ್ದು ಅಂತಂದ್ರೆ this becomes a precedent. That is my worry.
20,000 ಆದ್ರೆ 80 ಲಕ್ಷ ಆದ್ರೆ ಹಾಕದ್ ಹಾಕ್ಲೇಬೇಕು. 8 ರೂಪಾಯಿ ಆದ್ರೆ
ಹಂಗಲ್ಲ.
ಮತ್ತೆ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಅಲ್ವಾ?
It becomes a
That's the
precedent,
problem.
my lord.
Yes.
I should not be.
Yes. Please see section 19, Lord, of the Small Cause Courts Act. Finality of decrees and orders. Very unusual, not your lordship will not find this in any other statute generally. Save as provided by this act, a decree or order made under the foregoing provisions of this act by a court of small causes shall be final. So generally, Lord, because the scheme of this
Cannot be challenged here.
No, that's why, that's the objection, Lord, that I had pointed out. Now, please come to page 18, section 18. There is a revisional remedy that is provided under section 18. Even against a decree, the High Court, Lordships are there.
Yes, one moment.
Give the court's copy the memo judgments. Lordships are there.
18, tell me.
The High Court, for the purpose of satisfying itself that a decree or order made in any case decided by a court of small causes was according to law, may call for the case and pass such orders with respect thereto as it thinks fit. Now, this, please see, Lord, what happens in the context of this case. There's a 711 that the defendant files. That 711 is allowed. The plaint is rejected. The rejection of a plaint on account of 22 CPC becomes a deemed decree. Against the decree, there is a revisional remedy that section 18 provides. They had initially filed under section 115. Now, why I raised that objection is because the scope of interference under 18 is very different from the scope of interference under 115. Now, according to law, Lord, your lordships have to satisfy your lordship that the decree was according to law. And if it is according to law, then there is no question of interference at all. Now, according to law has been interpreted in 1937. Your lordship will have this. Give them their copy. No?
What is it?
We'll hear it.
No, no, I will not take more than 2 minutes. I'll not take more than 2 minutes. Let me tell your lordship what the standard is.
Yes.
According to law has been interpreted to mean it is compared to the Wednesbury unreasonableness standard. No judge acting judicially would reach such a conclusion is the standard. So if they want to argue.
No, in which year is that?
From 1937, I've given you a lordship.
From 1937.
From 1937, full judge bench, full.
Anyway, 1937, Wednesbury can't be there.
No, it was them.
Wednesbury is in 1947.
It's
Wednesbury
equivalent to that
Corporation's
standard.
case is 1947.
It's equivalent to that standard from 1937 to 2019. I've given your lordship judgment. That is the standard. So if my learned senior friend wants to argue now, he will have to satisfy your lordships that that 711 application that was allowed is so wrong, is so erroneous that no judge acting judicially would arrive at such a conclusion. Here is a plaint in which they're asking for recovery of money, in which there is not even the basic averment to show when is the date of default. Under 711, if the date of default is not provided, there's no cause of action at all. It's allowed. So they have to satisfy your lordship that the trial judge acting under the small causes jurisdiction is so wrong that no judge would have come to such a conclusion.
We'll hear leisure. Reject agidiyalla plaint.
It's a 2018 suit. You the CRP.
We'll post it. I'll also go through this.
Yes, my lordship may see it, but the only point is on according to law, the standard is so high. That is because my lord, you want to give finality to decrees passed by the Small Causes Courts Act. It's comparable to summary trials under CRPC. If you start allowing for appeals, then it will become nothing different from a civil court. Not it will be a 96 appeal, it will come get lagged here. So they have to show that there is something so seriously defective in that order. And unless they satisfy your lordship on that standard, there is no reason to interfere with this.
17th, yes.
Our memo may kindly be taken on record.
We have no objection. It may be converted as to under section.
Shall be under section 18 and not.
Section 8.
So memo is taken on record. The subject proceeding is converted to section 18 of the Small Cause Act. Small Cause so and so Act. Yes.
35.
In this case, I appeal for respondent. The
Sorry, my
Honorable
lord.
Court.
I'm sorry,
as
much
per
time is taken for this matter, but Embatsara, I am there. My lords, I'm definitely there with my lord.
They have not deposited, my lord. Even after the order passed by the Honorable Court. 26.
Idu nimdena?
Idella.
People are suffering without their matters getting listed where there are very dangerous consequences are there.
ಏನಂದ್ರೆ ಎಲ್ಲದರಲ್ಲೂ ಹಿಂಗ್ ಆಗ್ಬಿಟ್ರೆ ಬ್ಯಾಂಕ್
ಆಯ್ತು ಏನ್ ವಿಲ್ ಸಿ ತೀರ್ಮಾನ ಮಾಡ ಇನ್ನೊಂದು 5 ವರ್ಷದಲ್ಲಿ ಮಾಡ ಎಸ್ ಸರ್
there are series of vehicles loan ಇದೆ ಮನೋಜ್ ಸರ್
ಇದ್ರಲ್ಲ
ಇಲ್ಲ ನಮ್ಮ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ everybody is sort of resorting to these type of tactics.
ಅವ್ರು ಹೋದ್ಮೇಲೆ ಮಾಡ್ತಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್
not on merits. Not definitely.
ಅಲ್ಲ ಅದು ಗೊತ್ತಾಯ್ತು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಆಗುತ್ತೆ. It's not the question of money. Quantum is not important, but there are very serious issues to be decided. Yes.
35, my lord.
Yes, sir.
This Honorable Court passed orders on 26/3/2024, directing the petitioner to deposit a sum of ₹40,000.
Not deposited?
Not deposited.
The learned counsel for the petitioners, this court on 26/3/2024 had passed the following order. The learned counsel for the petitioner, the respondent submits that not a rupee has been deposited pursuant to the said order. If there is no representation on behalf of the petitioner, in the event the deposit is not made by the next date of hearing, the petition would be dismissed for its non-compliance. List the matter on Wednesday in plenary hearing. That is the last chance. Wednesday, CRP Thursday.
How date?
Yes.
36.
36, I appear for the petitioners, my lord. I'm
going
to
to
VC.
Why?
My lord, I was before the Bombay High Court in Nagpur. Unfortunately, there are heavy rains here, so all the flights to Bangalore are rescheduled. Your lordship will recall this matter is where the trial court holds that 711 cannot be decided on the basis of pleadings. A 1991 suit, 1991 sale deed is sought to be challenged in the year 2023.
Granted, interim order is
There is
operating.
also interim order is there. Your lordship had indicated on the last date that this petition would be disposed. Your lordship will just have page 36.
No, it's all right. Let's the matter on
There is a-
24th interim order subsisting will continue to the next date. Next.
Right.
37.
The respondent, I have preferred the application to vacate the interim order, Lordship. Lordship, before the court.
You are the
below-
landlord,
I am the landlord, Your Lordship.
ಎಷ್ಟಿದೆ ಸರ್?
ಅಲ್ಲ ಇದರಲ್ಲಿ we were ex parte before the trial court. We filed a miscellaneous petition too.
That is
Give us
also
an op-
rejected.
That is rejected. That is why we are before this honorable court. Even in the petition.
I think arrears ಎಷ್ಟಿದೆ rent?
ಅಲ್ಲ ನಾವು ಅವ್ರ ಟೆನೆಂಟೇ ಅಲ್ಲ. There is
Tenant
no
ಅಲ್ವಾ?
no. There is no document produced by them.
Your Lordship.
ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಟೆನೆಂಟ್ ಇದ್ರಿ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೂ ಏನು
Yes,
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
sir. Then how was the suit decreed?
Not that is one of the strange things, my lord, because there is no document. ತಾವು exhibits ಅಲ್ಲೂ ನೋಡ್ಬೋದು. There is no document showing that.
How was
Notice
your
was also
tenant?
issued.
How was your tenant?
Your Lordship, there, the present petitioner before this court, father was the tenant and caretaker.
Agreement.
And caretaker.
Agreement.
It was long back, it was on the
However,
oral.
long back agreement.
No agreement is entered. Your Lordship may kindly appreciate.
Anything else, sir?
Your Lordship.
Oral tenancy.
Oral tenancy. Oral tenancy.
ಹಾಗಾದ್ರೆ oral arrears.
What has happened, Your Lordship, during.
Arrears oral ಅಂತ ತಗೊಂಬಿಡಿ.
It is of 50 years. The father of the present petitioner was staying in the small portion as a caretaker as well. Your Lordship, there.
ಏನ್ eviction suit ಹಾಕಿ?
Howdo? I have preferred the eviction petition before the court below. Their contention is that the notice is not duly served and the name of the petitioner.
ಅದೆಲ್ಲ ಇರ್ಲಿ, let's go to the root of the matter. Where is the agreement of tenancy?
Oral.
Yes.
It has been rightly appreciated by the trial court and it was allowed, HRC petition was allowed. Your Lordship.
Ex parte.
Howdo, ex parte. But on the strength, Your Lordship may
What
kindly.
strength? ಏನು strength ಇಲ್ಲ?
No, Your Lordship, what has happened, the postman has gone to the premises in question and he has dropped the intimation letter to come and collect the article, which they have failed to. In fact, Your Lordship may kindly appreciate they are not at all staying in the petition scheduled property.
ಟೆನೆನ್ಸಿನೇ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಯಾಕೆ ಇರ್ತಾರೆ?
La. But then what is the right there to hold on the premises with them only?
Your mercy. Your mercy.
Maria Mercy, my lord. That name is also wrong. My husband name is also wrong.
It is not disputed.
Entirely wrong.
Your Lordship, it is not disputed by anybody.
Correct.
The postman has properly gone to the scheduled premises.
So your whole case is built on postman.
No.
ಮತ್ತೆ?
Your Lordship, no, their contention is that I have taken the article in a wrong name and I have taken the ex parte order. It is their contention.
Correct.
It is not so, since though they may.
ಏನಾರು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ಟೆನೆನ್ಸಿಗೆ. On what document did the court decide?
Your Lordship may kindly appreciate which.
Where is the
respect to the, they have approached the police station at the time of evicting the premises in question and they have admitted that they are the tenant and they are paying to, I will furnish the exhibit, Your Lordship.
ಇದರಲ್ಲಿ judgment in OS 1313 of 95.
That
They
is-
produced a document saying that in that partition, I got this portion of the property.
ಅದು ಅವ್ರದ್ದಾಯ್ತು.
ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು ಅವ್ರು ಇನ್ನೇನು ಕೊಟ್ಟಿಲ್ಲ. Ejection suit ಅಲ್ಲ, this is a suit for eviction.
Your Lordship, their.
And in
their
fact,
own-
the trial court itself.
Their own
Page
document,
42
exhibit, they admitted before the police station that we are the tenant and we are paying a monthly rent of 2,800 rupees. Your Lordship may kindly appreciate at page.
50 ವರ್ಷದ ಕೆಳಗ.
ಅಲ್ಲಲ್ಲ, ಈಗ ಇತ್ತೀಚೆಗೆ ಅವರು it is their ground. They have admitted.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಒಂದು ನಿಮಿಷ. Exhibit R2
What
the-
is your name?
Maria Mercy.
Maria Marcia.
Maria Mercy,
Exhibit R2
ರಾಜು. ನಾನು ಅದಕ್ಕೆ ಆಧಾರ್ ಕಾರ್ಡ್ಸ್ ಎಲ್ಲವೂ ಕೊಟ್ಟಿದ್ದೇನೆ.
Wife of?
ರಾಜು.
ಹಸ್ಬೆಂಡ್ ಬೇರೆ ಇದಾರೆ.
ಹಸ್ಬೆಂಡ್ ನೇಮು ರಾಂಗ್ ಇದೆ.
ಅಲ್ಲ.
ನೀವು ಯಾರಿಗೆ ನಿಮ್ ಫಾದರ್ ಕೊಟ್ಟಿದ್ ಗೊತ್ತಿಲ್ವ ಯಾರಿಗೆ ಅಂತ?
No. What has happened? My husband,
Your husband?
during that point of time, had given the property as for the
Your husband?
father of the.
No, your husband at what point of time? Because you are yourself 87 years.
Yes, Your Lordship.
At what point of time ಕೊಟ್ಟಿದ್ರು?
That is way back 50 years. Your Lordship may kindly appreciate a suit came to be filed in the year 1985 for partition among the family members of the present
No
landlord.
problem. ಆಯ್ತು
In
ಮಾಡ್ಕೊಳ್ಳಿ.
that one also, since he is in the occupation, the father of the present petitioner was in the occupation, he has arrived as a necessary party in that suit itself, 1985.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
ಎಂಟ್ರಿ ಮಾಡಿದೆ.
ಇದೆ ಹೋಗ್ಬೇಕಷ್ಟೇ. ಎಸ್.
Like Your Lordship may kindly appreciate exhibit R2 complaint given by me to the police station. Idralli R2 they have categorically accepted that we are the tenant and that so and so.
ಎಲ್ಲಿ ತೋರ್ಸಿ.
Swami.
ಅದ್ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಅದು ಅವ್ರು ಹೇಳ್ತಿರೋದು subsequent to decree. That is when I filed miscellaneous. When he filed a complaint, I said I am not.
Subsequent to decree ಅಂದ್ರೆ were you in possession of the property?
Yes. ಅಲ್ಲ ಈ ಡಿಗ್ರಿ ಆಗ್ಬೇಕಾದ್ರೂ I am continuing in the possession of the property.
How?
Because I am ಈ property belongs to some.
So ex parte ಅಂತ ಕಳ್ಸೋಣ ಅಷ್ಟೇ.
Yes. Ex parte, and in fact court observes there is no document to substantiate that you are the tenant ಅನ್ನೋದಿಲ್ಲ, because we are ex parte.
Court has not observed. In fact, the court has appreciated exhibit R2.
Let him be heard in the matter. Yes.
Your Lordship. It is not that.
ಒಂದು 5 years ಬಿಟ್ಟು ಪೋಸ್ಟ್ ಮಾಡೋಣ.
With time limit, kindly it may be.
Yes. The petitioner is before this court calling in question twin orders. One, the decree in so and so, and rejection of an appeal in miscellaneous appeal so and so. The petitioner is said to be the tenant in the premises owned by the respondent. There is no document of tenancy produced before the court, before the concerned court, or before this court. The learned counsel for the respondent submits that the tenancy sprang from oral agreement between the father of the husband of the respondent and the father of the petitioner. The learned counsel for the petitioner submits that he is in possession of the said premises and no notice was ever served upon him. The learned counsel for the respondent would now submit that the postman had reached the doors of the petitioner and had dropped the article which the petitioner acknowledges in his evidence. Therefore, it is not a case where the proceedings are held ex parte against the petitioner. The perusal at the order would indicate that no notice was served upon the petitioner and the petitioner was not made aware of the proceedings. He comes to know of it only after the decree is passed and the execution of the decree comes about. It is then he prefers a miscellaneous appeal seeking recall of the order. The said order on the face of it is erroneously rejected by the concerned court, as admittedly the decree that is passed is ex parte. In that light, I deem it appropriate to grant an opportunity to the petitioner to put up his defense before the concerned court, as more so in the light of the fact that there is no document of tenancy that is placed before the concerned court by the respondent. In that light, for the aforesaid reasons, following order allowed, quashed, both the orders quashed. Listen, the matter is remitted back to the hands of the small causes court so and so to consider the matter afresh. Since the issue is now 2 decades old, more than 2 decades old, the concerned courts will endeavor to conclude the proceedings within 4 months from the date of receipt of the copy of this order.
Petition ಹಾಕಿರೋದು ಇವಾಗ 2 decades ಅಲ್ಲ, ಅವ್ರು ಸೂಟ್ ಹಾಕೊಂಡಿರೋದು. ಈ ಕೇಸ್ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. HRC is of 22.
In the light of the issue being of the year 2022, the concerned court shall endeavor to our ವಯಸ್ಸು 90 ಆಗಿದೆ ಆಗ್ಲೇ.
ಅವ್ರು ಬರ್ತಿಲ್ಲ, ಅವ್ರ ಮಗ ಬರ್ತಿದ್ದಾರೆ ಸರ್.
Sorry.
Son is-
Concerned court shall endeavor to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order.
One submission, Your Lordship. They are not at all in the possession of the property.
ಅವರೇ ಹೇಳಿದ್ ನಾನು ಹೇಳಿದ್ದೀನಿ ಅಷ್ಟೇ. Yes.
My submission may kindly be recorded. They are not at all in
You
the.
don't have a tenancy, you say they are not in possession.
They are, what has,
Possession ಇಲ್ಲ ಅಂದ್ರೆ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ?
they are elsewhere, keeping the,
ಯಾಕೆ
keeping the
suit ಯಾಕೆ
lock, keeping the lock and key.
Oh, lock and key.
Yes.
All right, sir. Yes, sir. Next.
38,
Your Lordship has directed me to file an affidavit.
hearing for the respondent.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ?
9 ತಿಂಗಳು ತಾವ್ ಹೇಳಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್.
9 months. Yes, madam.
My lord, ಕೆಲವೊಂದು ಪಾಯಿಂಟ್ಸ್ ನಾವು ಆಡ್ ಮಾಡ್ಬೇಕು.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಂದ್ರೆ
ಕೇಳಿದೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಅದು ನಾನು ಅದನ್ನೇ ಕೇಳಿದೆ ಮೊನ್ನೆ.
ಇಲ್ಲೇ
my
ಹೇಳ್ಬಿಡ್ತೀನಿ.
lord, ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್ ನ ಅವರು ಅರಿಯರ್ಸ್ ಅಲ್ಲಿ ಸೆಟ್ ಆಫ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಅದನ್ನ ಅವರು they can't ask for refund and they have to make good for the damages while vacating the premises and for also pay the painting charges.
ಆಯ್ತು. Paint.
Yes, my
Correct,
lord, nowadays like
All right, yes.
and the proportional cost which the
So charges for natural wear and tear.
and proportional cost which the lower court has been decreed, that also they have to pay, my lord, and they have to make no default in paying the rent.
ಆಯ್ತು, ನೀವು
for
ಒಂದು
the-
ಹಾಕ್ಬಿಡಿ ಏನ್ ಬೇಕು ಅಂತ. ನಾಳೆ ತಗೊಂತೀನಿ.
ನಾಳೆ.
ನಾಳೆ ಕ್ಲೋಸ್ ಮಾಡಿ.
Please, my lord, grateful.
ಹಾಕ್ತೀನಿ ಅದನ್ನ ಬೇಕಿತ್ತು ತಾವ್ ಹೇಳಿದ್ರೆ ನಾ ಹಾಕೋಣ ಅದಕ್ಕೇನು.
ಬರ್ಲಿ, ನಿಮ್ದು ಹಂಗ್ ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇದೆ, ಅವ್ರದ್ದು ಹಂಗೆ ಮಾಡಿ.
ಎಂಟ್ರಿ ಮಾಡು.
Entry order subsisting will continue to the next date of hearing. Place tomorrow.
Sir, appearing for petitioner, my lord.
Unserved respondent 3.
Take steps for R3, my lord. R3 steps.
ಏನ್ entry order ಇದೆಯಾ?
ಇಲ್ಲ.
ಇಲ್ಲ. Learned counsel seeks 2 weeks time to do the needful. List the matter after 2 weeks. Needful be done by then. Next.
40.
I am for the respondent, my lord.
The petitioner. Request for a passover, my lord.
ಯಾಕೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತಾ ಇದ್ದೀನಿ?
ಇಲ್ಲ ಬರ್ತಾ ಇದೆ. My lord, senior is. Sorry.
ಪಾಸ್ ಓವರ್ ಬೇಕಾ?
ಇಲ್ಲ.
I'm sorry.
Maintainability.
No, I'm told, my lord, earlier, my lord, the honorable court overruled that objection.
Overruled.
I have heard objections.
ನೀವು ಹೇಳಿದ್ರಲ್ಲ overrule ಮಾಡಿದ್ದಾರೆ. First time when it had come up, I'm told.
Now what has happened to this?
No, my lord, this is a
711 application?
Yes. No, this is a no, suit filed under section 6 of the Specific Relief Act for eviction on the ground that we have been dispossessed. There was an agreement to sale with the defendant under which, my lord, possession was never given. She only wanted to do some puja and she asked for some temporarily wanted to see the place. And after that, my lord, she dispossessed me. Therefore, suit is filed. Now, my lords, the trial court dismisses the suit only on the ground that she has filed another suit for specific performance of that contract.
Yes. Respondent.
I have filed my objections, my lord.
Already
In this
filed.
case, I have produced the decisions of the Supreme Court also. This is not maintainable under section 115 of the
That's the
CPC.
Sorry,
my
I will
lord.
never- there is no order
No, I am told, my lord,
overruling maintainability.
I am told, my lord, there was an order which was passed.
I have not seen it.
1712.
1712. 1712 office objections overruled, not qua maintainability.
Adರಲ್ಲಿ one of the objections was that.
Not by the coordinate bench.
It was not raised.
No, this cuts at the root of the matter. That can't be
Correct, no,
overruled.
correct,
like
no,
that.
that's what, my lord, no appeal is provided, my lord. If lordships permit me, my lord, then I'll just examine what are the
Just
judgments
look
which
at
my
it
learned
and
friend is
get-
relying upon. I don't know, my lord.
There are so many judgments, yes.
I'm not
Putilo, copy?
supplying copy.
Counsel for the, counsel for the respondent to serve the list of authorities that he has placed on record to the counsel appearing for the petitioner, heard, learned senior counsel Madi, and we'll have it on 24th, list on 24th. Yes, next.
41.
I represent appellate in smart case.
Suit for partition in smart case.
My submission. Suit for
Partition.
partition.
Partition 711.
ಹೌದು.
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಸೈಟೇಷನ್ ಇದ್ರೆ ಕೊಡಿ ಅಂತ ತಾವ್ ಹೇಳಿದ್ರಿ ಸರ್.
ಅದೇ ಏನು ಇಲ್ಲ ಬಿಡಿ.
ಅದು ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಸರ್.
Yes, sir. Anything else, sir?
Yes. Lord, find some documents, please.
Documents illa, sir. 711 and partition I will not permit it.
My humble submission, there is already partition in the, my humble submission. There is already partition in the family. Way back in the 1970, back in the 1968. The revenue records is affected, the partition. Humble submission or writing citation one.
Citation, kodi sir. ಅದು ಕೊಡಿ ಮೇಡಮ್, ಅದು ಕೊಡಿ. Yes, sir. Registered partition did ಬೇಕು ಅಂತ ನಾನು ಹೇಳಲಿಲ್ಲ. Who said?
Partition ಆಗಿ revenue entry ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
Oral partition permissible. That doesn't mean that 711
ಪಾರ್ಟಿಷನ್ ಆಗೋಗ್ಬಿಟ್ಟು ಅದನ್ನ ಅರ್ಲಿಯರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ 70 ವರ್ಷ ಆದ್ಮೇಲೆ 70 years ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ. ಇವ್ರು ಕೇಳ್ತಾ ಇರೋದು ನಮ್ಮ ದೊಡ್ಡಪ್ಪನ ಅಪ್ಪನ ಅಣ್ಣನ ಮಕ್ಕಳು ಕೇಳ್ತಾ ಇದ್ರು ಪಾರ್ಟಿ.
ಕರೆಕ್ಟ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್.
ನಮ್ ದೊಡ್ಡಪ್ಪನ ಹೆಸರಿಗೆ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ, ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಾಗಿದೆ. 70s ಆದ್ಮೇಲೆ ಪಾರ್ಟಿಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಪಾರ್ಟಿಷನ್ ಅದೇ ಐಲಾರ್ ಅಲ್ಲಿ ಬೇರೆಯವರೆಲ್ಲ ಪಾರ್ಟೀಸ್ ಇದೆ, ಅವ್ನು ಪಾರ್ಟಿನೂ ಮಾಡಿಲ್ಲ, ರೆವೆನ್ಯೂ ಎಂಟು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಡಿಫೆಂಡ್ ನಂಬರ್ 18 ಯಾರು?
Sister of the defendant number
15, 16, 17. Defendant number 18
is the sister to the petitioners here in this case. I mean, defendant evidence post agide there in the trial court. Defendant evidence post.
I am not going to. Last time I ಹೇಳಿದೆ.
Madam.
711 in partition I will not.
In the partition.
My point is just that.
7 to 11
will not be applicable.
There the judgment.
There is already partition in the family. The revenue is affected. Revenue is affected. The presumption that is a partition in the family. Repartition are permissible is my case.
No, nothing. 711 will not partition suits or 711 anyway. It's evidence. It may be rejected also. Suit may be dismissed. Who knows?
Instead of doing evidences, they come up before this honorable court.
ಏನು ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ
ಅದರ್ ಸೈಡ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಅವ್ರು ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕು.
ಯಾರಿಗೆ? ನಾನು ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಮಾತ್ರ ನೋಟಿಸ್ ಬೇಕಾಗಿರೋದು, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಬೇಕಾಗಿಲ್ಲ. Yes.
My point is earlier there is a partition in the family.
That treated in evidence, sir. 711 ಬರಲ್ಲ. Rejection of a plaint in a partition.
Question of law is already partition in the family. Repartition are permissible under law. This is my question of.
Rejection of plaint ಬರಲ್ಲ.
Please.
You may get the suit dismissed by evidence. That's a different thing.
Please.
The petitioner is before this court calling in question an order dated 4th December 2024 passed by the concerned court rejecting the application of the petitioner filed under Order 7 Rule 11 CPC seeking rejection of the plaint. The petitioner heard words. The petitioners are the defendants. The respondents 1 to 3. The first respondent, the plaintiff. The plaintiff institutes a suit in OS 121 of 2018 against whom?
Defendant number 15 to 17.
Against the present petitioners, defendants 15, 16 and 17, seeking partition and separate possession and consequential reliefs. The defendant number 4 to 14 in the said suit filed written statements. Defendant number 15 and 18 also file their written statements and a counterclaim. It transpires that a compromise decree compromise entered into between ಯಾವುದು 177 ಯಾವುದು?
Defendant number 15 to 18.
A compromise is entered into in OS 177 of 2010 on 20th March 2010, not between the present plaintiff and the petitioners, but between others. The present plaintiff was admittedly not a party to the said suit nor a party to the said compromise. The petitioner then prefers an application under Order 7 Rule 11 A and D seeking rejection of the plaint. The present defendant number 18 files objections to the said application. Considering the application, considering the application and the plaint averment, the petition, the application comes to be rejected. The rejection of the application is on the following reasons. The concerned court observes that the matter is at the stage of evidence and the present defendant number 18 was not a party to the compromise decree arrived at between the parties therein in the year 2010, and also considers the fact that there is the partition was partition between whom?
Respondent number 1B and C.
The your old partition.
Old partition.
15 to 18.
15 to 18.
And also considers the fact that there is already a partition between respondents 50, defendants 15 to 18, and negatives the plea, negatives the plea on the score that there cannot be an application seeking rejection of a plaint in a partition suit. I do not find any error apparent or perversity in the order so passed by the concerned court for this court to exercise jurisdiction, revisional jurisdiction, and obliterate the order passed by the concerned court and allow the application which would result in rejection of the plaintiff.
Ma'am, sufficient. In the written statement, or dispute the relationship with the.
Adella Almadi, so and so. In the light of the aforesaid reasons, the petition lacking in merit stands rejected. All contentions of both the parties are permitted to be urged before the concerned court at the appropriate stage. Ordered.
42.
For petitioner. 42. I'm for petitioner.
ಆಮೇಲೆ ಎರಡು ಸರಿ ಆಯ್ತದೆ.
ಇಲ್ಲ ಅವ್ರು ಬರ್ತದೆ ನಾನ್ ಪಿಟಿಷನರ್ ಅಂತ. Plaintiff's petition, my lords. Order 9, Rule 13. Coordinate bench raised maintainability, my lords. On 29(1). Civil revision petition.
Petition advocate have served so and so. Serve ಮಾಡಿದೀರಾ?
ಮಾಡಿ acknowledgement file ಮಾಡಿದೀನಿ.
Why ex parte?
My lords, notice has been not served thereafter under Rule 6. Substitute
miscellaneous ಹಾಕ್ಲಿಲ್ವಾ?
Miscellaneous petition ಹಾಕಿದ್ದಾರೆ. That application is allowed by the trial court.
Yeah.
That order under challenge, my lords, by the plaintiff.
You have challenged that is.
Only on limited ground, my lords, on limitation point, my lords.
ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರು?
11 months.
11 years.
11 months. My contention is this, my lords. Application filed by the defendant under Order 9, Rule 13 hit by the Section 3 of the Limitation Act, my lords. Kindly.
What is the limitation?
30 days, as per Article 123, my lord, 30 days from the date of knowledge. As per petition application averment.
Section 5 not applicable.
Article 123 of Limitation Act, my lords.
We'll see. Let's tomorrow in preliminary hearing.
Petition, Lord. Only 2 weeks time we can.
Interim order not compliant.
Let me kindly. 2 weeks time he has deposited 50%, my lord. On 15/4/2020.
I have already passed an order.
Please, my lord, but
this court on 12/6/2025 had passed the following order. The learned counsel for the respondent submits that the order has not been complied with by deposit of amount ಎಷ್ಟು? Deposit of
25,000 deposit.
25,000.
No, my lord. We have deposited, my lord, 50,000 in one case, my lord, first case.
One
In another
minute,
case,
where
my
is
lord,
the
we have-
order directing deposit?
At the time of execution, my lord, we have paid, my lord. Attachment of the movables, my lord. When the bailiff came near to the petitioner's house, my lord, at that time we have paid, my lord.
Would clear the entire amount. ಎಷ್ಟು the entire amount?
1,64,000.
The learned counsel for the respondent submits that not a rupee has been paid pursuant to the order dated 12/6/2025. In that light, the interim order stands vacated. The petitioner is at liberty to comply with the order and then move, and then seek restoration of the interim order.
Petition, my lord.
Yes,
My lord,
next.
one opportunity may be given, my lord, because, my lord, 50% we have
opportunity.
already paid, my lord.
No, sir. Next.
44.
Same, my lord, respondent.
Same order. Next.
45.
Appeal for the respondent number 3 to 8, Lordship. Lordship, I have filed a vacating interim order.
ಎಲ್ಲಿದೆ vacating?
Objection. Interim order vacating.
ಹಾಕಿದ್ದೀರಾ?
ಹೌದು. This is the fifth round of litigation in this matter, Lordship. In year 2014 to till date, this institution is under dispute, Lordship, between two managing committees. Kindly appreciate my statement of objection, Lordship. There are three WAF tribunal orders regarding the conducting election to the said WAF institution, Lordship.
Yes, sir.
Milord, this
So
facts
what
are-
has happened is, Milord, the learned tribunal has passed the impugned order dated 27/1/2020.
Page.
Your Lordship would find at page number 33, Milord.
Yes.
There in your Lordship.
Application documents ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ, Lordship. Objection.
The registry is directed to put up the objections and the application seeking vacation of the interim order said to have been filed by the respondent by the next date, list on Tuesday.
Please,
Yes. Interim order subsisting will continue to the next date, Tuesday, 15th. List interim order subsisting will continue
Your
to the
Lordship may
next,
have it on 16th.
or 18th, yes.
Please, Milord.
46. Appealing to petition, my lord. We have got the NOC. Next date we'll file the wakalat.
Learned counsel for the petitioner seeks 2 weeks time. List the matter for 2 weeks. Next.
47.
I appeal for the respondent number 1 to 4, my lord. Week's time may be granted, my lord. Some documents are produced, my lord. 1 week time.
Learned counsel for the interim order there.
Interim order, it may be extended.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. Objections, if any, in the next 2 weeks. Interim order subsisting would continue to the next date. Heard is senior counsel and Thaki. Next, yes. Next.
48.
Respondent.
251 days delay.
My lord, I am for the petitioner. My lord, the delay in account of the petitioner was sick for, she was bedridden for more than 8 months. And maybe within
We'll
4 5
condone the
days.
delay. Yes.
Within 4 5 days of filing of the CRP, she died also, my lord.
For the reasons indicated in the affidavit accompanying the application being satisfied with the same, the delay of, so, estidu 251 days, 251 days stands condoned more so in the light of the fact that the learned counsel for the respondent has not objected to the condonation of the delay.
Yes. My lord, this suit for partition, my lord. The plaintiff.
11 rejected,
My lord,
What's the?
the suit for partition. My lord, the plaintiff, after our examination chief, she filed the memo for dismissal of the suit as not pressed for. My lord,
Not pressed, as not pressed.
As not pressed for.
Where is it?
My lord, memo.
Order on the memo is at page 16.
Page at 35, my lord. Memo is at page 35, my lord.
Order on memo ಯಾವ್ದಿದು? Page 16 ಅಲ್ಲಿ. Memo is dismissed.
35.
Dismissed as withdrawn.
Memo filed by the plaintiff to dismiss the suit as not pressed for. My lord, at the outset, the plaintiff only submit that she is aged 87 years, unable to walk, and her health issues also does not permit to prosecute the case. Secondly, the suit is filed without her knowledge that there was already a partition.
ಈಗೇನಾಗಿದೆ?
My lord.
Now what has happened?
My lord, the trial court, my lord, out of 32 parties, my lord, 30 parties given the no objection to dismiss the suit. My lord,
ಎಲ್ಲರಿಗೂ 87 ವರ್ಷನ? 30 defendants gave no
32,
objection to dismiss the suit.
Including the LRs, including the
All right.
16 defendants,
All right.
including the LR.
Suit is OS 8121 of 2012.
2012. My lord, the first defendant, out of 7 LRs, 5 LRs have also given the no objection to dismiss the suit. My lord, the 2 LRs, that is the respondents hearing, my lord, they objected, they said they were going to contest the matter. My lord, the background of the case is that, my lord,
What happened after that?
My lord, the trial court
dismissed my memo and said, let the
Dismiss your memo. What memo was that?
memo for dismissal of the suit.
ಇಬ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ, ಅದೇನ್ ತಪ್ಪು?
ಅಲ್ಲ, ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಅಂತಾರೆ ಸ್ವಾಮಿ. ಇವಾಗ ಏನಾಗಿದೆ, the suit is filed on my behalf. My lord, I have taken the moral responsibility to see that it is dismissed. 32 parties, they are all my own kith and kin. And my lord, this absolutely has no right, because the return statement was not filed by her for more than 6.5 years, the first defendant. Thereafter, these LRs came on record. They did not file.
First defendant is Shardamma.
Shardamma. Shardamma entered appeals in 2012. Filed the wakalat.
Suit
Did
is
not
for
file the
Partition.
partition.
No, why Shardamma may contest it?
Sorry?
Shardamma will contest it. Wherever not, how can you force someone to withdraw the suit?
No, I am withdrawing myself. I am withdrawing.
You are withdrawing it yourself.
Yes. A plaintiff is withdrawing the suit.
Plaintiff withdrawing the suit.
Plaintiff withdrawing the
yes.
suit. My lord, out of 7 LRs of the first defendant, 5 LRs have also given no objection for dismissal of the suit. These two, this respondent, my lord, they said they are going to contest, they will not agree for dismissal of the suit. My lord, the background of the case, my lord, and the impugned order is passed relying upon the ruling of this honorable court. That ruling is not at all applicable because the glaring distinctions, my lord, both on the fact.
Gauramma's case.
Gauramma's case. Gauramma's case. And also, my lord, there is a glaring distinction between that ruling and the facts of this case. My lord, there it was the original defendant who objected, and moreover he had filed the return statement in the initial stages. Therefore, the honorable court said, because having waited for 10 years, let it go. Here it is not the original defendant; it is the LRs of the defendant, and the other LRs have also given the no objection. My lord, this will now, he has filed the application.
Difficult.
Sorry?
We'll continue at 2:30. Yes.
August.
Number submission, my lord. List number 1, serial number 58, my lord.
Karbidi, madam.
Page-wise agenda.
50?
8, my lord.
Wait. Page wise will call.
Page 12, 49 to 50, 55.
Petition, my lord. I have filed an IA for conversion, my lord. It has not been put up.
Tag this petition along with?
No, my lord. Already connected with petition, my lord.
In the connected.
Connected matter, my lord. I filed an
Then we'll pass some order. Wait. Yes. Next.
Page 13, 56 to 60.
58, my lord. For the petitioner, my lord, I seek adjournment, my lord.
Pradeep Kumar Ghelidi. At the request, 14 matter.
58, my lord.
58.
Skyline versus
2014. 58. Which list, sir?
List 1, sir.
List 1. 58 is not that.
WP 6936 of 23.
It's 2014 matter. Yes. Nodkomband heli. Next.
Page 57.
Pray for time.
57.
Court of pray for time and proxy counsel.
The request to the counsel representing the petitioners list the matter after 2 weeks. Respondent list the matter 2 weeks. Interim order, continue order. Next.
Page 14, 61 to 65. Page 15, 66 to 69. Page 16, 70 to 74. Page 17, 75 to 81.
77, my lord. Rejoinder file not ready.
77.
77.
Counsel for the petitioner seeks 2 weeks time to file a rejoinder statement to the statement of objection so filed. List the matter on 24th. Rejoinder if any by then.
25th, my lord.
79.
24th. Yes. Next.
Serial number 79, your lords. Sina is out of town, so kindly can the matter
Serial
be
number
listed on
79.
Monday?
List the matter on Tuesday, madam.
Tuesday. Much okay.
We'll take it on 15th. List the matter on 15th. Because it
Apologies,
is for
ma'am.
consideration of interim prior. Yes.
Apologies, my lord. List 2, serial number 58.
Wait, sir.
Yes.
Yes.
My lords, can it be under preliminary hearing, my lords? Serial number
It will be
79.
listed, yes, 15th, yes. List the matter and preliminary hearing on 15th. Consideration of interim prayer. 80,
Page 18, 82 to 84, page 19, 86 to 89, 85 to 89, page 20, list number 2, page 6, 30 and 31, page 7, 32 to 38, page 8, 39 to 45, page 9, 46 to 52, page 10, 53 to 56, page 11, 57 to 61.
58, my lord.
Hmm.
WP 6936 of
Yes.
23.
Hmm.
Short adjournment, my lord. Interim order is already there.
You are for the respondent.
No, my lord. Petition.
But the interim order is already there, Andre?
It's there, my lord. Like it may be extended, my lord.
The learned counsel for the petitioner seeks weeks. Respondent ಕೇಳಿದಿರಾ?
No, my lord. they are
6,
not
2 weeks time, list the matter on 25th. Or in the event he comes, I'll take up the matter. Or object ಮಾಡಿದ್ರೆ I'll take up the matter.
My lord, 25th it will be taken up. My lord.
25th it will be taken up, but
Final
if he
hearing also
objects
there.
for adjournment, then I'll definitely
Well,
take it
senior,
up.
I'll inform them.
Yes, inform ಮಾಡಬೇಕು ಅಂತ ಅಷ್ಟೇ. Yes.
Page 12, 62 to 70, page 13, 71 to 73, page 14, 74 to 77, page 15, 78 to 83, page 16, 84 to 88, page 17, 89 to 95, page 18, 96 to 101.
98, my lord, and for the respondent, 1 week.
At the request of the counsel appearing for the respondent, list the matter on 25th. Yes.
99, after the petition,
Hmm.
I have already filed the application for implementing the application. Tell us on the record.
Hmm.
And I need the time.
6, at the request of the counsel for the petitioner, list after 2 weeks. Yes.
Maybe direct the office to put up the application.
Applications pending in the registry concerning the subject petition be put up on the next date, next. Yeah, ಅದಾಗತ್ತೆ.
Page 19, 102.
Yes.
Minutes. List 1, serial number 7 minutes. May I request the last date in the 25th of this month.
List 1?
Serial number 7 minutes.
ಏನಾಯ್ತು?
He is avoiding service. I'll take out hand summons.
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. Petitioner is permitted to serve on the respondent by way of hand summons.
Great. Last week of July minutes. 25th.
Hand summons. List the matter on 24th.
Grateful.
Is the lordship permission? Act of disposition is required. What happens is, property is in court. A suit is filed in Bangalore City Civil Court and obtain injunction not to interfere. And the court has granted injunction. On the basis of injunction, they are trying to dispose of the property.
ನೋಡಿ, ಅದು FR ಆದ್ರೆ ಬರಲ್ಲ.
ಈಗ ಬೆಳಗ್ಗೆ ಹಾಕಿದ್ದೀನಿ ಅರ್ಜಿ.
ಕಂಪ್ಲೈ ಮಾಡಿ. WP ಕೊಡಿ, ಆಮೇಲೆ ಬರುತ್ತೆ.
ಸರಿ, ಎಲ್ಲೇ ಇದೆ.
Someone took time.
My lord, I am present here only, my lord. I just informed him, your lordship told me to inform the opposite lawyer, I informed.
See, I knew he would object it.
Yes, my lord. That's why, my lord, like, we are
I
ready
posted
to.
it for 25th. We'll post it on 18th. Yes.
Much more.
Okay.
ನಾನು ಅದು ಬರ್ಲಿಲ್ಲ. I was here only. It is
49. ಯಾವ ಲಿಸ್ಟ್
14,
ಮೇಡಮ್?
14. List 1, serial number 14.
14.
14. Can I request your lordships to fix any date, my lords?
ಅದು ಸೈನು ಮಾಡ್ಬಿಟ್ಟೇನೋ ಒಂದು ನಿಮಿಷ.
2 weeks to file objections ಅಂತ ಮಾಡಿದಿರ ತಾವು. Objection ನಾನು ಹಾಕಾಗಿದೆ. ಅವ್ರ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರ
ಬೇರೆ ಯಾರೋ ಕೇಳ.
ನಾನು ಬರ್ಲೇ ಇಲ್ಲ, ನಾನು ಅಲ್ಲೇ ಇದ್ದೆ.
ರಾಜ್ ಪ್ರಭು ಯಾರೋ ಕೇಳಿ.
ನಾನು ಬರ್ಲೇ ಇಲ್ಲ, ನಾನು ಅಲ್ಲೇ ಇದ್ದೆ. ರಾಜ್ ಪ್ರಭು ಇಸ್ ಫಾರ್ ದ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್, ಅವ್ರ ಬ್ರದರ್ ಸಿಸ್ಟರ್. ನಾನು ಬರ್ಲೇ ಇಲ್ಲ.
ಆಕ್ಸಿಡೆಂಟ್ ಅಂದ್ರು.
ಎನಿ ಡೇಟ್ 2 weeks ಗೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಸಾಕು. ನಾನು
25th 4th ಏನೋ ಹಾಕಿರ್ಬೇಕು.
ಹಾಕಿಲ್ಲ, ಡೇಟ್ ಇಲ್ಲ.
24th.
Great. I'm really sorry, my lord.
One submission, serial number 60, my lords.
60.
60, my lords.
2014 land acquisition.
My lords, some personal medical emergency, I need to go, my lords. Can you have it on Monday, my lords, and preliminary hearing, my lords?
14 preliminary hearing, madam. 60.
60, my lords. Preliminary hearing.
Yes.
Grateful, my lords.
Preliminary hearing alla.
My lords, the issue, we have just filed an application only for the determined, only for the
compensation.
Compensation, my lords. My lords, please, my lords.
It will come on
preliminary hearing, my lords.
18th.
Preliminary 14th.
14 matter.
At least 18th preliminary hearing.
Rule issue agilla andre it will come in preliminary hearing.
Preliminary hearing, my lords.
Rule issue agilla andre.
My lords, previously my lords have directed and it had come. Then thereafter.
Rule issue agilla andre it will come. Yes.
No, please.
ಇಲ್ಲ
ಬಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಇದೆ, ಆಗ್ಲಿಕ್ಕಿಲ್ಲ.
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು, ಬಿ ಗ್ರೂಪ್. ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. ಸೀರಿಯಲ್ ನಂಬರ್ 31 as well, my lords. In list 2. ಏನ್ ಬೇಕು? My lords, I'm just supporting, I mean, one of the main contesting respondent, the DCA and the
Union, my lords. This is pertaining to the dental
Adu,
college.
you want time, is it?
My lords,
Illa
tomorrow
idare.
at least, sir. My lords, I have some medical emergency, that's the
Well, in this
reason.
case,
Tomorrow
my
or.
lord, only I am only requesting, my lord, we'll submit a compliance report to the DCI. Let the
I'll
DCI.
pass
My
an
lords,
order.
I appear for respondent number 1. This is a
Yes.
matter where, my lords, the report is on record. I had suggested that if my,
No,
if
let-
your lordships are,
Let them file their compliance.
Compliance report.
my
will
lords,
go-
my only difficulty for that, my lords, is that compliance cannot be filed here before the court. It has to be
Not
before the
court.
DCI.
Not before the court, before the DCI.
Please, my lords, in terms
My
of
lords,
section
in which
16,
event
it
the
will get
matter may be
disposed of.
disposed, giving them an opportunity, giving the DCI an opportunity to proceed in accordance with law.
We'll pass an order, wait. Let the matter be
Very
called.
well. Very well.
Serial number
Case
74
are
is
not
the
there.
list.
Don't
Appear
worry,
through
madam.
VC.
Don't appear at all.
Yes.
We'll mark your presence, not absence. Yes.
Serial number 74 is
You
the
know.
second list. Street light matter, my lord.
Sir, one ನಿಮಿಷ.
Serial number 91 in list number 1. ಅದು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆ 372.
ಏನ್ ಮಾಡುವ?
ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡೈಡ್ ಟು ಫೈಲ್ ಎ ಮೆಮೋ ವಿತ್ ದಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ರೆಡಿ ಇದೆ, ಸ್ಟಿಚ್ ಮಾಡಿ ಆಫೀಸ್ ನಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಹಾಕ್ಬಿಡಿ. ಯಾವಾಗ ತಗೊಳ್ಳಿ? ಯಾವಾಗ ತಗೊಳ್ಳಿ?
ತೀರೋಗಿರೋದ
ಅಲ್ಲ, ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ ತಗೊಳ್ಳಿ?
ನಿಮ್ ಇಷ್ಟ, ತಮ್ಮ ಇಷ್ಟ.
ಹಾಗೆ ಆಯ್ತು, ಮುಂದಿನ ವಾರ 18ಕ್ಕೆ ಆಗ್ಬೋದಾ?
ಆಯ್ತು, ಇದು ಸತ್ತೋದ್ಮೇಲೆ ಅವ್ರು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
ನೀವೇನೇನ್ ಹಾಕ್ಬೇಕೆಲ್ಲ ಹಾಕಿ.
ನಾನಲ್ಲ, ಅವ್ರು ಹಾಕ್ಬೇಕು.
ರೆಸ್ಪಾಂಡೆಂಟ್
ನಾನು
ಪೆಟಿಷನರ್. ಆಲ್ ರೈಟ್. ಎಲ್ಲಿ
Petitioner ಹಾಕ್ಬೇಕು.
ಪ್ರದೀಪ್ ಸಾವ್ಕರ್, ಕಮಲಾಚರಣ್ ಮಸ್ಟ್ ಬಿ ಹಿಯರ್.
ಇಲ್ಲ, ನಾನು ಆಲ್ರೆಡಿ ವಿಚಾರಣೆ ಮಾಡಿದೆ, ಇಷ್ಟು ಜನರಲ್ಲಿ ಇಲ್ಲ ಅವರು.
ಓ, ಇಲ್ಲಿ ಯಾರು ಅಲ್ಲಿಲ್ವಾ?
ಇಲ್ಲ,
ಅನ್ಐಡೆಂಟಿಫೈಯಬಲ್.
ತಾವು ಬರ್ಬೇಕಾದ್ರೆ ಒಂದು ತಪ್ಪು ಮಾಡಿದೆ. ಏನು ಅಂದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಇದು 372 ಅಂತ ಕೂಗಿದೆ ಇಲ್ಲಿ ನಾನು.
ಓ, ನೀವೇ ಕೂಗ್ಬಿಟ್ರ? ಸರಿ, ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಪರ್ಮಿಷನ್
ಆಯ್ತು, ನೀವೇ ಕೂಗಿದ್ಮೇಲೆ ನಾವೇನ್ ಕೂಗಂಗೆ ಇಲ್ಲ.
ಇಲ್ಲ ಅಂತ ಗೊತ್ತಾಯ್ತು.
ಗೊತ್ತಾಯ್ತು.
ನೀವು ಹಂಗೆ ತಗೊಳ್ಳೋದು.
ಆಯ್ತು ಸರ್, ನಾವು 18ಕ್ಕೆ
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಫೈಲ್ ಮಾಡಿ.
ಆಯ್ತು, 18ಕ್ಕೆ ತಗೊಳ್ಳುವ.
ಆಯ್ತು.
ಎಸ್.
List to serial number 70, my lord. It's in B group, my lord. Some urgency, my lord. There's an order passed against me. But my lord, my submission would be, my lord, try.
ಸಮ್ ಅರ್ಜೆನ್ಸಿ ಅನ್ಬಿಟ್ಟು ಈಗಲೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ.
No, my
ಏನ್
lord.
ಹೇಳಿ?
My only submission is, my lord, your lordships have granted them an ex parte order, may be sent back to the learned trial court. My lord, trial court can decide. Order can be continued, my lord, without being influenced by these observations.
Let me take it. You are for the petitioner in that?
I appear for the
Wait.
petition.
Before EOD, we'll do it.
74 malad in the second list.
ಗೊತ್ತಾಯ್ತು.
ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ಅದು ರೂಲ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ, ತಗೊಂಡು ಹೋಗಿ ಬಾಟಮ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ.
ಹೌದು ಸರ್.
ಆಯ್ತು ಸರಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್. ಎಸ್.
ಇಲ್ಲೇ ಇದ್ರೆ ಇವತ್ತು ತುಂಬಾ ವರ್ಕ್ ಇದ್ರೆ ನಾಳೆಗೆ ಹಾಕೊಂಡು ಟಾಪ್ ಅಪ್.
ಇವತ್ತು ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆಗೆ ಹಾಕುವ. ಎಸ್. ಎಷ್ಟು?
I am filing a memo, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಮೆಮೋ?
74 ನಲ್ಲಿ.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ
Amount has not been paid to the Bescom.
ಅಯ್ಯೋ, ಆಯ್ತು, ಅವ್ರದ್ರಲ್ಲೇನಾ? ಸರಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಮತ್ತೆ ಸೀತಾರಾಮರಾವ್ ಸರ್ ಕಾಪಿ ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಫೈಲ್ ಮಾಡಿ. ಈಸ್ ವಾಂಟಿಂಗ್ ಟು ಫೈಲ್ ಸಮಥಿಂಗ್.
ಆಯ್ತು ಸರ್.
ಎಸ್.
ಹಂಗಾರೆ ನಾಳೆ ತಗೋಬಹುದು.
ತಗೊಳ್ಳಿ.
ಟಾಪ್ ಅಪ್ ಲಿಸ್ಟಲ್ಲಿ ಬಂದ್ಬಿಟ್ರೆ ತಮ್ಮ ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಿದ್ರೆ ಸಾಕು.
ಎಲ್ಲ ಟಾಪ್. ಎಸ್ ಸರ್.
ಅಲ್ಲ, ರೂಲ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ, ಬಿ ಗ್ರೂಪ್ ಹೋಗಿದೆ, ಅದೇ ಬಂದಿರೋ.
ಗೊತ್ತಾಯ್ತು, ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಹಾಕುವ. ಎಸ್
ಪ್ಲೀಸ್.
ರೂಲ್ ಇಶ್ಯೂ ಆಗದೆ ಇರೋದೇ ಬಿ ಗ್ರೂಪ್ ಹೋಗೋದು.
ಅಲ್ಲ, ಇದು ಎಂಟ್ರಿ ಮಾಡ್ರಿಗೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಂದ್ವಿ, ತಗೊಂಡ್ವಿ, ಆಮೇಲೆ
ನೋಟಿಸ್ ಹೋದ್ಮೇಲೆ ಅದು ಬಿ ಗ್ರೂಪ್. ಎಸ್.
ಲಿಸ್ಟ್ ಬಂದ್ರೆ
ಆಯ್ತು. ಎಸ್. ಕಾಲ್ ದಿ ಕೇಸ್. ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅವರಿಬ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿ. ಲೆಟ್ ದಿ ಸೂಟ್ ಬಿ ಕಂಟೆಸ್ಟೆಡ್.
ಇಲ್ಲ, ನಾನು ದಯವಿಟ್ಟು ನನಗೆ
ನೋ 711.
My lord, I request your lordship to please, because the question of law.
Yes.
Question of law.
Yes.
Because my lord, this is one thing, there are 2 points. In fact, I would like to draw your lordship.
Please do.
Swami.
ಹೇಳಿ.
Swami, now, shall I read the impugned order, my lord?
Whole impugned order?
No.
You can't go until the cows come back.
Very quickly, just in 1 minute.
Yes.
Now, my lord, at page 16. Relevant portion, my lord, is at para 5, from para 5. The defendant number 1BC submitted on 15/9/23 that the memo filed by the plaintiff may be dismissed. That is the LRs of defendant number 1. It is pertinent to note that D1A, my lord, this is pertaining to all other parties, para 7. To say that all the parties except respondent 1 and 2 have objected out of 32 parties. Now, my lord, the para 9, I'll go to para 9. In a partition suit, both the plaintiff and the defendants are standing on the same foot as the plaintiff, and the plaintiff does not want to contest the matter, then the defendant can come as plaintiff by transposing. Here in the case of ration laid down in Gaurama versus Ranjappa is applicable, even though the plaintiff is a master of his suit and he can withdraw the suit, etc., etc. Now, in order, please see, the whole thing now, my lord, depends upon this ruling. My lord, my contention, my lord, the respondent, the original in the suit, in the ruling, my lord, the defendant was the original defendant, not the LRs. Here it is LR. When the LRs come on record, the whole law changes, my lord. It is not the applicable, what is applicable to the original defendant. My lord, now I request your lordship, please see this. What is that? What are the rights of the LRs? My lord, Order 22, Rule 4. Rule 3 is regarding bringing the defendants or the LRs of the defendant on record.
Correct. It is only the right of the deceased and not beyond it.
Yes.
Correct.
Exactly. Not beyond.
No, that's too rudimentary. Yes.
Now, Swami, now the original defendant, when they have not filed the return statement, where is the question of setting up any claim by the original defendant?
So non-filing of the return statement will take away the right of defense itself?
My lord?
Non-filing of return statement will take away the right of defense itself?
Undoubtedly. That is my contention.
That's your contention. Yes.
No, that's my contention. And also, my lord, I have relied upon some rulings. I'll read that rulings, my lord.
Kodi.
ರೂಲಿಂಗ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಒಂದು ಅದು ಟ್ಯಾಬ್ಯುಲರ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ, ಅದು
ಮಾಡಿ ಕೊಡಿ.
ತಗೊಳ್ಳಿ. ಈ ಟ್ಯಾಬ್ಯುಲರ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ 3 ರೂಲಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. No, my lord. The second point, my lord, I would like to draw your lordship kind attention on the question of law. My lord, the first ruling, my lord, that is Supreme Court ruling, AR 1968 Supreme Court, Ullas Rai versus Boss.
Boss?
Yes.
Boss.
Yes. My lord, this is the ruling, my lord. The Honorable Supreme Court has laid down a categorical law, rule of law. My lord, they say, my lord, shall I read that? My lord, it's a short judgment. I'll read that paragraph. My lord, the first ruling, my lord, at page 12, rulings ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ, page 12, my lord. And the relevant portion, my lord, is at para, is at 113, page 113. The short question that in these circumstances falls for decision is whether the respondent was entitled to withdraw from the suit and have it dismissed by application dated so and so at the stage when the issues had been framed and some evidence had been recorded, but no preliminary decree for rendition of accounts has yet been passed. My lord, the facts are identical. My lord, after the evidence, I have filed the memo. Now, this is This is what the law laid down. The language of Order 23 Rule 1, Sub-Rule 1, CPC, gives an unqualified right to the plaintiff to withdraw from the suit, and if no permission to file the fresh suit is sought under Sub-Rule 2 of the rule, the plaintiff becomes liable for such cause. My lord, now, I don't read the entire this one because of the time. My lord, the law laid down, my lord, that it is the absolute right of the plaintiff to abandon the suit and ask for dismissal of the suit, which has been done in this case. My lord, the only condition that has been laid down, my lord, is that the plaintiff, in the proceeding, there should not be any preliminary decree declaring the rights of any of the defendant, or the counterclaim, or the set-off. These are the only three conditions that this honorable court has laid down. My lord, it is rational because if the right has been already declared in the suit, so he should not go against the defendant. Therefore, he has the right to contest. Otherwise, he has the right to file a separate suit. Now, you want me please see, this is the ruling which has been quoted.
Why did you want to withdraw the suit?
My lord, the very purpose, my lord, let me make it very candid submission. My lord, the very purpose of filing of this suit, my lord, this litigation is going on for the past 32 years, from 92. My lord, the very purpose, because I get, my lord, by not withdrawing, I'm sacrificing a very big share, my lord, because I'll get 1/3 share. Otherwise, all other defendants will get only 1/6, and further subdivision. My lord, the very purpose of filing of the this one memo for this filing of the suit, to see that
suit for partition.
Suit for partition. So, all the defendants.
What happens to the defendants who are not accepting your plea?
My lord,
about their rights?
My lord, their right, they are making a new claim. Other than what is there in the suit also, they are making the new claim.
Won't they get transposed as plaintiffs? Because they have an independent right in partition. Defendant also has an independent right. They will get transposed as plaintiffs.
No, my request, my lordship is, I will read two more rulings.
Ella ruling adene.
Illa. Yadikendre, Swami, the right of the LRs is totally different from the original defendant.
You LRs bide. Beyond the right of the deceased, the LRs cannot go definitely. Merely because they have the deceased did not file the written statement, that doesn't mean no evidence of theirs can be taken, no right of theirs can be contested. No, that is not. Mere filing of a written statement is a circumstance which they cannot rely later. That's all. That doesn't mean their evidence is gone, everything is gone.
The law is when the law is very clear.
No, it's not that.
Supreme Court ruling is very clear, my lord.
Written statement ಹಾಕಿದ ತಕ್ಷಣ ಅವ್ರದ್ದೇನು ಕೇಳಂಗೆ ಇಲ್ಲ ಅಂತ ಅಲ್ವೇ ಅಲ್ಲ.
ಇಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. Other than that, my lord, when the Supreme Court has laid down the law.
Correct, sir. Supreme Court lays down the law. Yeah.
Can it be just honorably disagreed and pass some order, as in the case of this Gaurama's case, my lord?
We'll see, sir. Gaurama is by division bench.
Division bench.
Sir.
I want to make a distinction. Your Honor, please see this 1968 Supreme Court ruling. It has been quoted for approval in 1973. They say this is the correct law. And disagreeing with that Supreme Court ruling, this honorable court division bench.
Oh, then you should complain the division bench, sir. If division bench has written something contrary to Supreme Court.
The rulings ಕೊಡ್ತೀನಿ.
ನಾನು ಬರೆಯಲ್ಲ sir. Per incurium, I will not write.
Swami.
Don't be under the impression that I will ever say per incurium.
Swami,
per curium.
Swami, even if it goes against to me, I think your lordship is, I am in the right court to whatever the this one.
What one?
Law. I request your lordship to lay down the law, quoting all these rulings, particularly the Supreme Court.
I will, sir. Definitely.
I know.
Straight away. When defendant objects to the withdrawal of the suit in a partition, suit for partition, becomes a plaintiff.
And let my my submission come on this one, my lord. Supreme Court ruling is there.
Yes, sir. Correct. We will answer.
Yes.
Ashte tane.
Ashte.
Aayt bedi. Nimden, sir.
We already transposed, my lord, co-plaintiffs in this case.
You have filed
Gets
our evidence.
transposed as a plaintiff, sir. Partition suit,
Not very
everybody have a
curiously,
right.
not,
It is for equal right. But plaintiffs are not greater than the defendants, nor the other way around. Everybody have a share. If you compromise with someone else and say that I want to withdraw the entire suit, that won't happen. They will have to agitate their rights. They become plaintiffs.
Let them do it, I understand.
That is what they're doing.
No, see, my lord, the.
My lord, one submission, my lord.
These are all two rudimentary principles.
When
My
the
lord, in
law,
the trial court, my lord, they
one
filed
minute,
the.
when the
LR
law is
application.
laid down, when the law is laid down by the Honorable Supreme Court.
Correct.
It is the
Division
sum-
bench could not have written something else. That is your submission. Yes, yes, sir.
Not in the.
ಅಲ್ಲ, ಇದು ಇನ್ನೊಂದಿದೆ ಸ್ವಾಮಿ. Supposing
ಏನಿದೆ
it
sir?
goes against to me, I may be transposed as the defendant. Because that's what the ruling also says.
That is obvious, sir.
ಸ್ವಾಮಿ,
He is transposed as a plaintiff, he will obviously become a defendant.
Not in that
yeah,
case.
ಅದು ಮಾಡಿಲ್ಲ ಅವರು.
ಅದು ಮಾಡದ ಬಿಡಿ.
Lord,
ಅದು
during the
ತಾವು ಮಾಡಿ.
pendency of this, my lord, the CRP, my lord,
But
they have
one thing,
filed LR
my lord, if
application
the matter goes
before the
against
trial
me,
court.
I like to challenge this in the Supreme Court. ಅದರಿಂದ
Here they are
ದಯವಿಟ್ಟು
saying, my
ಒಂದು
lord,
ಯಾವುದು?
ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೂಲಿಂಗ್.
Oh, next flight to Delhi you can take. We will do it.
ಅಲ್ಲ,
Yes.
ಅದು ಸ್ವಲ್ಪ ನಂದು ಏನಿದೆಯೋ ಅದು ರೂಲಿಂಗ್.
ಎಲ್ಲ ಹೇಳ್ತೀನಿ. ತೊಂದ್ರೆ
I
ಇಲ್ಲ.
know, I know,
ನಿಮ್
I know.
ರೂಲಿಂಗ್ ಮೇಲೆ ಏನ್ ಸ್ಕೂಲಿಂಗ್ ಬೇಕಾಗಿಲ್ಲ, ಮಾಡ್ತೀನಿ.
అవును, ಆಗ್ಬೋದು ಸರ್, ಆಗ್ಬೋದು.
Yes, yes. Heard reserved. Yes.
ಅದೊಂದು
Next.
ಟ್ರಾನ್ಸ್ಪೋಸಿಂಗ್ ಮೇಲೆ ಡಿಪೆಂಡೆಂಟ್ ಅದೊಂದು ಬಂದ್ಬಿಡಿ.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಳ್ಕೊಳ್ಳಿ.
ಸುಪ್ರೀಂ ಆಗ್ಬೋದು,
I will only confirm the order.
ಆಗ್ಬೋದು, ಆಗ್ಬೋದು.
Next. Yes, Sandesh.
Lord, in the connected matter, my lord, I had filed an application which has not been put up, my lord.
What, vacating stay?
Illa, I had filed an application for conversion. In fact, it is not necessary.
Application is not necessary, petition is not necessary.
Illa, application is not necessary.
ಸರಿ ಹೇಳಿ, ಏನಿದು?
The first matter, my lord.
My lords, it's a suit for specific performance, my lords. As on the date of entering the agreement to sell, my lords.
Date?
That is on 12/8/2022, my lords.
12/8?
2022. The agreement, my lords. As on that date, I'm not the owner of the property itself, my lords.
Why?
It is the defendant number 2 who is the owner, my lords. Because there is a partition deed which is executed between the defendant number 1 and defendant
Date of
number 2.
partitions.
My lords, the date of the partition are produced at Annexure B, page 39. Date is
Date
on
of partition,
23/8, my lords.
date of partition, date of agreement, date of institution of the suit. ಮೂರು ಡೇಟ್ ಕೊಡಿ.
Date of institution of the suit is, lords, date of the partition deed is 23/8/2022, my lords.
23/8?
2022, my lords. Date of the agreement to sell is 12/9/2022, my lord.
12/9/2022.
12/9/2022. So as on the date of entering this agreement to sell, I am not the owner of the property itself. It is defendant number 2, my lords. And on.
Who entered into the agreement?
Runners, both defendant number 1 and defendant number 2 are the signatories. But
Both
in
are
the very
signatories.
same agreement, there is a clause at page number
ಈಗ
41. my
ಎಷ್ಟು
lord.
ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದೀರಾ?
ನಾನು ದುಡ್ಡೇ ಇಸ್ಕೊಂಡಿಲ್ಲ. Everything has gone to defendant number 2.
Who is
my lord.
defendant number 2?
Defendant number 2 is.
How much money you have taken?
30 lakhs is the advance.
ಈಗ ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
I'll take instruction.
What you take instructions? ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಸೂಟ್ ಹಾಕಿ ಇದು ಬೇರೆ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ತಗೊಂಡಿರೋದು ನಾನ್ಗೋಸ್ಕರ. Who are you both?
Brothers.
ಮತ್ತೆ?
Lords,
If it were to be others, ಬೇರೆ, your brothers.
Lords, but
Yes.
I did not get the consideration and it was.
That's different thing. You decide amongst you who will return the money.
Lords, I didn't get
Along
any
with
money
interest.
to.
ಸೂಟೆ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ.
Lordship,
ಇದಕ್ಕೇನ್ ಕಮ್ಮಿ ಇಲ್ಲ. ದುಡ್ಡು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟು ನನ್ನಲ್ಲ, ನನ್ನ ಬ್ರದರ್ಗೆ ಬಂದಿದೆ, ನಾನು ಪಾರ್ಟಿಷನ್ ಆಗೋದು, ನಾನು ಓನರ್ ಅಲ್ಲ. Why did you sign? Why did you sign?
Your lordship may have it next week, my lord. I'll
Or
take
have it
instruction.
next week. And suit ಹಾಕಿದ್ರೆ ಅದ್ರಲ್ಲಿ order 7 rule 11
Please, my lord.
I
Oh,
filed my lords.
rejection ಬೇರೆ ಅದ್ರಲ್ಲಿ. ಯಾಕಂದ್ರೆ you are not the owner of this suit, owner of the property. Why did you sign? You knew, right?
My lords, in that.
You knew that partition had happened 1 month before the signing of the document. Why did you sign?
Lords, the specific recital in the agreement also.
That
my
you are
lords.
not the owner of the property. So why did you sign? Why did you sign? This is neat ploy. 30 lakhs, huh?
Please, my lord. ಅದರಲ್ಲಿ 30 lakhs ವೈಟ್ ಅಲ್ಲಿ ತಗೊಂಡಿರೋದು ಬೇರೆ.
White ಅಲ್ಲ.
Please, my lord. ಬೇರೆ ಇನ್ನೇನು?
ಅಂದ್ರೆ ಬೇರೆ ಕಲರ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಾ?
My lord, what had happened in this matter is this, my lords, there was a case against both of them. So they were on the verge of arrest. By that time, my lord, they need some money. So ಆಗ ಈತನ ಕೇಳಿದರೆ ಈತ he keep on paying that money. So thereafter, my lords, ಅವರಿಂದ repay ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ. So they agreed will sell
ಎಷ್ಟು ತಗೊಂಡ್ರು ಟೋಟಲ್?
It is around 50 or 54 lakhs, my lords.
Totally.
Please, my lord.
In make it 24 ಬೇರೆ ಕಲರ್?
ಅಂದ್ರೆ it was cash ಅಲ್ಲಿ pay ಮಾಡು.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Lordship may have it next week. I'll take instruction.
Don't bring all these frivolous things here. ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಸೈನ್ ಮಾಡಿದೆ, ನಾನು ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತು, ಇದೆಲ್ಲ. I've taken money, give it back with interest. Yes. ಅದ್ರಲ್ಲಿ 711 ಬೇರೆ ಹಾಕಿದಿರಲ್ಲ. List the matter on 18th. I will not record anything, but I will not forget. Don't worry. Yes.
The petitioner, my lord, I served copy to the trial court appearing before the in original suit.
Awaiting the appearance of the counsel. List the matter on 24th. Interim order subsisting will continue to the next date. Next.
Lordship directed the ADL to survey the land and my lord.
ಮಾಡಿದ್ದೀರಾ?
Road is far away from my land, it seems.
Land is far away from the road.
My land.
ಏನು ಮೇಡಮ್ ಕೊಡಿ, ರಿಪೋರ್ಟ್ ಕೊಡಿ.
Because of I sketch, my lord, there is a wrong order as passed. Actually, its length is 151. Instead of 151, they take it as 125. Then they claim that I occupied that.
ನೋಡಿದ್ದೀರಾ?
Just now it has been served.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
Next week, my lord.
List on Wednesday.
My lord, 17th, my lord, Thursday, next Thursday.
17th, but 18th.
Obliged.
List on 18th. The learned counsel for the learned HCGP has placed on record a report of survey that was directed to be conducted on in terms of order dated 26/6/2025. Counsel Amritesh, appearing for the respondent, seeks a week's time to go through the report and make his submissions. List on 18th. Interim order shall idea.
No. Otherwise, my lord, executing court can decide the issue.
Let him have his say. Yes.
Interim order.
Undertaking was may be extended, my lord.
Interim order of any kind subsisting shall continue to the next date of hearing. Yes.
Obliged, my lords.
Agree with the rest.
Petitioner, my lords, so
File
they have to file
objection.
objection, copy.
Okay.
Objection copy. Registry will file ಮಾಡಿ. Counsel for the respondent seeks to file a statement of objection. The same be filed before the registry. 24th. Interim order subsisting will continue to the next day. Next.
First response. The legal relationship, my lord, was subject matter of dispute. Inquiry,
legal relationship between whom?
Between one Nanjundaya, my lord, who was the petitioner in the FDP proceedings, and my lord, his alleged wife by name Mahadevamma.
Alleged wife?
Yes, my lord. It was disputed. Now, during the
alleged wife springs only in the FDP?
Yes, she comes for the first time there. During the lifetime of Nanjundappa, my lord, a suit was filed very interestingly by her, seeking a declaration that her husband was dead. Now, this man walked into the court.
Who is the husband?
Nanjundappa, my lord, is the Nanjundaya is the husband.
Nanjundaya is dead, huh?
And she had sought a declaration, my lord, by filing a suit.
What happened?
Now he came there and he said that I am Nanjundaya and she is not my wife. My lord, recording that finding submission, my lord, the suit was dismissed as not maintainable. Now he eventually passed away.
You mean dead man walking? Yes.
Then, my lord, it so happened that after his demise, in the final decree proceedings, my lord, she files an application. We, my lord, bring all these aspects.
Is he now dead or not?
He is dead.
Yes.
He is dead now.
Yes, sir.
82 suit, my lord.
82 suit.
82 suit. Suit was decreed in the year 1986. FDP filed on 15.
15?
21/11/15.
21/11/2015. ಅಷ್ಟು ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ?
And the reason is, my lord, process went on. Then they came, they filed application, inquiry was conducted.
And he died on 28/2/2027.
28/2/2020.
2020. Or 20. ಎಲ್ಲಾರ application filed on 13/11/20.
ನೀವಾ ಎಲ್ಲಾರ application?
ನಾವು ಎಲ್ಲಾರ application. In fact,
ಯಾರು
I-
legal heirs ಅಲ್ಲಿ?
She is only legal heirs. He has no issues.
Then what is the issue about?
Like, I have brought on record as LR. Now he has challenged. Except this petitioner, nobody has a disputed relationship.
Oh,
My lord,
who are you?
My lord, I am the person, my lord, I am the brother of Nanjundaya, brother and brother's son.
Brother of Nanjundaya.
Nanjundaya's brother is one Bairegowda and I am the son of Bairegowda. My lord, throughout the litigation, he never said that, my lord, he was married. In fact, my lord, he was, my lord, leading a saintly life.
That is why he has not said, sir.
No, my lord.
No, but the very
That's
important
precisely the
aspect-
reason he has not opened his mouth with
Yes.
regard to
No, but
this
he
relationship.
came to the court, my lord, it is recorded in the order sheet, where, my lord, during his lifetime, he himself has said that she is not the
Don't use the word saintly life. Yes. Hmm.
without considering, my lord, the impugned order is passed.
In permitting,
Come on record.
Come on record is all
So
right.
what?
My lord, that must be always limited, only for the purpose of, my lord, representing the estate.
ಈಗೇನಾಗಿದೆ?
Now what happens is, my lord, this shall not be, my lord, at any point be considered, my lord, as a declaration of the legal status of the person.
That's a
For
different
that, my
thing,
lord,
yes.
an independent proceedings will have to be made. Now all that, my lord,
produced
will have
number
to
of
be.
ಈಗ where is it declared that you are the wife of Nanjundaya?
I have produced a document to show that.
What document, sir?
Exhibit P 19 to 45.
ಏನದು 19.5 ಏನದು?
20 documents produced.
ಏನದೆಲ್ಲ?
That is the Aadhaar card, ration card, then voter list, and bank passbooks.
Oh. ಎಲ್ಲ ಇದೆಯಾ?
ಎಲ್ಲ ಇದೆ. In fact, except this petitioner, he has nobody has disputed relationship. In fact, he himself.
Who are the other party? Who are the other persons?
Other persons, let me kindly see that Boramma.
Who is Gauramma?
Boramma is the uncle of the maternal uncle of the petitioner. The branch of Boramma has not disputed my relationship.
So ಯಾರು dispute ಇವರೊಬ್ಬರೇನಾ?
Except this petitioner. ಇವ್ರು ಬಿಟ್ಟು ಯಾರು dispute ಮಾಡ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ ರಿಲೇಷನ್ ಅವರದ್ದು ಯಾವ ಪ್ರೊಡ್ಯೂಸ್ ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಅದರಲ್ಲಿ
ನನ್ನ ತೋರಿಸಿ ವೈಫ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಎಲ್ಲಿ ತೋರಿಸ್ಬಿಡಿ, ಅದೊಂದು ತೋರಿಸಿ ಸರ್.
No, there is no such document.
ಅಲ್ಲ ಎಲ್ಲಿ ಅದೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ.
ಆಯ್ತು
ವಿಲ್ ಡಿಸ್ಮಿಸ್ ದಿ ಪೆಟಿಷನ್.
ಆಯ್ತು ತರ್ತೀನಿ.
ಅವ್ರು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್
ಅವ್ರದಲ್ಲ,
ಮತ್ತೆ
ಬ್ರಾಂಚಸ್ ಆಫ್ ಬೋರಮ್ಮ.
ಅದು ಎಲ್ಲಿದೆ?
I will produce it.
ಕೊಡಿ.
Start it.
What is the problem if she comes in?
My lord, enquiry has happened.
The
There is no
enquiry,
such document. I
second
don't
order application,
understand
my
where-
lord, already once the earlier application is allowed, the same as challenged, the matter was remanded back again.
But where is the determination that you are the wife of Nanjundaya? Which court has determined?
This court has passed an order, make an enquiry and pass an order.
Inquiry is made?
Enquiry.
What kind of enquiry is made?
Detailed enquiry, evidence has been let in by both parties. I have also fully cross-examined the petitioner. He also
Then
cross-examined.
ಅದೆಲ್ಲ ಆಗಿದೆಯಾ?
ಹೌದಾಗಿದೆ.
Anything else?
The 22
He has
rule
fully
5, my
examined.
lord, is a summary proceeding.
Pursuant to the
My lord, a
Summary
person
proceeding
who is-
ಅಲ್ಲೇ ಸಾಕದು.
Now what happens
ಅದೇನು
is,
regular
my lord,
civil suit ಆಗ್ಬೇಕು.
No, the court must say, my lord, that this is only confined for the purpose of representing the estate. My lord, thereafter, my lord, she must go and, my lord, seek a declaration before the competent court regarding her relationship.
So there is a direction by this court to hold
No, that
summary.
was
Yes, my
only
lord.
an
There is a
enquiry
direction.
because-
Summary proceedings.
Yes, summary proceedings.
yes.
22 rule 5 contemplates a
Only summary proceedings, but this court had directed those proceedings to be conducted.
Yes, my lord.
Right. Because, my lord,
Enquiry
he
has been
had said
conducted.
that the FDP will have to be concluded in a swift manner.
Yes.
This honorable
well
court,
considered
my
order
lord,
has been passed.
made an order that
Then-
let there be an
Then we'll
enquiry.
close it.
My lord,
ಇದರಲ್ಲಿ ಏನಿದೆ?
that has not been said by the court below,
Only
which
to
is
award-
the bounden duty, my lord, to
Only
be
to award
stated.
my share, he has made a-
Because what happens is, my lord, there will be an issue of res judicata tomorrow. That's the difficulty that will be always encountered.
Oh, yes.
Until and unless the court specifically says.
Ingenuity will bring about so many
No,
difficulties.
no, my lord, this is the law, my lord, on the aspect
Correct,
of
sir.
22 rule 5.
Give it.
I shall surely do it.
Yes.
Please.
And where is the genealogical tree? ಕೊಡಿ ಅದು.
Sorry, my lord.
ಇದ್ರೆ ಕೊಡಿ ಅದು. List on Wednesday.
Yes, my lord.
Yes. And don't come empty handed.
Absolutely.
You'll have to go like the same
No,
way.
because he said, my lord, he had not got the copy.
No, now
my lord.
only I have received the
I gave
copies.
the copy to him. I'll, my lord,
Yes.
get the.
Next.
Great.
And will not expect Nitesh to come like this. Yes.
Okay, for petitioner, my lord. The petitioners are the parents of deceased son, my lord, who is electrician, my lord. Before suit, my lord, claiming compensation, the court have waived the court fees, my lord. Before appellate court, my lord, the court is not ready to waive the court fees under the impression that the compensation.
Comment.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ವಿ ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ವಿ.
ಎಸ್ ಸರ್ ಮೇಡಮ್ ಅಲ್ಲೇ ನಿಮ್ ಪಕ್ಕದಲ್ಲಿದ್ದಾರೆ.
ಕಾಪಿ ಸರ್ ಇನ್ ರೀಚ್ ಓಪನ್ ಕೋರ್ಟಲ್ಲೇ ಕಾಪಿ ಕೊಟ್ಟೆ.
ಎಸ್ ಕಾಪಿ ಚೆಕ್ ಮಾಡಿ ಎಲ್ಲ ಹಾಕಿರ್ತೀರಲ್ಲೇ. ವೆಡ್ನೆಸ್ಡೇ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
ಪ್ಲೀಸ್.
Office objection in production of certified copy. House building. Yes, sir.
It's an against the review petition has been dismissed. A court fee issue has been framed, my lord. During the pendency of this, a suit was filed for declaration. Subsequently, suit was converted to declaration and possession. At that point of time, court fee issue was raised, and the trial court answered the court fee issue. Kindly see at page 94, my lord.
Where is the original order?
Suit is decreed.
That is annexure C, page 27.
Yes, my lord.
Yes, madam.
We were the plaintiffs. We were the plaintiffs before the trial court.
Hmm.
We had to file a review. He has filed. The court fee issue was already determined, my lords, during the pendency. The court, kindly see page.
Page 94.
94, relevant portion at 98. The honorable court heard us on the court fee. They heard the defendant also, and they said court fee was sufficient. But in passing the decree, adu original issues ittalla, matte they've passed the ella.
Then it has to be allowed.
Yes, yes.
When review has to be allowed.
The review has to be allowed.
We had to file a review, but the defendants only have filed a review.
Yes, allowed. Dispersed.
Great.
Yaar tenant yaar.
My lord, there is a serious dispute regarding
Serious dispute regarding what?
ownership, my lord. The plaintiff files a suit in the name of Kabadi Leasing, and he signs and verifies the affidavit by saying he is a partner of Kabadi Leasing.
Whose tenant are you?
I have taken from the father, my lord.
Whose
Kabadi,
father?
but I have executed an agreement in favor of Kabadi Leasing. But power of attorney holder who has been examined, he says, in view of the partition, the property has fallen to my share. Your lordship will see section 16.
What is the date of the agreement?
Date of the agreement is I will say
3rd October 1989.
Between whom?
Between
Kabadi Leasing and Kamla Bai. Kamla Bai is the
Kabadi Leasing, he says he is not the owner. Your lordship will see he is having the lesser is the holder of property.
Where is the agreement?
Exhibit ಕೊಡ್ತೀನಿ ಸಾಹೇಬ್ರೆ ಇದು exhibit P1 ಕೊಡಿ ಸಾಹೇಬ್ರೆ. Lesser is the holder of the property. No, they want claim that they are the owner of the property. HUF is there. One case they have already withdrawn. In spite of me, they filed 2 suits. Your lordship will see underline ಮಾಡಿದ್ದೀನಿ. And in Khata, in the plaint, they say they are the manager. And then verifying affidavit, he says he is the partner. Power of attorney holder says he is also a partner and property has fallen to his share. There are 2 things, my lord. The Abdul Wajid case, if the simple suit for ejectment, it is not a simple suit. Section 16 says, small cases court, the plaint has to be returned when the plaintiff is claiming ownership. In para 3, your lordship will say that.
How did you come into the property?
I came into the property by the father, Kabadi Sankar Shah. Then Kabadi Sankar Shah told, yes. Then he told that you execute the lease agreement. Then Kabadi leasing executed by two persons.
Hmm.
They executed the lease, my lord.
All right.
And we paid Prakash Trading. I have Kamla Bai because my husband, he has paid the advance amount.
Hmm.
And it was a dual tenancy, my lord. Tenancy in common. Both are running the property. So now Kabadi leasing
So you are
says
directed to vacate in within 2 months.
2 months.
You want some more time?
I will inform my clients if they want. If I have paid 10 lakhs goodwill, 1,25,000 advance put in.
Where is the document?
Documents are there. Deed 3.
Where is the document of payment of 10 lakhs?
ಇದೆ ಸಾಹೇಬ್ ಕೊಡಿ.
ನೀವು ಕೊಟ್ರೆ ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ.
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇಲ್ಲ ರಿಟರ್ನ್ಸ್ ಹಾಕಿ ಕೊಡಿ ಸರ್. I have produced from the date of inception of the.
Where is the document of 10 lakhs total ಕೊಟ್ಟಿರೋದಕ್ಕೆ?
Income tax returns.
As goodwill.
Income tax returns.
ಅದು goodwill ಅಂತ ಇದೆಯಾ?
ಹೌದು ಇದೆ ಸರ್.
Goodwill for shop number 2.
ಹೌದು ಇದು ಶಾಪ್ ನಂಬರ್
10 lakhs. ನೀವು ಡಿಕ್ಲೇರ್ ಮಾಡಿರೋದು ಅದು?
ಮಾಡಿ.
ಇವ್ರ ಅಕೌಂಟ್ಗೆ ಹೋಗಿದೆಯಾ?
ಹೋಗಿದೆ.
ಎಲ್ಲಿದೆ? ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲಿ?
ಯಾವುದು?
ಅವ್ರ ಫಾದರ್ ಅಕೌಂಟ್ಗೆ ಹೋಗಿರೋದಕ್ಕೆ ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲಿ?
ಲಾರ್ಡ್ ದಿಸ್ ಆರ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್.
10 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರೆ ಅದನ್ನ ಕೈಯಲ್ಲಿ ಏನು ಕೊಟ್ಟಿರಲ್ಲ?
Cash we have paid.
Paid by cash.
ಹೌದು.
Then that is your declaration.
No, declaration from ever since from inception.
That's your declaration goodwill ಅಂತ ಹಾಕಿದ್ದೀರಾ ಅಷ್ಟೇ.
ಹೌದು ಸರ್.
Unless you have a document to show.
Your lordship.
ಈಗ ಎಷ್ಟು ದಿನ ಬೇಕು ವೆಕೇಟ್ ಮಾಡಕ್ಕೆ? ವೆಕೇಟ್ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿನ ಬೇಕು?
ಅದಕ್ಕೆ ಮುಂಚೆ ನವೆಂಬರ್ 2021 ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದು.
ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅವತ್ತಿಂದ ರೆಂಟ್
There is
ಕೊಟ್ಟಿಲ್ಲ.
no pending.
ಆಮೇಲೆ
your lordship will say.
ಈಗ 2 things. ಈಗ arrears of rent ಎಷ್ಟಿದೆ?
ಏನಿಲ್ಲ. There is no arrears.
6,39,700.
ಎಲ್ಲಿದೆ ಅಂದ್ರೆ ನೀವು ಎಲ್ಲಿ ಇದ್ದೀರಾ ಅಲ್ಲಿದೆ.
ಒಂದ್ ನಿಮಿಷ. Court has not considered the quantum of rent.
No problem. This we will see.
No.
What is the monthly rent?
1,600. Then we have enhanced to 3,300.
1989
Court has stated that plaintiff has not produced any document to prove 3,300.
ಆಯ್ತು ಈಗ ಎಷ್ಟು 1,600?
1,600 earlier. Then it was enhanced to 1 ನಿಮಿಷ.
ನೀವು 1 ನಿಮಿಷ ಇರಿ.
14,540 rupees. This property is situated in RT Street, Chickpete Cross. 1989
No document has been produced.
No problem, sir. ಈಗ
No, I am not paying. I have stated.
That's all right. ಈಗ ವೆಕೇಟ್ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿನ ಬೇಕು?
2 ವರ್ಷ.
2 ವರ್ಷ. 2 ತಿಂಗಳಿಂದ 2 ವರ್ಷ. Impossible. Yes, next. Anything else, sir?
ಎಷ್ಟು ಕೊಡಿ ಸಾಹೇಬ್ರೆ?
Anything else?
Here there is a serious.
ಎಷ್ಟು ವರ್ಷದಿಂದ you want to squat over the property on these blurring technicalities?
Your lordship may feel reasonable. Reasonable.
ಎಷ್ಟು ವರ್ಷ?
So rent ಅಂತೂ ಕೊಟ್ಟಿಲ್ಲ. 2021 petition small cause court.
Advance ಇದೆ. Advance.
Then we will consider on merits. ಯಾಕೆ ಇದೆಲ್ಲ? 2 months ಕೊಟ್ಟಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ 2 months ಇವತ್ತು ಆಗುತ್ತೆ ತೊಂದ್ರೆ. ಎಸ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ.
ಇಲ್ಲ, there is a serious other case they have withdrawn, my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಸ್.
ತಾವು at least 1 year. Your lordship.
At least ಒಂದು ಅಂದ್ರೆ
for breathing time.
Breathing time ಗೆ you should give a breather. Rent ಕೊಡ್ಬೇಕು.
ಇಲ್ಲ, ಅದು ಅಡ್ವಾನ್ಸ್ ಇದೆ. Goodwill ಕೊಟ್ಟಿದ್ದೀವಿ.
ಏನ್ ಅದು goodwill ಕೊಟ್ಟಿರೋದು ಡಾಕ್ಯುಮೆಂಟ್.
Advance they have not considered. 1 lakh your lordship will say.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಡ್ವಾನ್ಸ್?
Advance we have paid 1,25,000.
Yeah, in 1989.
1 lakh at the time 25,000. D2 ಪ್ರಕಾರ 1 lakh by way of check. So total advance ಹೇಳಿ ಸ್ವಾಮಿ. 1,25,000 is the advance and 10 lakhs rupees is the goodwill, man.
Goodwill, no.
ಇಲ್ಲ,
I don't see any goodwill in that.
Your lordship is aware from Bangalore how many shop premises. Your lordship is also aware that goodwill.
Correct. ಅದಕ್ಕೇನೆ how long will you squat over this property without doing anything?
ಪಾಪ ಎಲ್ಲ goodwill ಎಲ್ಲ ಬಾರೋ ಮಾಡಿ ಸಾಲ ಮಾಡಿ ಎಲ್ಲ. Your lordship is the pathetic condition of the tenant.
ಅದಕ್ಕೆ.
And court has not considered.
You want me to answer 1 minute? I will answer. But you will have to pay rent. How can you squat over the property without paying rent?
ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ ಸಾಹೇಬ್ರೆ. We have produced the document accounts that in advance.
ಅಡ್ವಾನ್ಸ್ ಅಲ್ಲ, ಈಗ 2021 ಸೂಟ್ ಹಾಕದ್ಮೇಲಿಂದ ಕೊಟ್ಟಿದ್ದೀರಾ ದುಡ್ಡು?
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ
ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ
ಸಾಹೇಬ್ರೆ?
ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ
ಸಾಹೇಬ್ರೆ?
ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
It is not the case of the plaintiff, my lord, that they have not filed a suit for recovery of rent. Court has not given finding. Court says
anything else?
No document has been produced. no document has been produced by the plaintiff to show the quantum of the rental.
Anything else?
Yes, my
Ashwina?
lord. There is, he has already withdrawn one suit. He filed two
Andre.
suits before this honorable court. That he says,
All
our
right.
case withdraw madidare because there is a
Heard.
serious dispute.
Heard reserved. Yes.
Earlier.
Next.
Korea.
Yes. For next list. Okay.
Number 2. Now hearing number 30.
Lordship, I appear for the proxy.
Huh?
Proxy counsel appearing for the petition. Counsel is held up before the trial court. Should kindly have it tomorrow.
Tomorrow.
Yes, please.
ಏನೈತೆ?
Senior is held up in the civil court.
ಕೊಟ್ಬಿಡಿ ವಾಪಸ್. There is nothing wrong in this order. 617. You proxy counsel.
Yes, please.
Proxy counsel.
Yes, ma'am.
Learned counsel representing the counsel for the petitioner seeks a week's time.
And interim
List
order.
after 1 week.
There is an interim order.
I won't extend interim orders for proxy counsels.
Your Lordship.
No.
Kindly tomorrow.
Yes, next. Last time ಹೇಳಿದ್ದೀನಿ proxy counsel interim order extend ಮಾಡಲ್ಲ ನಿಮ್ಮ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಮತ್ತೆ ಬರ್ತಾ ಇದ್ದೀರಾ. I will not extend it. Interim order ತಗೊಂಡ್ಬಿಟ್ಟು you can't be wavering around. Next. ಇದೇನ್ ಮಾಡ್ತೀರಾ? ಅವ್ರಿಗೆ compliance ಕೊಡಿ.
I'll submit the compliance report. Let them take a decision in time frame, my lord, because the
I
admission
will direct them
process-
to take a decision in time frame.
Time frame, my lord.
As simple as
By
that.
way of interim measures, my lord, your lordship keep
No,
the
no,
writ
I
petition.
will direct them
Yes,
to take a decision within a time frame.
please,
You report all the complaint deficiencies are there, the compliances you report.
please.
They will communicate the decision taken.
Yes.
If there is any grievance, then you can always approach this
Right,
court.
that's it. Your lordship to keep this writ.
Now, why keep this 2023
The
matter
reason is,
pending?
my lord, if your lordship could see the report, my lord, on the basis of report of some other college, my lord, this interim order is passed. It's not pertaining to my college. If your lordship could see just, my lord, I will not.
ಅಲ್ಲ ಈಗ deficiencies ಇದೆ ಅಲ್ವಾ?
My lord, now these deficiencies which if I point out, my lord, just your lordship will take this report, my lord. How these deficiencies, I will only just point out, my lord, this report which is there, page 260, your lordship may kindly take. (262), your lordship may kindly.
Page?
Page 262 of the report, my lord.
Bullets, there is a spiral bind.
Is like this.
The reports, bullets.
260?
Yes, yes.
62.
Yes. Kindly come to this para 5, my lord, medical teaching staff.
262 na.
Please, ma'am.
Para 5,
Yes.
medical teaching. Staff.
Yes.
All right.
Reader in Department of Physiology, reader in Department of Pharmacology, reader in the Department of Microbiology. Well, those people were present.
ಈಗ ನಾವು ನಿಮ್ದ್ರಲ್ಲಿ ಡೆಫಿನೆಟ್ಲಿ there are deficiencies.
Well, those deficiencies, my lord, they are all rectifiable.
ಆಯ್ತು ಎಲ್ಲಿದೆ where is rectification?
No, no, I am only pointing out, my lord. Kindly come to page 73.
I am not on that at all,
Yes.
sir. Now you comply with all the deficiencies that are projected. All right, to the dental council of
Please.
India. All right. Then after that, they will pass some order. If you have any grievance, you can definitely
But
agitate.
now, but there is an interim order passed in this, my lord,
What is it?
prohibiting that the admission shall not be made. Kindly say annexure A, what is challenge is, my lord?
No, no, what is the interim order granted here?
My lord, this interim order granted is, my lord, staying the order annexure A, prohibiting the admissions from the academic year 2023-24.
Oh, then that will not,
Bullets, what will happen
by
is
this method, he should not lose the interim order.
your inspection reports pale into insignificance, my lords. The earlier inspection
Mike Todis.
reports,
Mike.
the earlier inspection report, my lords, as also the order of withdrawal of recognition pales into insignificance in light of your lordship's order dated 12/3/2025, where we were
Is it
directed.
12/3/25?
Please have 12/3/2025 minutes for a moment, because they said there were discrepancies in the inspection
One
report
minute,
was not supplied to them.
12/3/2025. Huh.
My lords, because they said there were discrepancies in the inspection report. This honorable court, my lords, directed us to conduct a fresh inspection on
What
24
has happened to
2000.
that?
Now that is what was placed before your lordships, my lords, which is the spiral bind. my lords.
Even in that, there are discrepancies?
There are discrepancies, my lords, and I will just point it out in just a minute. Your lordships may kindly come to page number 266, my lords, of the report.
1 minute. Which is the latest report?
The latest report, my lords, is in the spiral bound, my lords, which is placed before your lordships by way of a memo dated 26/6/2000.
Page.
Please come to page number 266, my lords.
Huh.
My lords, if your lordships
Inspector's
see-
observations.
Please, my lords, there are inspectors' observations. If your lordships comes to number 8, Roman number 8, my lords.
Yes.
There are, my lords.
No boys hostel.
There are infrastructural deficiencies, my lords, along with no teaching staff. Now, what I would implore.
Where have you said no teaching staff?
My lords, your lordships will see no teaching staff at page number 262, my lords. Your lordships just comes to 262. Number 5, my lords. Medical teaching staff, my lords, Roman number 1, read on the Department of Physiology, requirement is 1. Not available is 1, my lords.
Requirement, no, I'm at page 262. Not available.
Not available is 1. The requirement on the left side, my
Oh,
lords.
available is 0.
Available is 0, my lords, precisely. So this is the deficiency that is there in the college. There's no adequate teaching staff at all, my lords.
My lord, your lordship, I replied to that, my lord. Kindly come to page 73.
1
The
minute.
very same inspector, my lord.
Another deficiency in another.
Please, my lords. Now, if your lordships, my lords, comes to 266 again, my lords. If your lordship sees number 9, my lords. There's one dental mechanic, no dental hygienist in the institute. Availability of deficiency of patients. my
One
lords.
dental mechanic, no dental hygienist in the institute.
Please, my lords. Then 10, 11, 12, 13, all of this, my lords. These are deficiencies that are pointed out. Now, what is there prior to this at 262, my lords, is the entire inspection report. Then the UG subcommittee observations is what is there at page number 266, my lords, which is nothing but a crux of the inspection report. Now, all that is, my lords, there is, can I just pass on this compilation, my lords, for a moment?
Yes.
My lords, your lordships may, my lords, for a moment, just have page number 4, my lords. Your lordships has section 16A, my lords.
Yes.
Now, generally, when DCI conducts an inspection, my lords,
I'll clarify his
my lords,
facts
may
of
I
the case
finish,
in
my
2
lords,
minutes.
and then they may come
No,
to
but,
it.
Because
Because these are disputed
I'll just
questions.
kindly see, my
Why are they shy, my
Unless
lords, of
you
reporting
comply
on a
with the
compliance?
deficiencies,
comply, my lord.
we will not permit one single student also to be
Just
admitted.
might kindly come to page 73, my lord.
Staff illa. And what are you running there?
That this college is established in 92.
Then
As in 1996. My lord, earlier, my lord, they inspected, the director of medical education, on the direction of the government of India, inspected and submitted a report saying that our college has all the infrastructure. Within 2 months, my lord, they sent another inspector stating that you go and inspect. The central government direction is you take the inspector along with the
Sir,
state government.
pursuant to this order, inspection is carried out or not, correct?
Right, true.
If carrying out of inspection has resulted in these glaring deficiencies, how can you even expect this court to give a direction to
I'll
admit
only
students?
just page 73 for a minute, my lord, in that minute. How the deficiency has been pointed out, the staff is available, in fact, in their own report, my lord, they report deficiency.
Sir, there are 0 faculty available.
So kindly see, my lord, page 73, that answers their question, my lord. That is the reason, my lord, I didn't want your lordships to go into that. We'll go and tell the executive committee of the DCI, the inspectors, they themselves have taken the signature of the teachers, then still they show that there is a deficiency. Kindly come see, my lord. The Department of Pharmacology, first, my lord, physiology, kindly see, my lord, here.
What?
Physiology, the reader is absent. The reader is not available. They themselves have taken the signature, Sheila MD, Doctor, Assistant Professor. Now, reader has been redesignated in Karnataka, my lord, as per the UGI, Assistant Professor. They themselves have taken the signature. This is a part of it, my lord. Despite that, they show that, my lord, reader is not available.
1 minute.
Likewise, your lordship.
One moment.
Yes.
One by one.
Yes.
Now, yes, DCI council.
Yes.
Please, my lords.
Now what is the signature and what is the discrepancy that you have pointed out?
My lords, I may have to, my lords, again verify this aspect, my lords, because this is a report, my lords, that has been conducted, my lords, along with the officials of RGOHS and the state government, my lords. It's not as though I have unilaterally gone and conducted an inspection. Now, for a moment, assuming that there is some discrepancy,
Now, you
they can place that
pointed
by
out
way of
at
a
page
compliance.
262.
Please, my lords.
medical staff at column number 5.
Please, my lords.
DS required 8
Please, my
and
lords.
there are 0 staff.
Please, my lords, the requirement is a reader, my lords. This is in respect of
Reader is
assistant.
assistant professor, that's not a
No,
problem.
no, my lords, my lords,
Sir, assistant, associate and professor, reader is re-designated, that's no doubt about it, yes.
my lords, but that does not mean, my lords, there are no other deficiencies. Fine, very well, my lords.
One by one, see,
Please, my
if
lords.
you are caught on the first flaw, then definitely we will not consider anything else.
Please, my lords.
You have to be very responsible in making submission that nothing is there. Why have you deliberately drawn this?
My lords, that's not because the point is, my lords.
Why have you deliberately
may I-
drawn this deficiency
Now, my
list
lords,
if
may
you
I-
have
my lords,
taken the
may I-
signature here?
Now, my lords, may I just point out, my lords, reader, associate, professor, my lords, though it may appear, my lords, is synonymous, they are not, my lords.
Array,
And
not
I will, my lords-
synonymous, it is redesignation.
My lords, it's
What do you
not-
mean
No,
synonymous?
no, my lords, my lords, the way is, my lords.
The
our
post of
staffing
reader is
pattern-
now assistant professor, sir, it is the MCA, earlier MCA itself has said so.
No, no, my lords, my lords, our staffing pattern says.
What
my lords-
staffing
my lords,
pattern?
okay, my lords, for a moment.
Anything
I will-
else?
Please, my lords, come underneath, my lords. What about, my lords, assistants? What about receptionists? What about DSAs, my lords? What about dental teachers? My lords, if there is a discrepancy, please point it out in
No,
their
that,
compliance report.
why did this happen now?
Well, it's because we look at readers.
No, why
as
did this
separately.
happen? You have taken signature of the assistant professor
Well, it's because
and
we
you have
look
said
at
no
readers.
faculty, why?
Well, we look at readers differently, my lords. That is the reason, because our staffing pattern requires readers, assistant professors, lecturers, and then professors.
Where is that notification of the government redesignating readers as
But
assistant professor?
Well,
Let them
I don't
produce
have
it,
that
Milad.
designation.
It is,
Milad.
sir.
Yes, it is, but there is a,
Milad.
on the direction of the UGC, Milad, all these readers have been
Correct, sir, there is no
redesignated.
post of reader now.
Reader
Because
as
then
on
very well,
today,
Milad. Please come to 263, Milad. If there is this discrepancy, they may please point it out to the DCI. Then, Milad, what happens to the major equipments, Milad? Now, on equipments, I can't possibly
One
lie.
that next.
Milad, please see number 7, which is
What are the
major
other
equipments.
faculties other than this, sir?
Milad, secondly, Milad, they see pharmacology. Your lordship, I kindly see, is very, in the same page, they have taken the signature of assistant professor of pharmacology in
Allu
the
illa
same page,
antara?
Milad. Page 73, Milad.
All the faculty signature you have taken.
Yes.
Milad,
And then I
non-teaching
have one
staff-
more submissions to make,
Let
Milad.
them show non-teaching
These
staff, Milad.
deficiencies are pointed out by relying on, Milad, kindly come to page 56, Milad. This inspection is conducted on the basis of standards of establishment of new dental colleges, opening of dental colleges. Page 56.
Where do
Milad.
you get that?
Page 56, Milad. This is the inspection letter given. Kindly come to para 2, Milad. You have been appointed inspect physical facilities, building, staff, and their
ಆಯ್ತು,
qualification.
ಬೇರೆ ಕಾಲೇಜ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದ್ರಲ್ಲಿ.
ಎಲ್ಲಿ?
As per DCI regulations 2006, establishment of new dental colleges, opening higher course of study or training, increase of admission capacity, dental college regulation 2006. But this rule is not applicable because BDS regulations 2083 is applicable for this college, Milad.
Why?
Now, the reason is because this college was established in 1992, Milad.
Which is that regulation?
That regulation I have copy here, Milad.
Page.
Milad, I have the printout I have taken. Just only one. But this is 83 regulations. Relevant portions, Milad, I have taken. The minimum physical requirement of a dental college, Milad.
Page.
Page 11, it starts, Milad.
Minimum physical requirements
Yes.
of a dental college.
Yes. Milad,
ಇದಕ್ಕೇನ್
accommodation.
ಎಲ್ಲಿಂದ ತೆಗ್ದಿದ್ದೀರಾ? ಯಾವ್ದ್ರದ್ದು?
Milad, this is from the website of the DCI.
You don't have something else which shows that it is
Well, I have
this
the
that
book
is
itself,
applicable?
Milad.
Teaching hospital.
Milad, may I just come in, Milad, with a small
Wait, sir.
correction?
One moment.
Teaching hospital. Milad, this is for 40 admissions, Milad. Now what my learned friend is pointed out for 50. Page 17, Milad, is the staff, Milad.
What regulations are these?
Milad, the medical BDS regulations 1983, Milad.
Where do I get that?
Milad, I'll just download and just. This I downloaded from
ಯಾಕೆ
the
ಫಸ್ಟ್
website.
ಪೇಜ್ ಮರ್ತ್ ಬಿಟ್ರಾ?
ಇಲ್ಲ.
ಡೌನ್ಲೋಡ್ ಮಾಡೋದು.
I'll this thing. Because it was some 80 pages, relevant I took.
ಆಯ್ತು ಫಸ್ಟ್ ಪೇಜ್ ರಿಲೆವೆಂಟ್ ಅಂದ್ರೆ ಫಸ್ಟ್ ಪೇಜ್ ಇಂದ ಶುರು ಆಗ್ಬೇಕು ತಾನೆ.
First page. I'll have this thing. In 1983, I will download again. Kindly come to for concluding, minimum staff, page 17. Staffing pattern for 40, 60 and 100. This our college is 40 admissions. Dental staff, professor, reader, lecturers. Then for 40 admissions, your lordships will down below get it. Principal, dean, so and so. Teaching strength of 40 admissions. In case of admission, not less than 6 of which one be principal. Then the grouping there, each one of them are mentioned. Kindly come to the next page. Yeah. Download 83 regulation from DCI. The staff, medical staff.
ಒಂದು ಕೆಲಸ ಮಾಡಿ ಸರ್.
Yes.
ಎಲ್ಲ ನೋಟ್ ಮಾಡ್ಕೊಂಡು
Yes.
ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ತರ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಬನ್ನಿ. ಇಲ್ಲಿ if you go on flipping pages, time also gets flipped for nothing.
Now, what may I request your lordship, let there be
first ಅದನ್ನ ಮಾಡಿ, let there be ಅಂದ್ರೆ come all with all preparation. Come with all preparation.
Lordship have it tomorrow, I take it today.
Monday. Yes.
Manoj, I have some difficulty on next
You
Monday.
can come on Union of India formal party, madam. You can come online. Yes.
No, Manoj, mine are the impugned orders. Of course, now it does not matter because there's a new report.
Let me see. I'm only testing on the new report. Yes.
Yes.
Very good.
Prepare everything and come.
I have.
ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಂಡ್ರಾಗಲ್ಲ ಒಂದು ಕೊಡಿ.
All of them is there. Because there is a voluminous, I took out the relevant portion.
ಅದಕ್ಕೆ ಒಂದು ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ತರ ಮಾಡಿ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಒಂದ್ ಕಡೆ ಇದ್ರೆ ಎಲ್ಲ.
I'll make it. I'm sorry.
Next.
I'm grateful.
32.
And get that notification of the UGC.
I'll also get.
Readers are lecturers or assistant professors, readers are associate professors, professors are professors.
That also.
And if you're not aware of that, please dig into it and see.
I will also
Don't now stick on to readers post which is not even there.
Very well.
Yes.
I'll just check.
Interim order your lordship granted to continue.
Interim orders idea.
Ide
Subsisting will continue to the next date of hearing.
Please.
Yes.
32.
Rejection of amendment application filed by the defendant. Now, OS was filed on 2/22/2006.
Yes, sir.
I filed written statement on 2/11/2007. Lord, there are several defendants. Lord, reissues were framed on 29/5/2024. Not then on 5/6/2024, Lord, I filed this application.
What for, sir?
Lord, seeking to say, state that, Lord, the
Suit for
partition, Lord. At the first instance, Lord, I said it is a joint family property. Lord, then, my Lord, I discovered a document. Then, my Lord, I filed an application to say that it is not the joint family property.
There is a delay of 18 years, my lord.
Allah, the independent claim he has registered now.
My lord.
And Lord, I've given the details how I acquired, my father acquired the property.
It is at the stage of evidence, my lord. In her affidavit
Allah,
itself, she says. my lord,
generally I also won't entertain, but he said independent claim ಇದೆ ಅಂತ ಅದಕ್ಕೆ ಅಷ್ಟೇ.
After a lapse of 18
Written
years.
statement ಯಾವಾಗ ಹಾಕಿದ್ದು?
My lord.
Lord, it was filed on 2/11/2007.
You have filed?
Please.
My lord.
You also filed?
Please.
Is anything else?
Lord, the issues
What is
framed
the
on
amendment
20
now? Issue frame ಆಗಿರೋದು ಯಾವಾಗ?
on 29/5/2024. ಅದಾಗಿ ಒಂದು 4 ದಿವಸಕ್ಕೆ I made the application.
Make submission. It is in.
Now, my lord, there are several
ಅಲ್ಲಿ ನಿಮ್ಮ ಪಕ್ಕದಲ್ಲೇ ಇದೆ, ಅದು ತಗೊಳ್ಳಿ.
One submission, my lord. The matter was clubbed, my lord. 2018, my lord. Evidence was commenced on the same date.
ಮತ್ತೆ issues ಯಾಕೆ ಇವಾಗ ಫ್ರೇಮ್ ಮಾಡಿದ್ರು?
My lord, there are two matters, my lord. One more matter is there, my lord.
ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿದ್ ಯಾವಾಗ ಅದರಲ್ಲಿ?
ಅದರಲ್ಲಿ
2014
ಅಲ್ಲಿ ಒಂದಿದೆ.
2014.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅಲ್ಲ, issues ಇಲ್ಲಿದೆ ನನ್ನ ಹತ್ರ issues.
ಅಲ್ಲ 2014 ಅಲ್ಲಿ ಯಾವ್ದು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿ?
ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದು? ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದು?
ಅಪ್ಲಿಕೇಶನ್ ಈ ಕೇಸ್ ಅಲ್ಲೇ.
Same party,
1256.
same defendants, my lord.
It was
What were the two suits for?
Partition itself.
ಎರಡು ಪಾರ್ಟಿಷನ್.
ಹೌದು. Same property.
Evidence in a commence ಆಗಿರ್ಲಿಲ್ಲ. Much later evidence is commenced.
I will
Lord,
show,
one
my lord.
judgment, Lord, I am
Oh,
relying
please,
on
sir, ಕೊಡಿ.
2012 ಅಲ್ಲೇ
one judgment.
Come to proviso to rule 17.
ಹಾ.
There are many judgments. We'll dismiss it now.
Lord,
Correct.
before commencement of trial, Lord,
No, sir. ಯಾವ ಟ್ರಯಲ್ ಯಾವ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ?
ಇದು ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ನಾನು ಜೂನ್ ಅಲ್ಲೇ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಈ ಕೇಸಲ್ಲ ಸರ್, ಇನ್ನೊಂದು
ಕೇಸ್ ಅಲ್ಲೇ.
ಇನ್ನೊಂದು ಯಾವ?
my lord, 27/4/2018 my lord. Common.
ಟ್ರಯಲ್ ಕಮೆಂಟ್ಸ್ ಆಗಿರೋದು.
ಇಲ್ಲ ಇದೆ ಡೇಟ್. ಆರ್ಡರ್.
ಈ ಕೇಸಲ್ಲೇ ನಾನು ಅಪ್ಲಿಕೇಶನ್
ಕ್ಲಬ್ಬಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ
both cases are clubbed, Your Honor.
Anything else, sir?
Lord, this judgment, my lord.
Judgment ನಾನೇ ಕೊಡ್ತೀನಿ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ.
ಈ ಜಡ್
Yes.
ಪ್ಲೀಸ್.
And also you time bound case, Your Honor.
ಹೇಳಿ ಸರ್.
Please, my lord, page 2, my lord, page 2. Page 2 of the judgment. Second paragraph, the defendants 1 to 7 or respondents number 2 to 8 in this appeal entered appearance in the suit and filed a written statement supporting the case of the plaintiff. After entering appearance in the suit, the appellant so and so and filed written statement in which they admitted that the plaintiff with defendant number 1 to 7 were entitled to one-half share in the suit scheduled properties. Now, this is also similar case, my lord. Initially, an application for amendment of the written statement was filed with the appellants on 18th June 2003, which was contested by the appellant. The said application was allowed the civil court so and so, but subsequently writ application filed before the High Court, the instance of the plaintiff. The order allowing amendment was set aside and the application for amendment was rejected. However, liberty was given the appellants to file a fresh application for amendment of the written statement. Pursuant to such liberty, a fresh application for amendment of the written statement was filed on 12th March 2004 by the appellants, which was also contested by the plaintiff. In the application for amendment of the written statement, Lord, the appellants had sought to add that the plaintiff and defendants 2 to 7 could not acquire right, title and interest in the joint family properties as they were
Which is that order of the High Court directing?
Time bound was given on 2019 itself.
Lord, I will cooperate. Within 1 week, Lord, I will file the amended written statement. Lord, only one issue. Lord, the entire burden by this amendment, Lord, the entire burden will come on me, Lord. I have to establish that this is the self-acquired property. If this is not done,
You have
Lord.
already done that in the suit that is already clubbed.
No, my Lord, it is not done, Lord. This is the application I filed.
When did the clubbing order come about?
2018, my lord.
After that, this order is passed?
Yes, Your Honor.
Clubbing ಆದ್ಮೇಲೆ?
Club.
Now, my Lord, there are several applicants who have come on record as impleading applicants. My Lord, the case is reverted back to the original position now. They are also, they have filed, they are yet to file their written statements. There are several defendants who have come on record.
was
Already
extended
there
on-
are 34 defendants in
It was
this matter.
extended on 21/1/25.
Now, which are the other defendants that have come in?
There are so many defendants who
There
have
are
come.
Why in the clubbed suit, is it?
Yes.
Yes, my lord.
ಬಂದಿದ್ದಾರೆ ಅವರೆಲ್ಲ ತಿರ್ಗಾ ಈಗ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
There are 75
ನೋ
defendants.
ಹಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಬಿ ಕಾಸ್ಟ್ ಟು ದೆಮ್.
There are 75 defendants.
ಮತ್ತೆ ಎಲ್ಲರೂ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕಲ್ಲ ಈಗ?
ಹಾಕಿದ್ದಾರೆ.
It is all.
Amendment ಆದ್ಮೇಲೆ
Already plaintiff evidence is closed, Your Honor. The matter is set down to defendant evidence.
Within 1 week I will file
No,
the
no, sir.
amended.
Please, Your
Nothing.
Lord, one more judgment, my Lord. Related to builders judgment.
ಕೊಡಿ. Suit is of 2006 ಅಲ್ಲ?
Yes, my lord.
Which is the suit that is now clubbed?
Your Honor, this case is clubbed to the another case in.
ಅದ್ಯಾವ ವರ್ಷದ್ದು?
ಅದು 2006.
6.
OS number.
Parties are the same?
Yes,
Same
my lord.
parties and same schedules. Your
The petitioner is before this court. Petitioner defendant number 8 is at the doors of this court calling in question an order dated 29/6/2024 by which an application in IA 77 in OS 1256 of 2006 comes to be rejected, an application filed seeking amendment of the written statement as of
For indulgence, this judgment, I just point out, Lord.
no problem.
Devajit to
To
builders.
written statement in written statement in disturb ಮಾಡ್ಬೇಡಿ, wait, yes. Whatever it is, I'm not going to permit this 20 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕೋ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಇಲ್ಲ.
Lord, reason, Lord, as she was an
Whatever
illiterate
may be
lady,
the reason,
but
yes.
issues were framed just.
No, that is in
soon
the.
after the framing
That
of
is in the
issues.
suit that is clubbed.
Lord,
Yes.
Supreme Court says, Lord, before the commencement of trial, Lord,
2018 commencement.
comments ಆಗಿಲ್ಲ ನಾ ಇದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ, ಇದ್ರಲ್ಲೇ ನನ್ನ application.
Nothing. Yes, that is the way to do it. ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಡಿಲೇ ಬರುತ್ತೆ ಅಂತ ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಅಷ್ಟೇ. ಎಲ್ಲ ಒಂದೇ. The plaintiff, the petitioner is the defendant.
The very property, my lord, because my lord, it is the self-acquired property of my father, my lord.
Entry ಮಾಡಿದ್ಯಾ?
ಇದೆ.
Will not continue it list after 4 weeks.
Lord, sorry, my lord, I don't interfere,
Next.
sorry, my lord, sorry. ಅಲ್ಲ interfere.
ಆರ್ಡರ್ ಬರೆಯಕ್ ಬಿಡಲ್ಲ ಏನ್ ಬಿಡಿ.
Apologies.
ಬರೆದ್ರು ಅದು ಬರೆಯೋದು ಅದೇನೆ.
ಅಲ್ಲ, apologies.
Next.
33.
ಇದು ನಾಡಿದ್ದು ಹಾಕಿ, ಇವತ್ತೊಂದು ಜಡ್ಮೆಂಟ್ ರಿಲೀಸ್ ಮಾಡಿದ್ದೀನಿ.
ಹಾಗೆ.
14 years ಆದ್ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್, ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. ನೀವು ಇದರ ಹೇಳಿರೋದೆಲ್ಲ ಇದೆ ಅದರಲ್ಲಿ.
It may be called day after tomorrow.
List on Wednesday.
Till then, entry matter.
Entry matter stand section to the
Right.
next date of hearing. Yes. What is this?
13%.
My lord. My lord.
One is this case, my lords.
My lord, as against the impugned order dated 16/11/2024.
What is the order, sir?
Order rejecting my application for framing up additional issues. I have prepared this writ petition seeking appropriate relief.
All issues are already present. Why do you want 9 issues to be framed again?
My lord, payment of court fee, there is an allegation in the filed by the plaintiff that the defendants are denying his title. On page 87.
Every issue is there. Just because you want issues to be framed, go on framing issues, sir.
These are relevant issues, my lords.
Yes,
These need to be framed and they require to be framed for fair decision of the complete and fair
Filed a
decision.
suit for perpetual injunction based on the title and possession, my lords. So required issues have already been framed.
Where are the issues framed already?
Kindly, page number 113, my lords, annexure H. Issues whether the plaintiff proves that he is in lawful possession of the suit scheduled property, whether the plaintiff proves the interference by the defendants in his possession over the suit scheduled property, whether the plaintiff is entitled for the reliefs claimed in the suit, water order and degree. So all the burden lies on the plaintiff only, my lords. The suit is simply filed for
injunction.
permanent injunction against the defendants.
My lord.
What are the issues that you want to now
My
to be?
lord, page number 115, 115. Whether the plaintiff proves that the plaintiff is the absolute owner having acquired right, title, in interest in the suit settled property. Number 2, whether the plaintiff proves that the suit has been properly valued and proper court fee is paid. Whether the plaintiff proves that the present suit is.
You are the defendant.
I am the defendant number 2.
Whatever is there, he has done it, leave it. Yes. Why do you want plaintiff to prove whatever you want? Yes. Suit, he has 5 issues are already framed. All
Only
concerning.
two issues.
2 or 3 na ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಈಗ?
Main issues are.
Main issues, it is his burden. Why are you worried?
Burden lies on
You
the
are the
plaintiff.
defendant.
To prove my
Suit
title
is for
and,
injunction. It is his burden to prove. Why are you worried?
Court fee, payment of court fee is a crucial matter, my lord.
For
Even
injunction
though it is
suit,
a
we
suit
have
for
paid.
injunction.
The
Whatever
court
is,
fee of 20
sir,
rupees we have paid on
whatever
the
issues are now framed are appropriately framed. Later, if you want, not at a later point in time, you can't say plaintiff should prove this, plaintiff should prove this. Court will decide. Court on the place of pleadings is already framed issues.
My lord, I have raised the deep cloud over the plaintiff's title. And when the provisions of laws clearly is. very clear.
It is his burden, sir. Suit for injunction is it is his burden.
That's true, my lord.
And then,
but proper
if
court
he
fee.
if he fails to prove, the suit will be dismissed.
His proper court fee has to prove.
That he has already paid, yes.
No, only, it's not according to law, he has not paid. 26, may kindly be read, my lord, A and C, 26 are court fees on suit admission act.
Yes, sir.
26.
Court fee.
So court fee, advance court fee of rupees 25, I have already paid, my lords.
Pay ಮಾಡಿದಿರಲ್ಲ?
The sufficient court fee I have paid.
He has
Before the
valued
on the
the
flag.
suit. Only two options are available for him.
We'll hear it.
To
Yes.
value the suit.
List after 2 weeks. Yes, next.
My lord, till then, interim order.
No
may
entry mod. ಎಲ್ಲ correct ಆಗಿರ್ಬೇಕಾದ್ರೆ entry model. According, you are the defendant.
I'm the
Don't,
defendant
you don't
number two.
direct the plaintiff what he should do. He will do. If he doesn't do, it is at his peril. Yes, next.
Just interim order, may kindly.
No, sir. Yes. Still number? Ah,
24 I accept for the petitioner. Thanks, I have to ಬಂದಿದ್ರು. Respondent.
ಅವ್ರದ್ದ?
Date ತಗೊಂಡು ಕೇಳು. ಅದಕ್ಕೋಸ್ಕರ.
When do you want it?
Any day, I'm ready. Interim order making.
List the matter on 25th. Yes, interim order subsisting will continue till the next date of hearing at the request of the counsel appearing for the respondent. Next.
35.
Yeah, for the petitioners, my lord. A week's time may be granted, my lords, to take the steps, my lords.
If interim order ಇದೆಯಾ?
Yes, my lords.
Finally, a week's time is granted. Do the needful. In the event needful is not done, the interim order would get automatically vacated.
Please, next. Much obliged.
Subject to the aforesaid condition, interim order stands extended.
Not for the petitioner.
Hmm.
Not petition by the plaintiff.
Order 1 Rule 10.
Order 1 Rule 10.
Ah.
Suit minutes is for partition and separate possession.
Hmm.
Minutes, there are two parties.
Who are the impleading applicants?
Impleading applicant, my lords, he claims that, my lords, he has purchased the property from, my lords, the class 2 heirs of Srimati Lakkama, my lords. We claim that, my lords.
At what stage?
My lords.
Now, preliminary decree ಆಗಿದೆಯಾ?
No, it's at the very beginning, my lords.
Now you have filed an application.
Application.
You come in the final decree, sir. Anything else? Stranger cannot be a part of the partition suit. You come in the final decree proceedings.
I will purchase the property.
When? Prior to partition?
No, my lord. Prior to, my lords, institution of the suit, my lords, just prior to institution of the suit, my lords, he has purchased the property. Now his case is that, my lords, that he has purchased the property, my lords, from class 2 heirs of the vendor, deceased vendor.
Prior to partition, then he has the right to come in.
My lords, the difficulty is,
Prior to the institution of the suit, if he has purchased it.
My lords, now there are 4 items. My lords, his claim, my lords, is only with regard to 1 item. Now, my lords, this is a simple suit for partition.
Simple suit, partition.
My lords, the relationship is admitted. However, my lords, my brother, he contends that, my lords, that whatever is to be given to the plaintiff, my lords, is already given, and as such, my lords, I am not entitled for plaintiff. Now, the brother, my lords, sets up this applicant to derail the whole suit, my lords. Now, if he comes on record,
it is now allowed, right?
Application is allowed, my lords.
Yes.
My lords, if he has any right, my lords, independently he can, my lords, institute a suit, my lords, and agitate.
That property is subject matter of partition now. And partition has taken place prior to the institution of
Now,
the
my lords,
suit. Prior to the institution of the suit.
My lords, as my lords, he is not, my lords, I run the risk, my lords, of taking a decree which, my lords, cannot be
No,
implemented.
they
as
would
he is
also
not a
run the
party.
risk of losing the property then. Yes.
My lords, any decree, my lords, which is passed, in which, my lords, he is not a party.
No,
would not
his
bind
claim
him.
will be only the purchase of the property from the hands of his vendors. ಅಷ್ಟೇ.
Now there are
If
4
it were to be after the institution of the suit, final decree proceedings. ಈಗ suit institute ಆಗಕ್ ಮುಂಚೆ he has purchased the property.
Yes.
Yes. Anything else, sir?
My lords, then, my lords, on terms, my lords, this application is to be allowed because in respect of
On
suit
terms
item,
what? He will not claim anything beyond what is sale deed is, sir.
now the contention is that, my lords, that we are not the children, my lords, of the original
That
proposal.
will be tried in the suit.
Now, there are 4 items, my lords. His claim is restricted to 1 item.
ಆ one item ಮಾತ್ರ ಅವ್ರ claim.
That, my lords, your lordship.
That is all. ಬೇರೆ ಏನ್ claim ಮಾಡ್ತೀರಾ?
Any claim in
He
respect of
cannot
item
claim
number
anything
1 to 3.
else, sir.
I have purchased the item number 4
My
before
lords,
institution of the suit.
the contention that
Prior
he
to the
takes-
institution of the suit, item number 4 in the suit schedule property, he has purchased, correct?
Yes, my lord.
His claim is restricted only to that.
Now, while allowing the application, my lords, that no such observation is made. Now,
We'll make that observation and close it, that's all.
to that extent, my lords, your lordship.
ಅಷ್ಟೇ, ನಿಮ್ claim ಏನು extra ಇರಕ್ಕಾಗಲ್ಲ ಅಲ್ಲಿ.
Claim in respect of the item number 1 to 3, my lord. We are concerned to item number 4, which was even my vendors
See.
are also not parties.
And the other thing
That's
is,
also not parties.
My vendors are also not parties to the suit.
Why?
They
Who are they then?
My lord,
Your lordship, my kindly see, my lordship.
kindly one
my lords,
submission.
my case is that, my lords, the case of the plaintiff is that, my lords, suit item number 4, my lords, belong to one Srimati Lakkamma.
All right.
My lords, Lakkamma, my lords, is my stepmother, my lords, stepmother of plaintiff and defendant. My lords, property, my lords, is purchased in her name under a registered sale deed.
All right.
My lords, during her lifetime, she executes, my lords, an unregistered will, my lords, in favor of my father.
Will need not be registered.
Yes, my lords, unregistered will. It is unregistered will, my lords, is executed. Now she passes away. My lords, property, my lords, comes, my lords, the will, my lords, takes effect, and the property, my lords, comes into the hand of my father. Now, on the basis of that, my lords, this suit is instituted. Now, the claim of the impleading applicant is that, my lords, that he has that we are not the stepchildren, my lords, of Srimati Lakkamma, and my father, my lords, did
Yes.
not have.
That is in the suit evidence.
Now, the other difficulty is, my lords,
If that particular item that he has purchased becomes a part of the suit schedule
My lords,
property in a
from
partition suit.
whom he purchases, my lords, that also, my lords, becomes relevant. Now, he says that, my lords, he has purchased it from class 2 heirs of the deceased vendor. Now, all that, my lords, in this suit, my lords, it may not, it may not.
I'll answer it. Wait. The list the matter on 25th. Next date, eh?
Next date, my lords, is shortly, my lords, 2 weeks after.
Yes, list the matter on 25th. We'll see. ಅಷ್ಟು ಮೊದಲು ಮುಂಚೆ ಇದ್ರೆ move ಮಾಡಿ. Next. The only problem is his purchase from whom? Yes, we'll
Yes.
see. Yes.
My lords, till such time, my lords, if it's
ಯಾವ
20th,
ಡೇಟ್ ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹೇಳಿ, ಅವ್ ಕೊಡ್ತೀನಿ.
my lords, exact date, my lords, I don't
You
remember.
get-
25th, my lords, would
ಕೇಳ್ಬಿಟ್ಟು
be
ಹೇಳಿ.
beyond 2 weeks. my lords.
ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Yes, yes. Okay.
Next. 30?
I represent, my lord, please. BDA had to place their version.
We'll file, my lords. Lords, I need some time. My lords, even at para 10, they make it clear, my lords, that they file a suit in the year 2000. It is dismissed. They file a suit in the year 2010. It is dismissed. They file RFA in 2017. It is
ಅದೇ
dismissed.
230 ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಸ್ಟೇ ತಗೊಂಡ್ರದ್ದು ಅಷ್ಟೇ. ಯಾವ್ದು ಮನೇಲಿ
Honestly, make it quite clear.
In fact, my lords,
But there is no reason mentioned at all.
I said, my lord, it's not on acquisition. Acquisition, my lord, I have hit the final gate, my lord, I have nothing more to, nothing more.
ಮತ್ತೇನ್ ಬೇಕು ನಿಮ್ಗೆ ಈಗ?
My lord, I am thereafter, my lord, I have made repeated applications.
For what?
To allot, my lord, to reconvey and allot it in my favor. My lord, larger extent of property was acquired. That has all been consummated. My lord, now a small portion where my house is there, my lord, my petitions for reallotment in my favor, my lord, about 3,000 square.
ಸದಾಶಿವ ನಗರ ಅಲ್ಲ?
Sadashiv Nagar alla adu. My lord, this is Bhupasandra, my lord. It is not even, my lord, remotely close to Sadashiv Nagar.
Just next to it.
They have, my lord, named it as Raj Mahal Vilas, my lord. There is nothing to be Vilas about.
Oh.
Absolutely nothing.
ಅದಕ್ಕೆ
In fact, my lord, I have produced photographs. My lords may kindly have this. GPS photographs also. That's quite vividly taken, my lord. It shows, my lord, it's a pathetic condition property, my lord. I don't think anybody should be wishing for
ಅಲ್ಲಿ
that.
unless someone buys pathetic condition li ಇರೋದು. ಸದಾಶಿವ ನಗರ ಆಮೇಲೆ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ.
ಇಲ್ಲ, these are surroundings unu ತುಂಬಾ ಕೆಟ್ಟದಾಗಿ.
ಅಲ್ಲ, house built on, sir, house built in Sadashiv Nagar is no value.
ಈ Sadashiv Nagar ಅಲ್ಲೇ ಅಲ್ಲ. Sadashiv Nagar, my lord, Bhupasandra, my lord. People will, my lord, dread to go there because of the traffic.
ಧೂಪ್ ಸಂದ್ರ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಪಕ್ಕದಲ್ಲೇ ಇದೆ. Yes, sir.
Let them place their objection.
What?
They have not.
Otherwise, my lord, let them consider my application.
But the prayer made in the writ petition, my lords, is so far as seeking for lapse of the
acquisition.
They have not made a statement, my lords, that they have sought for any reconveyance. They have not made an application under section 38D or any otherwise. Had they made such this, I would say take instructions to
1978 acquisitions.
Please, I am not on acquisition.
Anything else, sir?
I am not on acquisition.
ಅವತ್ತೇನೋ JCB ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ
ಮಾಡಿದ್ದಾರೆ. In fact, my lord,
ಅದಕ್ಕೆ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿದ್ದ ಅಷ್ಟೇ ಇವತ್ತವರೆಗೆ.
My lord, honorable chief minister, my lord, writes a memo particularly directing the BDA. ಹೌದು ಇದನ್ನೆಲ್ಲ ಚೆಕ್ ಮಾಡಿದೀವಿ, ಇವ್ರಿಗೆ ಅಲರ್ಟ್ ಮಾಡಿ ಅಂತ. Kindly, my lord, see the minutes of the BDA, my lord, which refers to, my lord, the honorable chief minister's notes. Your lordship should kindly have
page, sir.
My lords may kindly have page number, my lord, 9, my lord, in the memo which I just passed on. ಇದು ಯಾವುದು ಇದು? ನಂದೆಲ್ಲಪ್ಪ, ನನ್ ಕಾಪಿ ಕೊಡಿ. May I just, my lord, pass on this? Kindly, my lord, see page number 9 of this. Copy. ಕೊಡ್ತೀನಿ brother, ಒಂದು ನಿಮಿಷ ಕೊಡ್ತೀನಿ. ನಿಮ್ದೇ ಇದೆ ಎಂತ? I'm not. Kindly, my lord, have page number 3. Page number 3, my lord, is my representation, and based upon that, my lord, the forwarding note.
ಎಲ್ಲಿದೆ?
Page number, kindly, my lord, have page number 9, my lord, now. Forwarding note.
ಫಾರ್ವರ್ಡಿಂಗ್ ನೋಟಾ?
ಹೌದು, ಇಲ್ಲಿ ಕೆಳಗಡೆ ಪೇಜ್ ನಂಬರ್ 9 ಅಲ್ಲಿ BDA's, my lord, this thing. ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಸಚಿವಾಲಯದ ಪತ್ರ ಸಂಖ್ಯೆ so and so.
ಎಲ್ಲಿದೆ?
ಈ ರೈಟ್ ಸೈಡ್ ನಲ್ಲಿ, my lord.
ಎಲ್ಲಿದೆ ಪತ್ರ?
ಅಲ್ಲ, page number 3 is the patra which I submitted, and my lord, the office of the honorable chief minister, after looking into all my documents, would say, please do something about this because it's not allotted and it is the landlord who is seeking it.
2006 sir.
Thereafter constantly, my lord, we have been following.
Every chief minister has wrote it.
My lord, at least, my lord, once in 2006 something happened, my lord, at least they have to, my lord, at least they have to issue a responsible reply.
Yes, Ajay Kumar.
Let them at least make a statement, my lords, in writing, my lords, that they
Which
made an
chief minister
application.
wrote ಅಂತನ?
ಅಲ್ಲ, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಆದ್ರೂ ಹಾಕಿದ್ರಿ 38D ಕೆಳಗಡೆ ಅಂತ ಏನಾದ್ರು ಹೇಳಿದ್ರೆ then I can take some instructions.
ಎಲ್ಲಿ 38D
Right now they have only
38D
stated-
application ಏನು?
In fact,
Regular,
my lord,
if you
incidentally,
want
it is
regularization of unauthorized occupation, 4000 square feet.
that. ಹೌದು.
ಓ ಸದಾಶಿವನಗರಲ್ಲಿ ಜಾಸ್ತಿ ಆಯ್ತು.
ಇಲ್ಲ, ಸದಾಶಿವ್ ನಗರ್ ಅಲ್ಲ, my lord, ಇದು
Have to
ಸದಾಶಿವ್
satisfy
ನಗರ್ ಅಲ್ಲ, my
conditions
lord. In fact, ಸದಾಶಿವ್ ನಗರ್ ಅಲ್ಲೇ ಅಲ್ಲ.
My lords,
We will, my lord, produce.
38D application ಹಾಕಿದ್ರೆ we'll direct them to
Yes,
consider.
yes, ಇದೆ. Kindly, my lord.
ಎಲ್ಲಿದೆ?
ಏನಪ್ಪಾ?
ಇಬ್ರು ಕೈ ಹಾಕ್ತಾ ಇಲ್ಲ ಅಂತ ಆಯ್ತು. It's there. ಅವ್ರಿಗೆ ಹೇಳಿ.
ಇಲ್ಲ, let them produce a copy at least, my lords.
ನಾಳೆ
Don't have the
ಇದೆಯಂತೆ.
this one also. No, the memo which is filed now before the court.
ಇದು ತಗೊಳ್ಳಿ.
ಮೆಮೋ ಅಲ್ಲ, ಇದು ಸುಮ್ನೆ ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಕೊಡ್ತಾ ಇರ್ತಾರ.
ಇಲ್ಲ ಇದೆ. ನಾನು in fact
ಅವ್ರ ಮೆಮೋ ಎಲ್ಲ ಹಾಕಲ್ಲ, ಸುಮ್ನೆ ಕೊಡ್ತಾರೆ.
ಈ ತರ ಎಲ್ಲ at least give it in a decent manner, how the way in which it is given to the honorable court on urgent ನಲ್ಲಿ ಬಂದಂತೆ. That is the only.
ಓ ಪರವಾಗಿಲ್ಲ. 38D application ಹಂಗೆ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ 38D application ಇದೆ, ಅದು ಕಾಪಿ ಕೊಡ್ತೀನಿ. My lords, kindly have it tomorrow or day after, my lord. I'll see to that, my lord. I'll place it, and my lord, I'll certainly restrict my prayer only to that text statement. I don't want to, my lord, challenge anything. So in the fit of drafting, my lord, they ask everything under the sun, my lord, it can't be given.
ಅದು ಕೇಳೋದ್ರಲ್ಲಿ ಯಾವತ್ತೂ ತೊಂದರೆ ಇರಬಾರ್ದು, ಕೊಡೋದ್ರಲ್ಲಿ ಮಾತ್ರ. Yes. You want day after tomorrow?
Any day, my lord. Monday, day after tomorrow, my lord. Day after tomorrow, Saturday.
ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಬಂದು ಗೊತ್ತಾಗದೆ.
Monday or Tuesday, any day.
Take it on Tuesday.
Please.
Yes.
Great.
On Tuesday. Heard senior counsel so and so list on Tuesday.
Interim protection may kindly be extended.
JCB ತಗೊಂಡು ಹೋಗ್ಬೇಡಿ.
ಯಾವ
Chief
cause of
Minister
action?
ಹೇಳಿದಾರಂತೆ ಸರ್.
There is no cause of action also, my lords.
Chief
ಏನು
Minister
ಹೇಳಿಲ್ಲ
has
ಇದು.
told, I believe,
2006
that don't touch this house ಅಂತ. That's what he is telling.
They have that kind of a reach in that case.
That is what I'm telling.
That was in
ಸದಾಶಿವನಗರ ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
2006. That was in 2006. There are many others, my lord, who can prevail upon us now. That is the reason, my lord, I have come to court.
All right, yes.
Greatly.
Tuesday.
Greatly.
ಅದಕ್ಕೆ seek instructions and come and close it. Yes.
Greatly. Great.
Next.
That's this item 58, my lords. Monday, my lords. I'm slightly unwell, my lords.
All right. At the request of the council appearing for the petitioner, list on Monday.
ಡೇಟ್ ಕೊಡ್ಸು, ಯಾಕಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ 2 ಸಾರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಫೈನಲ್.
ಹುಷಾರಿಲ್ಲ ಅಂತ
ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತು. ನಾನು ಇವತ್ತು ಅವ್ರನ್ನ ಕೇಳೋದೇ ಇಲ್ಲ. ಮಂಗಳವಾರ ಅಥವಾ ಬುಧವಾರ
ಸೋಮವಾರ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಸೋಮವಾರ ನಾನು ಕೇಳಿದ್ದೀನಿ, ಸೋಮವಾರ ನಾನು ಇರಲ್ಲ ಅಂತ. ತಾವು ಇನ್ನೊಂದು ಯಾವ್ದು ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕಿದ್ದೀರಿ.
ಮಂಗಳವಾರ ಇದೇನು GMCPC
ಮಚ್ಚು
Friday. Yes.
ಮಚ್ಚು.
Interim order may kindly be extended.
Interim order continues. Yes, next.
May I request Thursday, my lords, subject to the courts.
Sir, illa Friday. Next.
As I appear for petitioner, my lords, kindly pass over the matter, my lords.
Pass over now.
Anyway, on the last date, what your lordships indicated that execution, my lord, he said that an appeal would be preferred and it bring it up. Your lordship's order last time clearly records, my lord, that if no order is placed, what I'm told is they enter appearance in the trial in the executing court in February, but file the appeal only, my lord, even 3 months thereafter, and now they say they were not parties to the suit. That may not really, my lord, be a reason. Let them, my lord,
Short
deposit.
pass over, my lords.
Not that I'm not never going to say no.
Pass over.
Agbo.
Passed over to Monday. Yes.
Not in that case, my lord, let me make it clear, no risk, whatever I'd made a submission that we would take an adjournment, that, my lord, may not be continued.
Nothing. Monday.
Great.
Interim orders there, my lords.
No, there is no interim order.
They've
I'm
taken,
sorry, that may not
they've
be correct.
undertaken
They've
not
given
to.
an undertaking. You have taken an undertaking.
I made a submission, we will take an adjournment on the first date.
Next date yavat?
It is coming up on the 15th, my lord.
On the 15th. No problem. Monday.
Monday,
Yes.
very well. No, great.
Undertaking idre. Yes.
40.
Appear for the petitioner now.
Not
Item number 38. Kindly extend it.
ಆಯ್ತು sir.
I'm sorry, my lord. Item.
Sir, it will be extended, don't worry, yes.
Plaintiff's writ petition, my lord.
Yes, sir.
Non-adjudication of my applications, my lord, for a continuous period of time in a suit for injunction, my lord, where there, my lord, 9 acres of land is involved. And that
ಯಾವ
is,
ವರ್ಷದ suit, sir?
my lord,
Suit ಯಾವ ವರ್ಷದ್ದು?
2020.
Application is not decided?
23, my lord.
Application is not decided?
Not yet decided, my lord. What has happened is that has led to multiple complaints being filed between the parties.
All right, we'll direct the court to decide the application.
Please, my lord.
39 1 and 2 is not
39 1 and 2, 39 rule 4, and 151 application, my lord, seeking for police protection, my lord. Because there are law and order issues.
The petitioner, plaintiffs 1 and 2 are before this court calling us, seeking a direction for disposal of the applications pending before the concerned court in OS
317 of
OS
2020.
317 of 2023 in the time frame that this court would deem fit to fix. The petitioners are the plaintiffs. Institute a suit for injunction,
Bare injunction.
suit for bare injunction. In the said, along with the said, in the said suit, file application seeking temporary injunction of restraint at the hands of the respondent. The concerned court, though, has proceeded further in the proceedings, has not answered any of the applications preferred by the petitioners, plaintiffs before it, despite the passage of 2 years. The learned counsel for the petitioner submits that on the strength of the pending applications and no order passed on those applications, several other multiple proceedings are instituted by the respondent. In that light, as also the fact that the prayer being innocuous, the concerned court is directed to answer the applications filed under Order 39, Rule 1 and 2, or 39(4) and 151 of the CPC at an outer limit of 3 weeks from the date of receipt of the copy of this order, if not earlier and if not already passed.
Much obliged. My lord, I have sought for a interim protection, my lord, where the police can.
Allocated. Yes.
Much obliged.
Next.
Petition is filed seeking mandamus for speedy disposal, your lordship.
41.
41, your lordship. There's another writ petition which we have filed, challenging an order which has been passed with respect to an IA which is filed by the.
ಮತ್ತೆ ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ಮೇಲೆ ಇದು ಹೆಂಗ್ ಕೇಳ್ತೀರಾ? ನಂಬರ್ ಕೊಡಿ.
Please, your lordship. We will
Tag
take
the
up together next week, your lordship.
Tag the number. Tag the petition along with so and so list on 25th.
So on the 16th before the trial court. we
You take an
our next
adjournment there, list on, not 25th, next to 18th, yes. Next.
42.
For filed for partition, and preliminary decree was passed by granting 1/3 land. And in the final decree proceeding, my mother, who is a party to the partition suit, expired. So she bequeathed a will in my favor in so far her share is concerned. So I sought for enlargement of the decree, preliminary decree.
Modifying the preliminary.
Modifying the decree, madam. Without passing order on the modifying decree, commissioner was appointed to effect a partition. That I have challenged, which was allowed as per the order. That's why.
Now what has happened?
No, the commission was directed to effect partition by virtue of the order dated.
OS of 2000, sir.
Pardon?
OS of 2000.
OS, yes, my lord. FDP of 2011. In the order, it is directed to effect half equal partition. That is
Your applications are allowed or rejected?
not my application, the respondent's application was allowed. My sister, we both are entitled for the share.
What is the next date?
Next date is on 18th.
Petitioner to serve on the council or.
He has appeared. Caveat
Where is he?
He is today absent on the last 2 occasions he has appeared. Caveat was there. I served in advance the copy.
List on Monday. Next.
43.
Appearing for the petitioner in this case, Your Lordship. On the last date of hearing, Your Lordship, had this is a case, Your Lordship, the extension application and under 151 filed before trial court is not extended because deficit process fee was not paid, Your Lordship.
Correct. Now it is, we'll close it and send it back.
Please, may I request, my lords, summons is not served on me. Let them serve a copy of the plaint and documents.
Yes.
My lords may direct us to appear on 17th. Within a week's
Next
time.
date
I'll
is
file
17th,
objection.
is it?
30th July, Your Lordship.
30th is, 17th we will appear. We will file
Petitioner-
objections, 4 weeks direction.
The petitioner is before this court seeking the following prayer. Mustafa is here also. Surface Gulam Mustafa nodi sakati. Here also is there. Yes.
Lordship, notice to other respondents, should I file a memo, Your Lordship, for dispensation?
You should
I
file a
appeal
memo.
for
Who is the
respondent.
contesting respondent?
Lordship, actually,
R1 is the main contesting
D1
respondent.
matra tha.
My lords, I
Lordship,
appeal for-
R1 and R1 is common record, is on caveat. R17 is on caveat.
Hmm.
R14 to R16 are filed wakalat.
I appear for R14 to
But
16.
The remaining respondents are not yet come on record in the trial
I
court.
undertake to file power for R13, my lords.
R13.
And I appear for R14.
You serve on everyone by way of
My
hand
lords may kindly
summons.
see the irony. This matter is also listed for not payment of process fee.
Lordship, that has been paid. That has been
He is-
kept, Lordship.
He is in the habit of not paying
I am
anything.
here, I am contesting. There is in fact an arbitral award in my favor. The MOU cannot be specifically enforced with the specific finding of the arbitral tribunal. Of course, it got set aside in 34. We are before this court in 37. The entire suit will go if that award is restored.
Lordship, now
Just
there's-
on the,
the dispute has
Let
become
the
non
other
arbitral.
respondents be served.
I leave it to my
Let me
lords, of course.
dispense, Your Lordship, because they have not come on record in the trial court
They
also.
have not come on record in the trial court also.
Then it can be sent back with
Please.
hearing these petitions.
Please, because I
I
am in
filed
a
a memo,
grave
Your Lord.
urgency.
ಎಲ್ಲದ್ರಲ್ಲೂ default. Yes. The petitioner is before this court seeking the following prayer. The petitioner is heard so and so. The petitioner is the plaintiff. Commercial OS ಇದು
No, no,
Regular suit.
institutes a suit. In OS 2702 of 2025 and files an application under Order 39 Rule 1 and 2 seeking an ex parte temporary injunction against the respondents from alienating, encumbering or changing, altering the nature of the suit schedule property. The applications were answered by the concerned court. And on the score that the petitioner has not, the plaintiff has not paid the deficit court fee, the interim order stood vacated. It is at that juncture the petitioner comes at the doors of this court. This court on 30th June 2025 passed the following order. The interim order captured the grievance of the petitioner inasmuch as the deficit court fee that was indicated was only on 11/6/2025, the date on which the concerned court had posted the matter. In that light, the interim order was granted, as after coming to know the deficit court fee, the petitioner had immediately paid the court fee. The respondents are now, a few of the respondents are now represented. In the light of the interim order granted, restoring the temporary injunction so granted by the concerned court on account of which was vacated on account of the non-payment of deficit court fee, and it being paid at a later point in time, I deem it appropriate to direct the parties to appear before the concerned court on
17th. Within a week, I'll file objections.
July.
Or ಇವತ್ತು serve ಮಾಡಿದ್ರೆ ನಾನು 17th
on
I will be there.
17/7/2025. 17/7/2025, the respondents are at liberty to file their objections to the objections before the concerned court on the application or on the plaint, as a written statement on the plaint, or as the case would be. Since the interim order is now granted or the temporary injunction is now restored, it shall continue till further orders would be passed at the hands of the concerned court. With the aforesaid observation, the petition stands disposed.
Outer limit of 4 weeks for disposal
In-
of the applications before the trial.
It is needless to observe that the applications under Order 39 Rule 1 and 2 shall, after hearing the respondents, be disposed with an outer limit of 6 weeks, if not earlier.
There are 17 respondents, Your Lordship. That outer limit of 4 weeks.
Outer limit beda, as expeditiously as possible.
The difficulty is I'll be the contesting respondent. They'll not
ಅಲ್ಲೇ
pay
ಮಾಡಿ.
process again.
Not
They are all
correct.
connected landowners.
No, not
Perhaps
correct.
6 weeks. ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಏನಾಗ್ ಬಿಡುತ್ತೆ, I will be stuck with the order. That's
You
only
come here
difficulty.
again. Yes.
Well, that's
He
why
has,
this is
he
6
has
weeks.
come, you come.
6 weeks at least. Because the
No, may
difficulty
not be
is
correct. when too many defendants are there. ಅವ್ರು ಹೆಂಗೂ ದುಡ್ಡು ಕೊಡಲ್ಲ. You're
ಅಲ್ಲ,
expecting
ನಾನ್ ಕೊಡ್ಬೇಕು, I have to give it back to him.
You have to give back.
Under the MOU, I took some money, I said, you can develop. They went for specific performance that got refused. I am ready to pay, they got the arbitral award set aside.
Almost
no point
20
of
crores.
this.
Very,
20 crores
very
is
well.
not.
Yes, yes.
My lords may set some limit because otherwise now.
8 weeks. Yes.
Very well.
We told that some of the respondents are deceased, your lordship, so.
Alla, now.
And that's why it's not correct. Don't, as expeditiously as possible.
Great.
We don't know what is the situation there. It's not correct. Yes.
Very well. Alla, they filed the plaint only 1 month ago. If they're deceased, they should know.
We got
Unless they filed it
got
against
an
a dead
endorsement,
person
your
now.
lordship, after
I'm
receiving.
only saying, Malats, this cannot be the way, Malats. Allu process kattala, illu process kattala, they're not served.
ಅವರೆಲ್ಲೂ ಕಟ್ಟಲ್ಲ ಬಿಡಿ.
No, that is a difficulty. Now,
ಸರ್ಫೇಸ್
outer
ಇಲ್ಲಿ
limit
10
of
ಕೇಸ್ ಇತ್ತು,
object
ಒಂದು
ಮಾಡಿದ್ರೆ.
ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ.
8 weeks ಹಾಕಿ ಸ್ವಾಮಿ.
ಬೇಡ ಬೇಡ. Next.
44.
Much obliged.
For a petitioner in the matter grounds, I am passing the compilation for having complied the orders. Sir. Passing the compilation for having complied the order, my lords.
ಏನ್ ಕಂಪೈಲೇಷನ್?
The last set of occasion, it was agreed that we have settled the matter outside the court to take back the pipe inside the C schedule property.
ಪೈಪ್ ತಗೊಂಡ್ರಾ?
I thought,
Only they
but they
have
have
filed
not
the photograph.
completed the work. Whatever was pending, they have still kept it. And they are also trying to take a direct connection of BWSSB water into their premises.
ಯಾಕೆ ಬೇಕು ಇವೆಲ್ಲ? ಸುಮ್ನೆ ಒಂದು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಕೋಬೇಕು.
Lords, may I take my lords, the compilation. my
ಅದಕ್ಕೆ
lords.
ಕೇಳಿದೆ, ನೀವು ಎಲ್ಲ ನೆಟ್ ತೆಗ್ದಿದ್ದೀರಾ, ಬೋಲ್ಟ್ ತೆಗ್ದಿದ್ದೀರಾ, ಪ್ಲಂಬರ್ ಅಂತ.
My lord, the first photo, the photograph discloses the today's compilation, my lords.
Second photographs may be clear, my lord. In fact, I have also, I don't wanted to produce, I have a color photograph also.
ನೀವು ಬೇರೆ ಬೇರೆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ತೆಗ್ದಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅದೇ building, same
ಅದೇನಾ?
photograph. It's only color, it's a.
My lords, this was a pipe which was supposed to take inside, which I have taken inside, my lords. In spite of that, there is order in respect of C schedule property to go on with the renovation. My brother counsel files an application for trial court seeking for extension of interim order. He says the matter is settled here. He wanted me to take back the pipe. I want to put a into litigation. This court also made observation, let the suit be terminated if they are going to take back the pipe. He said, we'll report this compliance.
ಎಲ್ಲಿ ಇಲ್ಲ.
Before this court. Therefore, the matter is urgent today for reporting compliance. In fact, my lord, soon after that, before the matter come before the trial court, I complied the order.
I think I will pass an order. I will grant an interim order permitting construction.
I've undertaken, my lord, they can do the construction inside. I have no problem for that. Only thing is, whatever the damages has been done, they should redo it. And in the, they can do the interior works. my lord.
ಕೊಟ್ರಿ ಯಾಕೆ?
This is a 25 years old building.
That painting and all, we invariably have to do
ಅಲ್ಲ,
it.
painting ಎಲ್ಲ
At the
ಗೋಡೆ
time of
ತೆಗ್ದಿಲ್ಲ.
renovation, there can be.
Debris ಎತ್ತಿಲ್ಲ, ಏನಿಲ್ಲ.
ಅಯ್ಯೋ, ಒಂದ್ ನಿಮಿಷ ಸರ್. ಪೈಪ್ ಒಳಗಡೆ ತಗೊಳಕ್ಕೆ ಸುರಂಗ್ ಮಾರ್ಕ್ ತೆಗ್ದಂಗಿದೆ. ಯಾಕೆ?
ಅಲ್ಲ. That your CCTV is there, let him be summoned. It is the plaintiff who have done that. Why should I do that for taking a pipe inside, my lords? CCTV is there, let that be summoned at CCTV. If that is the case, my lords, my petition will dispose with 10 lakhs cost. If I have done the damage.
ಇರ್ಲಿ ಬಿಡಿ, CBI ಕೊಟ್ಬಿಡೋಣ. ಅವರೇ ಸರಿ ಇದೆ.
This kind of submission, in fact.
ಯಾರು ಸುರಂಗ್ ತೆಗ್ದಿದ್ದಾರೆ ಇಲ್ಲಿ?
It was there.
They cannot do the interior works without removing the wall. Debris, everything is as it is.
Now, whoever has done, you take that before the other concerned court. ಈಗ ನಿಮ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದೀರಲ್ವಾ?
A schedule property, they say it's A schedule property is a land area. B schedule property, I know it's their property. I will not interfere in the B schedule property.
ಏನಕ್ಕೆ ಬಂದಿದ್ದೀರಾ ಇಲ್ಲಿ?
Add interim ex parte order was passed
Ex
without
parte interim order
without a
they have
speaking
come.
order.
Will direct the court to consider both your submissions and pass necessary.
My humble submission is this.
That's the best way.
Yes, my lords.
There ನೀವು ಎಲ್ಲಾ ಕಡೆ ಸುರಂಗ್ ಮಾರ್ಕ್ ತಕೊಂಡಿರ್ತೀರ.
Yes, my lords. My humble submission, my lords, have filed citations where, my lords, this issue is covered by judgment.
No problem, sir.
That this
court will consider everything.
Yes, my lords. The orders, because, my lords, without speaking order, may take,
No
my lords,
problem,
to the
sir.
order at page number
Now,
7, my
whatever order I have passed,
Yes, my
I have
lords.
granted an interim order, is it?
Yes, my lords.
No, my lord, it's observation made that it's permitted to construct.
Yes,
And
my
we
lord.
said, let them construct inside. My lord, the
No
only issue
problem.
now is, my lord.
The petitioner is before this court. ಒಂದೇ petition ಎಷ್ಟಿದಾವೆ?
ಎರಡು.
The petitioner is before this court in these petitions, calling in question an order dated 20th June 2025, which declines to grant a temporary injunction as sought under R39 Rule 1 and 2 of the CPC.
Sorry, my lords.
Yeah,
Granted interim order was granted without giving any reasons.
Interim order ಅವ್ರ ಪರವಾಗಿ.
ಹೌದು.
My lords.
Interim order was granted. ನೀವು defendant.
Yes, my lords, without
The
giving any reasons.
petitioners are the defendants, are at the doors of this court in OS doors of this court in the subject petition calling in question an order that grants temporary injunction in favor of the petition, in favor of the respondent plaintiff. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನೀವು?
Challenge ಮಾಡಿ madam.
ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ.
I filed 34 in 39 rule 4.
Huh.
That IA has been kept on.
So
Because IA has been considered
the
not
defendants are on specific plea that the interim injunction as was sought for is granted without indicating any reasons for so granting, and would seek to place reliance upon several judgments of coordinate benches of this court to buttress the submission that an unreasoned interim ex parte interim injunction cannot be would not be sustainable. The respondent has entered appearance. In the light of the petitioner and the respondent both entering appearance, I deem it appropriate to direct the concerned court to hear both the parties and pass necessary orders in accordance with law, with an outer limit of 3 weeks from the date of receipt of the copy of this order, if not earlier, till such time the order that is subsisting in the order of any kind that is subsisting in the subject petitions shall continue. Yes, ordered accordingly.
45.
both my lords, both petitions.
Both.
Obliged.
Same order. Next.
Petitioner. In this one, in the commercial court case 994, I am the defendant, my lord. The plaintiff has sued us for.
Sued you?
50,000 rupees for the gas cylinders supplied in 23 cylinders.
Recovery of money.
Yes, my lord.
Yes.
And there was an issue. First, the issue will say this thing. The issue was raised on me on the third page number 66, my lord. Issue is whether the defendants prove that they have returned the empty cylinders to the plaintiff as contained in para number 10 of their return statement. I had produced my empty cylinder returns challan also.
All right. What is the application filed, sir?
Application is for the production of additional documents, my lord.
Additional documents.
Yeah, 20 documents I had produced.
The respondent is
So
here.
80.
Serial number in madam.
45. May I take your all also to the page number 87 and 88, my lord. That is the cross examination. Only one paragraph.
Where is the respondent?
No notice is served on him. I saw personally, he was waiting here from the morning.
Howda? Yes.
And
Let's the matter on. When's the next date there?
it is the second, so with great difficulty, I got the date the day before
Place
yesterday.
the matter on Friday, the next further proceedings before the concerned court shall remain stayed. Next. No representation we have the respondent and the Bharat Madi.
Appear for petitioner, Lord plaintiff petition, Lord as against the order passed by the my lord trial court and first appellate court, my lord on the application filed by the petitioner for permanent temporary injunction. My lord, 2 documents were not considered by both the courts. My lord, your lordships kindly see, my lord, annexure A. This is the partition deed. Annexure A, my lord, ink page number 16. My lord, the petitioner is the father of Sannegowda, and first respondent is my lord,
What?
son of
39-192 is not answered.
ಇಲ್ಲ ಅದು ಎಲ್ಲ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ extent was not taken into consideration by the trial courts.
What extent?
My lord, extent of the my lord's land. I am producing the sketch, your lordships, along with the memo. ಅದು
What application did you file?
My lord, temporary
ಮತ್ತೆ ಕೊಟ್ಟಿದಾರಲ್ಲ ಈಗ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಎರಡು.
ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು ನಾನು.
ಹೌದು.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ ಏನು ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅಪೀಲ್ ಹಾಕಿ.
ಇಲ್ಲ ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ, ಅಪೀಲ್ ಅಲ್ಲೂ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
ಎರಡು ಆಗಿದೆಯಾ?
ಎರಡು
ಕನ್ಕರೆಂಟ್.
Yes sir. Your lordships kindly see, my lord, in page number 24 application annexure C. My lord, this is the my lord, I am the owner of my lord, owner of the as per annexure A. Your lordships kindly see, my lord.
Respondent yaru sir?
Respondent ನನ್ನ brother son.
Correct. ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದಾರಾ?
ಹೌದು, ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
serve on the respondent. Yes.
8.5 ಗಜ ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. 9.5
Petitioner shall serve on the counsel who represents the respondent in the trial proceedings. List next Friday.
stay,
No, sir. Yes.
because my lord,
Next Friday, next.
Appear for the respondent in this matter. I must.
Respondent.
Indian Bank.
On a limited Millard prayer Millard time.
This is
another case of
100 crores sada idu.
This is 100 crores. They made an application before learned single
But
judge.
I'll submit.
Let me just.
I'll submit.
Out of petition.
But this is another case of Mexican standoff. These SARFAESI proceedings were challenged before this court. This court said go before the DRT. DRT said go before Chennai. That because of that 4/10/2022 notification that is stayed. In the meanwhile, the civil court does not decide my application under Order 13/1 and 2, their application for rejection of the plight. In the meanwhile, the bank is proceeding. The limited prayer is, now the matter is listed tomorrow. Matter is listed tomorrow. Let my application be decided. That's all. If the plaint is rejected, there ends the matter.
So far as, my lord, the question of where he must approach to challenge an action under the Securitization Act, this court has made a finding.
Securitization Act ಇಲ್ಲಿ challenge ಮಾಡಿದಾರಾ ಈಗ?
Exactly that. Please see the prayer in the plaint.
Suit
Sir,
for
may I just
declaration. Sorry.
May I just complete, sir? Please see the prayer, my lord. In the plaint, the prayer is
Yes.
page 37. To declare that the defendant bank. My lord, to declare that the defendant bank has failed to satisfy requirements section so and so of SARFAESI Act, hence not qualified to initiate action under the said laws, resultantly declare that the plaintiff has committed offences and penal acts that retract provisions so and so of Securitization Act, and plaintiff be entitled to seek for action in respect to the same.
Yes, Basuraj sir.
The reason is this: there are judgments and judgments of this honorable court and also Supreme Court that a suit for declaration challenging the proceedings on the ground of fraud, etc., is maintainable.
Fraud.
There are allegations against
That is not the allegation
No,
here.
there are allegations against the
SARFAESI
bank.
institute ಮಾಡಬಾರದು
No, there are
ಅಂತಂದ್ರೆ.
allegations. There are allegations
I
against
also
the
want to
bank.
add one
Your
more.
prayer, what is it then?
Suit for declaration based on the allegations against the bank. But tomorrow the application for rejection of the plaint is listed. Let the plaint application be decided tomorrow itself. That's all I am saying.
Can't
This
be
honorable
that
court in the writ petition said go before the
711
DRT.
711
I went before the DRT.
Coordinate bench. When the
711
coordinate bench of
ಹಾಕಿದ್ದೀರಾ?
this
Yes,
court,
they have filed the application. There are two applications, I number 2 and I number 4. Tomorrow the matter is listed. Let them argue the matter. We'll also argue the matter.
we don't want to.
Maintainability of suit cannot
That is
be
a
questioned
completely
in my
different
writ
issue, my lord. I'm
petition.
sorry.
In my writ
ಇಬ್ರು
petition.
ಹೇಳಿದ್ರು.
But in my writ petition, they check and
Why
cannot
is
check.
all this?
ಇಲ್ಲ, ಆ ಥರ ಇಲ್ಲ.
ಇಬ್ರು ಹೇಳಿದ್ರು
Challenge
ಹೆಂಗೆ?
myself.
ನಾನೇನು ಹೇಳಲ್ಲ. ಅವ್ರು ಮುಗಿಸ್ಲಿ. After that, I want to.
Yes, sir.
But in
Anyway,
my writ-
Now, if you look, Basuraj sir, if you look at the prayer,
Yes,
you have straight away attacked the proceedings instituted under the SARFAESI Act.
certainly. But certainly, my lord, that is why I submitted.
ಈಗ 711 ನಾಳೆ ಇದೆಯಾ?
7/11 ನಾಳೆ ಇದೆ.
Monday.
That's a slightly different point.
ಏನು
Point
rejection of plaint ಹಾಕಿಲ್ವಾ ನೀವು?
Rejection
ಹೌದು.
plaint is. May I just say one thing? He came to court challenging the Securitization Act
Where?
before this court.
ಇದ್ರಲ್ಲ.
Not in this. He filed a writ petition challenging it. Writ petition was dismissed. Here, please see the order.
Which is that?
That order is filed by them. Please see at page 209.
No, it's not mine.
Not your lordship's
no,
order.
yeah.
This court, my lord, I
Correct.
meant High Court.
No.
I'm sorry.
No, because generally this, if I decided it, I would have remembered.
And yes,
That's why.
ಅಲ್ಲ,
That
entry
is-
ಮಾಡ್ರೆ ಕೊಟ್ಟಿದ್ರಿ ತಾವು.
sir, one nimisha, sir.
Ah.
Now you give me 1 minute.
Yes,
please.
yes.
Now, my lord, your lordship will kindly see para 9 of this order. Interim order will stand discharged if you don't do it in 3 weeks. So he goes to, my lord, the DRT, files it on the last day. DRT says we cannot entertain this because it has to go to Chennai. So then, my lord, what should be done? You must go back to the same court, ask for extension. They do it. They move an application for extension before the same court.
Who did?
Not before your lordships.
No, before DRT.
Not before DRT Chennai. They've not gone to DRT Chennai till today. They went to DRT Bangalore.
That
DRT
is
Bangalore said no jurisdiction, go to
100
DRT Chennai. Therefore, my lord, since they went to the last day, no time. So they mentioned an application before the learned judge who passed this order.
What happened?
Learned judgment said posted on Monday. It was never listed after that. Till today.
Till ಬಂದಿದೆ.
In Bando, they get an interim order from your lordships saying, oh, they are saying Chennai, I have Bangalore, I didn't know. And on the basis of what? And this suit was filed in March. They don't move it. They come before your lordships now and ask for an interim order. And your lordships will not,
Granted.
in all these cases, my lord, I know your lordships are most sympathetic to borrowers. But it can't be like this.
ಇದು ನಾನು borrower angle ನೋಡ್ಲೇ ಇಲ್ಲ ಇದನ್ನ.
Today,
No,
my lord, they
Basuraj.
can't do this.
But can I make this submission? This honorable court in my writ petition, my lord, granted an interim order. Your lordship granted the interim order.
Maybe that
Then,
is,
my lord-
that is
no, no,
now
let-
over.
Then this honorable court said, go before the DRT. We went before the DRT on 2/7/2025.
That I have captured, sir. And you moved, all modification Kelly.
No, we are not on that. We are not on that. Let the civil suit be decided. That's all I'm seeking. Let the applications for rejection of the
And
plaintiff.
your
and my-
the entire premise, even the pleading
Yes.
is only
Certainly,
attacking
my lord,
surface
kindly
proceedings.
see the judgment of this honorable court.
Surface proceedings.
Yes,
no, sir.
certainly. Surface proceedings based on fraud, etc., is maintainable before the civil court, commercial court. Therefore, my lord, allegations of fraud are made. Even the surface proceedings, my lord, can be challenged in a civil suit.
Never.
Certainly, my lord, the division bench of this honorable court.
No, sir.
Division bench.
ಎಲ್ಲಿದೆ ಕೊಡಿ sir.
ಕೊಡ್ತೀನಿ. Sir.
Surface proceedings in a civil suit, you can challenge.
Certainly,
I have
certainly, my lord.
not
If it is
seen.
based on a declaration, not at any rate, my lord, at any rate, in my writ petition, my civil suit cannot be checkmated. That will be decided by the trial court. My lord, that will be decided by the trial court tomorrow. That's all I'm submitting.
Both of you go before the trial.
That's all I'm submitting.
That
Tomorrow.
But not with this interim order. Interim order can't be continued.
Not- The
Especially
reason
when
is-
the
that is why I
coordinate bench
said,
has
my lord,
refused to
this is
grant
the
interim
classic
relief.
case of Mexican standoff, because DRT says, I go to Chennai, this honorable court says, go to before the DRT.
No,
civil-
you take a clarificatory order from Justice Sunil Yadav itself, who has passed the order.
But that matter
The
is not
clarification.
They
All
will
I am
move it
take
after
a
that.
clarification, take a
Appeal
protection.
court, my lord, after issuing notice.
I will not decide a case where you have instituted a civil suit or.
That's all, my lord, my entire prayer that before this honorable court on that day and today also is, let the application be decided by the civil court, let the prayer be, plaint be rejected
be a-
tomorrow. But I cannot be made remediless because this court said, go before the DRT.
That is the remedy.
Pardon me?
Remedy there, not.
No,
before.
this honorable court said,
If my
go
lord, the
before the
suit was all
DRT.
that was there, why would they file a writ petition before
ಅಲ್ಲಿ
this court?
ಹಾಕಿ ಈಗ DRT ತಗೊಳ್ಳಿಲ್ಲಲ್ಲ.
But I do not want any extension of time from this honorable court in that writ petition.
So they're not going to
All
give-
I am submitting, this is a GM CPC writ petition. I am seeking a direction to the trial court to decide. my
There is
application.
no flavor of CPC at all here. ಎಲ್ಲ
Yes, certainly.
surface ಇದೆ.
But
ಪ್ರತಿಯೊಂದು surface ಇದೆ.
certainly, my lord.
Prayer, no sir.
My lord, kindly see the order passed by this honorable court. The judgment of this honorable court says,
no, sir.
kindly see, my lord, section 12, paragraph 12.
No,
Order-
again I
kindly see, my
don't
lord,
want to
para
report on the wrong
12,
side.
ಅಲ್ಲ, para 12 ಒಂದ್ಸರಿ ತಾವು ನೋಡ್ಬಿಡಿ. Not maintainability of the civil suit cannot be decided in my writ petition challenging.
I am not on that at all. You both of you go before the
That's all I
concerned
am
court, pass
submitting.
orders.
That's, let the application be.
So what is the next date there?
Tomorrow, 11th.
Tomorrow worge interim order will continue. Tomorrow you do
Certainly,
that.
my lord.
Yes.
Please don't continue. No,
But tomorrow we'll make
humbly
submissions
request
to the
your
trial
lordship,
court.
Please don't continue an interim order.
We'll take this as disposed. Tomorrow let the case be taken up before the concerned court and appropriate orders be
Make the
passed.
application,
The
we'll make the
difficulty
prayer
is
tomorrow.
this,
We'll
no,
press for interim order tomorrow.
So far as your lordship's interim order, my lord, in my humble submission, will stand in the teeth of what the other court has already held. Now the other court, not, and that is a
ಈಗ
challenge.
ಧ್ಯಾನ್ ಸರ್ ಈಗ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ನಾಳೆ 10 ನಾಳೆ ಬೆಳಗ್ಗೆವರೆಗೂ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ. I will dispose this petition, let the court pass any order. they
Certainly,
want.
my lord.
And merely because I have granted, the court will not grant interim order, just like that. I will observe that also.
Very well.
Yes.
Very well.
They heard the learned senior counsel, heard petitioner is before this court seeking the following prayer. This court, owing to the nature of controversy as projected at the time of preliminary hearing of the matter, had granted an interim order which reads as follows. The learned senior counsel, both the learned senior counsel representing the petitioner and the respondent would submit that the matter is pending before the concerned court even as on date, matter is pending before the concerned court where the applications under R39 Rule 1 is yet to be decided after hearing the parties. The matter is set to be listed tomorrow date. In the light of the matter being listed tomorrow, I deem it appropriate to dispose the subject petition with the direction to the concerned court to pass necessary orders on the application on Order 39 Rule 1 and 2, after hearing both.
And Order 7 Rule 11.
Oh, sorry, Order 7 Rule 11, after hearing both the parties. Merely because an interim order is granted today, in the light of this disposal, I deem it appropriate to continue the interim order dated 3/7/2025 for 24 more hours. The merely because the interim order is granted and continued, it does not mean that the concerned court is bound by the interim order so granted, which is continued for another 24 hours. The concerned court shall answer the application in the matter that is listed before the concerned court tomorrow in accordance with law. Ordered accordingly.
Let them not seek time, because last time they sought time before the trial court. Counsel for defendant praised time.
He'll
That's all.
argue, madam. We'll argue.
Yes,
both the applications.
ಇಲ್ಲಿ ಹೆಂಗ್ ಮಾಡಿ ಅಲ್ಲೂ ಹಂಗೆ ಮಾಡಿ
Yeah, ಹಿಂಗೆ ಮಾಡಿ.
ಇಲ್ದಾರೆ ಅವ್ರು ಇದಾರ ಬಿಡಲ್ಲ ಅವ್ರ ಶ್ಯಾಮ್ ಸುಂದರ್
Last
ಸರ್
time ಅವ್ರು
ಇದಾರ
ಇದ್ರು, ಪಾಪ ಈ
ಶ್ಯಾಮ್
matter
ಸುಂದರ್
ಅಲ್ಲಿ-
ಸರ್ ಇದಾರೆ ಎನ್ಕೋಮಿಯಮ್ಸ್ ಕೊಟ್ಟಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಎಸ್
Petition. But the application order 1 rule 10 has been rejected in an area. But today's matter has been posted for judgment. But though the application has been filed along with the document to show that I am the wife of the appellant Chandrappa.
ಜಡ್ಜ್ಮೆಂಟ್
ಹೌದು,
petitioner to serve on the counsel representing the respondents in the appellate proceedings
But in the
and
meanwhile,
file an ಹೇಳೋವರೆಗೂ ಬಿಡಿ and file an acknowledgement to that effect, list the matter on 18th. The concerned court, the further proceedings before the concerned court in MA, in RA, RA 119 of 2001.
2001 now,
Why,
but
sir?
it has been now, it has been remanded back by this court itself.
By who? By this court?
This court, my
Now
lord, I
what,
have
who are you then?
But I am the wife of the Chandrappa, that is who is the appellant in the area. But I have produced the
pension na?
document. ಹೌದು, document ಹಾಕಿದೆ. Earlier it has been.
Railway
disposed of.
employee, railway employee.
ಇಲ್ಲ, railway employee.
Right, so it's till further the concern, further proceedings in RA so and so shall remain state till the next date of hearing.
Please.
Next.
My lord, I appear for the petitioner, my lord. This is in respect of rejection of application under order 6 rule 17, my lord.
ಯಾವಾಗ
It
ಹಾಕಿದ್ರಿ
is
sir?
before the court. In the month of March,
Dates ಹೇಳಿ sir, suit,
suit is filed, my lord, in 2020.
issues,
Issues, my lord, are framed thereafter, my lord. In 2024, because there was a proceeding, my lord, there is a proceeding pending before this honorable court in the MFA. Now I filed an application for
Amendment of plaintiff.
my lord, of the plaintiff. Only 3, my lord, that is initial of the plaintiff number 3, my lord. And secondly, my
petitioner
lord,
to serve on the counsel who represents the respondents, defendants before the concerned court and file an acknowledgement before this court on or before the 11th of July 2025. List the matter on 25th July till such time further proceedings before the concerned court shall remain stayed. Next.
request
ಯಾಕೆ
for
ನಾಳೆ
hand
ಇದೆಯಾ?
delivery ನಾಳೆ ಇದೆ.
ನೋಡೋಣ, we'll see. ಕೊಡಿ.
ಅಚ್ಚಾ. Third.
Admission,
ರೆಸ್ಪಾನ್ಸ್
settlement.
ಸೆಟ್ಲ್ ಆಗಿದೆ 9 months ತಾವ್ ಹೇಳಿದ್ 9 months ಇದೆ ರೆಡಿ ಫಾರ್ 9 months
Yes sir.
I'm filing affidavit
Agreed, agreeable.
yes agreeable my lord I think is 32,000 rent arrears ಇದೆ
My lord,
Arrears.
my lord,
ಅವ್ರು ಹೇಳಿದ್ದು
ಇಲ್ಲ ಅಂದ್ರೆ ಅಡ್ವಾನ್ಸ್ ಅಲ್ಲಿ ಕೊಡಬೇಡಿ ಅಷ್ಟೇ.
ಇಲ್ಲ ಇಲ್ಲ, ಈ 25,000 we have settled, my lord. We'll pay that.
as per the concession I said 25,000 also no problem.
This court, the petitioner is before this court seeking the following prayer. This court on 19/6/2025 had passed the following order. In furtherance of the order, an affidavit is filed, affidavit of undertaking is filed by the petitioner and which reads as follows. 9 months time,
9 months.
9 months time is sought to deliver vacant possession of the property, and the petitioner is also undertaken that he would pay the rent diligently and also clear the arrears of rent, if any. In the light of the affidavit of undertaking, the learned counsel for the respondent submits that the proceedings be closed by recording the said undertaking. In the light of the settlement arrived at between the parties, as quoted herein above, the following order. The petition stands disposed on account of a settlement. The petitioner shall adhere to the terms indicated in the settlement as quoted, terms indicated in the affidavit of undertaking as quoted herein above. Any breach of the undertaking would be viewed seriously. Ordered accordingly.
My lord, may be recorded, my lord. What, my lord, arrears of rent, towards arrears of rent, my lord. They have not claimed the arrears of rent, my lord. Now they have said that there is arrears of
ಈಗ
rent.
ರೆಂಟ್ ಇದೆಯೋ ಕೊಟ್ಟಿದ್ದೀರಪ್ಪ,
ನಾವು
ಅದಕ್ಕೆ ಇಫ್ ಎನಿ ಅಂತ ಹೇಳಿರೋದಲ್ಲಿ. ಎಸ್,
We have
ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಮೈ ಲಾರ್ಡ್, ಇದರಲ್ಲಿ ಬ್ಯಾಲೆನ್ಸ್ ಅಷ್ಟೇ ಇದೆ. ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಕಮ್ಮಿ ಕಮ್ಮಿ
Yeah, maybe recorded, my lord.
32,000
That is ನಿಮ್ಮ affidavit ಅಲ್ಲಿ ಇದೆ.
We ourselves will pay within weeks, my lord. 25,000 is what we have spoke with them. 25,000 towards arrears will pay. And
Arrears ಎಷ್ಟಿದೆ ಸರ್?
32,000 ಇದೆ. ಅವ್ರು 25 ಕನ್ಸಿಷನ್ 25,000 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಆಯ್ತು,
ಅದಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇದ್ದೀರಾ?
ಅಷ್ಟೇ ಒಪ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು. Learned counsel for the parties would submit that they have agreed also on the arrears of rent to be at 25,000 rupees, which the counsel for the petitioner submits that the petitioner would pay. ಎಷ್ಟು ದಿನದಲ್ಲಿ?
weeks, my lord.
In a week's time. Yes.
And my lord, while vacating my premises, my lord.
ಹೇಳಿದಿರಲ್ಲ ಮತ್ತೆ.
I am ready to give it.
Next. 230 mood matter. ಇದೊಂದು ಅಡ್ಮಿಷನ್ ಯಾವ್ದಿಲ್ಲ ಕರೆದು ಬಿಡಿ. ಸೀಲ್ ನಂಬರ್ 50 ಅಡ್ಮಿಷನ್ ಆಯ್ತಾ? ಅದೇನಾ ಇದು? ಆಲ್ ರೈಟ್. Yes.
Lord, Dharwad bench matters.
Wait, ಎಲ್ಲಿದೆ ಸರ್?
30 more matters.
6 o'clock I'll take. Wait.
Satyanand
My lord, serial number 1. Initially this maintainability issue was not raised. Now, my lord, it has been raised. Lord, matter arises out of commercial court. CRP ಆಗಲ್ಲ. Writ petition ಬರುತ್ತೆ. Can it be treated, my lord, as by oversight ನಾನು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. Can it be treated, my lord?
Petitioner seeks leave of this court to convert the subject petition as one of GMCPC instead of a CRP. The said permission is granted for the statistical purposes.
Taken up tomorrow, my lord.
No, not tomorrow.
At least on Monday, my lord, because written statement.
Monday first convert ಮಾಡಿ ಹಾಕಿ ಸರ್ ಎಲ್ಲ.
Please, we'll do that. Much.
ನೀವು ಮಾಡೋದಿಲ್ಲ ಮತ್ತೆ ಅದಷ್ಟಲ್ಲೇ ಡೇಟ್. ಈಗ ಸಾಯಂಕಾಲ ಮನೆಗೆ ಹೋಗ್ತೀರಾ? ನೀವು ಆಫೀಸಲ್ಲಿ ಇರ್ತೀರಾ? ರಿಜಿಸ್ಟ್ರಿಲಿ ಕನ್ವರ್ಟ್ ಮಾಡಕ್ಕೆ.
Very well.
ನೆಕ್ಸ್ಟ್.
Number 2, yes. Shankarachar.
ಪೆಂಡಿಂಗ್ ಯಾಕೆ? ಶಂಕರಾಚಾರ್.
Vijay Kumar ke.
No representation. List on Wednesday.
Respondent Vijay Kumar.
Next.
Okay. Seal number 3.
Shivraj Patil.
Shivraj Patil.
Position was filed in the year 2007. TA was granted. Thereafterwards, your lordship, the land was acquired for the formation of Kempegoda layout, your lordship. Thereafterwards, your lordship,
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
ಈಗ ಅದು 10 sites have been executed by the BDA in favor of the respondent number 1 to 6, including my undivided share, your lordship. There is a remaining one site is available. That is
Just on Tuesday in preliminary hearing, the petitioner in ಎಲ್ಲೇ ಬಿಡಿಯಾ GMCPC ನ ಇದೆ?
GMCPC.
ಯಾಕೆ ಇಲ್ಲಿ GMCPC ಯಾಕಾಯ್ತು?
Your lordship, suit was filed.
Suit against whom?
Against the respondent number 1 to say, earlier, the only defendant number 1, your lordship, decision Rangamma.
What are you challenging here?
Here only you are sought for, then the injunction was
ಏನ್
not.
ಚಾಲೆಂಜ್ ಮಾಡಿದರೆ ಹೇಳಿ ಸರ್?
You are sought for mandamus, your lordship.
Mandamus?
Yes, your lordship.
For what?
Not to execute the sale deed on the notice.
Not to execute the sale deed.
Sale deed by the BDA in favor of the respondent number 1 to 8, your lordship, because notice were issued. The suit was filed, fresh suit was filed in the year.
Oh, no, sir. You serve on the respondents.
Your lordship.
I will not grant any ex parte order.
All 10 state, one day state will be the Swami are likely to be executed tomorrow or day after tomorrow, your lordship. Till then, your lordship, permit me to serve the notice.
Oh, no. Who are you all? Plaintiffs.
Plaintiffs.
What is your claim? Suit is of what year? 2007.
Earlier, so that was withdrawn with the liberty to file a fresh petition, your lordship.
Restraining the respondent 6 to 8 from alienating, encumbering. ಈಗ 39(1) ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. Notice was issued, your lordship, as per Annex RS. Thereafterwards, we gave a representation to BDA, your lordship. You are now wearing the pendants of the suit, your lordship.
You serve everyone by hand summons. The petitioner shall effect service of notice to all the defendants by way of hand summons and file an acknowledgement of such service by the 11th. List the matter on 16th in preliminary hearing. Status quo, the properties be maintained till the next date of hearing. In the event the petitioner would fail in serving any of the defendants, the interim order would stand automatically vacated. Yes. Huh? Oh, sorry. Yes, yes. In terms of the memo. Next. Sandesh Kumar.
4, Sandesh
My lords, I am plaintiff's writ petition, my lords. I have filed suit for declaration, possession and injunction, my lords. I am the absolute owner. I have purchased the property in the year 2006, my lords. From the family members of defendant number 1, my lords. The respondent number 1 here, my lords. Now, my lords, they are trying to encroach my property, my lords. They have encroached to the
Trying
extent.
to encroach.
They have encroached to the extent of 600 square feet, my lords. That for that I have.
ಈಗ ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಸರ್?
My lords, so declaration and injunction again to the.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, my lords. Page number 60, last document, 61 page number, annexure O.
Same order 18, all different, previous order ಮಾಡಿದ್ನಲ್ಲ same.
Let's order maybe hand delivery.
Hand delivery ನಾಳೆ. No hand delivery. Next.
For settlement, seal number 5, we look at.
482 petition, now parties has compromised.
Appealing for
Offense of
postponement, Your Lordship.
468, 471. The allegation is drafted the sale deed.
Lordship, filing wakalat for R2.
Council swords, ಜವೆ ಮರ್ತ್ಬಿಟ್ಟಿದ್ದೀರಾ? Settle.
Grant memo and affidavit.
Settlement ಕೊಡಿ. Next.
Please, Your Lordship. Oblige.
Order sheet signatures. 6, Sannaviya.
Pending matter ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
Lord, earlier, my lord, only notice was directed. my lord.
Pending matter 230 ಯಾಕೆ ಮೂವ್
Lord,
ಮಾಡಿದ್ದೀರಾ?
why? Because, my lord, the matter is posted for orders, my lords, by Monday, my lords. Otherwise, my lords, the suit will be dismissed. It is expressly.
An application has been filed seeking leave to withdraw the suit and file a fresh suit.
Where?
When the matter is posted for judgment. At the time.
A time of judgment.
It is not judgment, my lord. It is for argument. My lords, kindly see, 2024 only, my lord, third defendant filed a return statement. 2024, my lords, he has filed a return statement, my lords, narrating that he has also filed a suit, another suit for declaration. Therefore, my lord, I wanted to, instead of getting the plaint amended, my lords, I filed an application for order, my lord, withdrawal of the suit with liberty to file a fresh suit. My lord, it is my suit, my lords, for declaration and possession of a portion of property, whereas, my lords, the defendant number 3
Again,
claims
that is
that
rejected.
now it is rejected, my lords.
There is no formal defect is what the. trial
Formal
court-
defect, my lords, I have pointed out before the trial court, what the trial court opined, my lords, it is the plaintiff has not raised, my lord, his my lord, stand before framing of issue, my lords. When order 23, my lords, does not say that I should file such
Page
application
13
before framing of
Page
issue.
24 of the paper book.
50?
Page 24.
24, my lords.
24,
Para
para
19.
19. In fact,
It is very oldest case. The plaintiff has not made out any case that in spite of her due diligence, she could not have
Due
raised the matter.
diligence. But
But the trial court assumed
I
that
agree.
I have filed an application for amendment. It is not an amendment application. I wanted my suit to be withdrawn with liberty to file a fresh suit. Not
let
a
him
comprehensive
withdraw the
suit will
I
be
have
filed.
no
That is only, my
objection,
lords, I have sought
but
for.
Not without, he can always withdraw the suit.
Yes.
Not with liberty to file a fresh suit.
Because,
On
my
the
lord,
same cause of.
He has disclosed that he has filed one more suit.
Then
not for-
continue the suit, sir.
Please.
Continue the suit. 10 ವರ್ಷ, 10 years you have traveled in this suit. Why do you want to withdraw it?
Lord,
ಮತ್ತೆ ಇನ್ನೊಂದು suit 24 to 34?
Third defendant, my lord, raised a plea, my lords, that she is the beneficiary under the will of the year 2012. She
I
filed a
suit
return
will
statement, my lord,
direct
in
both
light
the
of
suits to
evidence.
be taken up together. That's all.
They're all there. And he has also filed a clubbing application that has been rejected
Fine.
in another suit.
There are 4 suits, my lords, that is why, my lords, I
ನಾ
want.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾರು ಹಾಕ್ದವ್ರು? Yes, what do you want to do?
Order may be passed.
Unless next week, yes.
ಅಲ್ಲ ಅದು
But time ಇಲ್ಲ.
otherwise ಏನಾಗತ್ತೆ ನಾಳೆ
Next week, yes.
7,
we become infectious. That is the
ಏನ್
problem.
ಮಾಡಕ್? We'll dispose it as having become infractions. Next.
Bhavana and Patil.
For petitioner, my lords. Lords, eviction order is passed, my lords, at page number 24, your lordship. It's a Waqf institution, my lords. I am a tenant in the Waqf institution, my lords. I'm a tenant, my lords, since 2009, my lords. Lease deed, my lords, is at page
ನೀವು
number.
ಪಬ್ಲಿಕ್ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರಾ ಅಥವಾ
Lords, it's a Waqf
ವಕ್ಫ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್?
Please, my lords.
Yes.
Lease deed is, my lords, at page number 40, your lordship.
Hostel.
Please, my lords, it's a hostel, my lords.
You're running a hostel or you're running a
It's a institution name is hostel, my lords. I'm running a shop, my lords.
shop?
Document number 5, page
Petitioner to
number
serve
40.
on the council who represents the respondent in the trial proceedings and file an acknowledgement of such service by the 11th list on 30th, 31st. There shall be an interim order of stay as prayed for till the next date of hearing. Next.
Hearing on IA, number 8, Akash Kumar Gowda.
Appearing for respondent.
Vacating interim order ಯಾಕೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ 2:30?
Kindly have it on Monday also.
ಅಲ್ಲ ಮೂವ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ?
ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದೆ.
ಯಾಕೆ ಮಾಡಿದೆ?
ನಾನು ಬೆಳಿಗ್ಗೆ ನಾಳೆಗಂತ ಮೂವ್ ಮಾಡಿದೆ, ನೀವು 2:30 ಅಂತಂದ್ರೆ ನಾನು ಅದಕ್ಕೆ
ಅದು ಬೆಳಿಗ್ಗೆ ರಶ್ ಎಲ್ಲ ಆಗುತ್ತೆ ಇವೆಲ್ಲ.
Please,
Yes.
have it on Monday.
Wednesday, Monday ಆಗಲ್ಲ. Wednesday.
Please.
Preliminaries, number 1,
Krishnamurti.
A suit for declaration and injunction is filed against me before the city civil court.
ಇದ್ಯಾವುದೋ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೊನ್ನೆ ಒಂದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ನಲ್ಲ ನಾನು.
Same party has filed a suit against me and my vendor in Madikeri, could not get the interim order.
ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಈಗ.
ಮತ್ತೆ ಈಗ city civil court ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. Office raised an objection that territorial jurisdiction is not there. The judge has decided that he has got the territorial jurisdiction, Bangalore City Civil Court, that too, and granted an interim order not to interfere and not to alienate the property against me. And that suit is still pending in Madikeri.
The petitioner to serve on the counsel who represents the respondents in the trial proceedings list the matter on 18th till such time the impugned order shall remain stayed. ಅದರಲ್ಲೂ ಹೀಗೆ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಿ interim order taken.
Order dated so and so stands stayed. Yes.
further hearing at 4.
ಅದರಲ್ಲೂ same order.
We'll see. B group alla will give dates. No choice. List number 1, one ನಿಮಿಷ. List number 1 ಕರೀರಿ ಮೇಡಮ್. Go to B group.
Lordship.
List number 1,
ಇದು ಕೊಡಿ, ಡೇಟ್ಸ್ ಇರೋದು ಕೊಡಿ.
Lordship, serial number 37, Lordship, disposed of matter morning. ಅದು both the parties shall appear on particular day ಅಂತ ಒಂದು ಸೇರಿಸ್ಬೇಕು.
ನೋಡ್ತೀನಿ ಅದು ಯಾವ್ದು. We'll see. Yes.
First of
We'll
August.
see. We'll see. Yes. Now call the B group.
37, Lordship.
B group.
list 1 B group matters 57 urgent, 58,
58, 22nd,
59,
22nd. ಅವರೇನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತಿದಾರಲ್ಲ ಬೆಳಗ್ಗೆ. Anyway, 22nd. Yes.
60 urgent, 61,
22nd,
62,
22nd.
63,
Those 20, all 22nd up to 60. ಮೇಡಮ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇರೋದೆಲ್ಲ 2 weeks ಅಂತ ಮಾಡಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲದೆ ಇರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ವಾ? ಹಾ ಸರಿ ಆಯ್ತು. I have not yet come there. Wait. 69 up to 69.
69, 2 weeks.
ಅದೇ 22nd is 2 weeks only. Yes.
I appear for respondent 69, Your Lordship.
Right, sir. One ನಿಮಿಷ. Up to 75, it is 22nd.
Much appreciated.
Yes. Interim orders ಎಲ್ಲೆಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಆಮೇಲೆ 76 ಇಂದ
76, 79.
1 minute sir. ಅದು then 23rd ಹಾಕಿ. 70 ಯಾವ್ದು ಕವರ್ಡ್? That we'll see. Yes. 77, 78.
I appear for 78, Your Lordship.
Petitioner 78, 23rd.
Much obliged, Your Lordship.
79, 78 in the till 83, 23rd.
79 is also covered. 83rd.
ಎಲ್ಲ ಅವತ್ತೇ ಬರ್ತದೆ.
84 ರಲ್ಲಿ notice ಇದೆ, connected ಮಾಡ್ತೀವಿ.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
83
24th. Yes.
connected matters are there, the notice is saying not
ನಂಬರ್ ಕೊಡಿ.
connected matters.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಇನ್ನ ಆಗಿಲ್ಲ.
ಅದು 83.1, 83.2 ಅಲ್ಲಿ ಎರಡೇ ಇರೋದಿಲ್ಲ ಸರ್. ಎಲ್ಲಿದೆ? ಹಾ ಸರಿ, ಇಲ್ಲಿ ಮೂರಿದೆ, ಅವ್ರು ಹೇಳ್ತಿರೋದು ಇನ್ನೊಂದಿದೆ ಅಂತ. ಎಸ್ ಸೊ ಅದ್ರಲ್ಲಿ ಯಾರ್ಯಾರು ಮುಂಚೆ ನೋಟಿಸ್ ಆಗಿದೆ ಅದೇ ಕೊಡಿ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್
Hearing on IA 84, criminal.
84 ಇಂದ interlocutory up to 84 to 89. 1 minute. 84 to 89. 84 to 88 list on 25th. 89 ಏನು?
I have made deposit before the commercial court. The court said you have no jurisdiction, file it before Kanpur court. On that day, what I want to withdraw that amount and deposit it before the Kanpur court.
89, very nice.
Adalli,
Very nice.
Sir,
Yes sir. 89 ಇರಿ ಸ್ವಲ್ಪ. Wait. You wait sir. 89 ಇರಿ. Wait.
There they want to be continue the evidences, therefore.
No, ಬೇರೆ ಎಲ್ಲ ಬೇರೆ ದಿನ. That intermodals will continue.
86, in serum 86.
Then final hearing also on particular date. Now come to the second list.
Automatic continue. 25.
97.
230 list, 230 list.
This is that CRP, IRP matter. Jagdish shall. This has to go.
This also has to go because the reason is that company has already been ordered to be liquidated.
No, 1 minute. This,
In charge of this.
ಇದನ್ನ
We have filed an application for release of certain.
ಒಂದು ನಿಮಿಷ. The list on 18th at 2:30 PM ಅಂತ ಹಾಕಿ.
98.
ಅದು ಈಗಲೇ ಇರೋದು ಅದೇ 2:30 PM. We'll see. Yes.
98, madam.
Intermodal subsisting will continue.
98. Allah, 98 is.
Manjunath Prasad.
Yes, madam.
98.
My lord has already heard this matter.
I know,
Second
18th.
case. 18th, madam.
18th, yes.
99.
This I have heard already. And I had, you have given some idala, evidence or something. Atrocities Act ಇದೆಯಲ್ಲ ಅದೇ ಅಲ್ವಾ ಇದು? This will post this on Wednesday. Yes. 99 Wednesday. 1 ನಿಮಿಷ ಸರ್, 73 ವಾಪಸ್ ಹೋಗಕ್ಕಾಗಲ್ಲ. Yes.
100.
100 18th. Right, sir. 18th, yes.
101.
ಎಲ್ಲ all 18th ಹಾಕಿ ಮೇಡಮ್. All other matters 18th. ಮೇಡಮ್ 18th ಬೇಡ, ಎಲ್ಲ all these parted matters 18th ಹಾಕಿರಿ. Yes.
Serial number 1.
ಬೇಕಾಗಿಂಗ್ ಸ್ಟೆಪ್ ಒಂದಿನ ಹಾಕ್ತೀನಿ ಮೇಡಮ್. ಏನ್ ಮಾಡೋದು ಮೇಡಮ್? ಹಾಕ್ತೀನಿ, 1 ನಿಮಿಷ ನೋಡ್ತೀನಿ. ಎಸ್,
List number 2.
ವೇಟ್ ಮೇಡಮ್. ಎಸ್
All on 18.
ಮೇಡಮ್ ಒಂದಿನ on Wednesday, interlocutory applications and B group will be in the forenoon, preliminary hearing afternoon, so that ಬೆಳಗ್ಗೆ will see what can be done.
Serial number 105.
Serial number 86, madam, can it be have it on the order?
No, ಅವೆಲ್ಲ ಆಗಲ್ಲ. Yes, next.
At the earliest.
No, don't.
25 ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಎಲ್ರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
Number.
My lord, serial number 114.
List number 2.
My lord,
Matters.
serial number.
51.
ಯಾಕೆ ಇಲ್ಲೇ ಮಾತಾಡ್ಬೇಕಾ? ಎಸ್, ಈಗ ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಯ್ತಾ? ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಯ್ತು, ನಥಿಂಗ್. ಎಸ್, ನೋ ಆಸ್ಕಿಂಗ್ ಎನಿಥಿಂಗ್.
37, your lordship, first. A common date may be given, your lordship, disposed of matter.
Wait, yes.
37, your lordship.
Wait, sir.
Morning it was disposed of, a common.
Wait, sir. Yes.
51.
51 to 2021. all on 23rd GMCPC. Interim order, the list after 2 weeks. B group interim order ellide adella list after 2 weeks. Where interim order is not there, list them on 23rd. one ನಿಮಿಷ. ಎಲ್ಲಿವರೆಗೆ?
74 street light pattern.
Wait. 77. Interlocutory ಎಲ್ಲ list next Wednesday ಹಾಕಿ, that is 23rd. All interlocutory applications on 23rd. ಎಷ್ಟೊಂದಿದೆ? Yes.
Further
Interim orders will continue.
104.
ಅಲ್ಲ 74 ನಂದೊಂದು short date fix.
1 minute, sir, 1 minute. Yes.
104 for the respondent, your lordship. 21st, your lordship.
21st.
21st,
Yes.
both the parties.
Yes.
Great.
Both the matters ಯಾವುದು?
Both the parties have.
Parties, yes.
105.
21st, yes.
For petition, my lord. 105.
105. 105 to up to 115. List them on 25th.
My lord, 114, my lord, I have given one list, my lord, it should be tagged along.
Madam, ಅದು ಅಪೀಲ್ ಇದು ಇರೋದಲ್ಲ? ಯಾವ್ದದು ಕನೆಕ್ಟ್ ಯಾವ್ದದು?
114, my lord.
ಲಿಸ್ಟ್ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡ್ತೀರಾ ಮೇಡಮ್? ಇಲ್ಲ, ಗೌತಮ್ ದೇವೇನ ಕೊಟ್ಟಿದ್ದಾರಂತಲ್ಲ.
Rare matters, madam. Rare matters.
Whatever, yes. ಅಲ್ಲ ನಂಬರ್ ಟ್ಯಾಗ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. It can be disposed ಅಲ್ವಾ?
It can be disposed, madam.
ಮಂಡ್ಯ. Yes. ಈಗೇನು ಒಬ್ಬೊಬ್ಬರಾಗಿ ಹೇಳಿ. Don't create chaos. ಒಂದು ನಿಮಿಷ. ಆಯ್ತು, we'll see. Bharat, yes, next. I have given a date already, yes. ಸರ್, ಈಗ ಯಾವ ರೀಚ್ ಆಗಿಲ್ವಾ ಈಗ? ಕೊಡಿ. $56. One moment. One moment, sir, one moment. VB Shivkumar. ಏನಾಯ್ತು? ಆಯ್ತು, ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆಯಾ? List the matter on Monday. Yes. Monday in preliminary hearing had. Infractions close ಮಾಡಿ. Yes, Murthy sir. Of the second list, directed me to yes, ಅದು ಕೊಡಿ. Advocates Clerks Association. What has happened?
Lord, I have prepared a chart. Complete charts for him. What will not is with respect to the number of wakalas filed from 22.
ಆಯ್ತು, ನಟರಾಜ್ಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ಟು I will take it next week. Give a copy. Ivat, because yesterday I was on leave, 2 lists, otherwise only 1 list. Yes.
Millets.
So can this be at?
It will be in only 1 list, sir. Yes.
Let's have.
2:30, that will be there, yes.
Millets 118, my lord.
118 ಅಷ್ಟೇ, ಶುಕ್ರವಾರ ತಗೊಂತ.
My lord, 110, my lord, 110 is for the grant of, first list, my lord. It's for grant of the 2 acres alternate land from the forest department.
Clifton ಇರೋದಲ್ಲ?
Within Hegdesa's
Yes, we'll see. Real time ಆಗುತ್ತೆ.
Any date, my lord?
Yeah, ಎಲ್ಲ 18th I've given already, yes.
Second list,
50.
115. Second.
ಏನಾಯ್ತು, ರೀಚ್ ಆಗಿಲ್ವಾ?
14.
ಪಾಟೀಲ್ ಸರ್ ಯಾರಿಗೆ? ನೀವಿರೋದು ಸರ್? ಅಲ್ಲ, 14 15?
14.
ಯಾವತ್ತು ಹಾಕಿದೆ ಮೇಡಮ್? ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು. ಮಂಡೇ ಬೇಡವಾ? ಫ್ರೈಡೇ? ನಾಳೆ ಕಷ್ಟ. ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆ, ನಾಳೆ ಬಾರಿ ಕಷ್ಟ. ಮತ್ತೆ ಇದೇ ತರ ಆಗುತ್ತೆ ವೆನ್ಸ್ಡೇ.
Lordships, list two, serial number 62. It is a res judicata, Lordships.
So you are withdrawing the petition?
No, I am for respondent.
Then wait, sir. Yes. 62.
The next date when it is listed, can it be listed in the preliminary hearing list? That's my only remark.
Huh? Inter-mortem ಇದೆ.
Inter-mortem, you would like it to be delegated back to the trial court.
Then if that is the case, then we'll post it in preliminary hearing. We'll see. 18th or 25th, we'll see. Yes.
Dharwad bench Supreme Court remand.
ತಗೊಂತೀನಿ, ಒಂದು ನಿಮಿಷ.
My lords, list number 2.
ನಿಮ್ಗೆ ಮಾಡ್ತೀನಿ, don't worry. Yes.
My lords, list number 2, serial number 61, my lords. The matter is posted for judgment tomorrow, my lords.
61.
Yes, my lords.
List number 2.
Yes, my lords.
Yes, we'll see list that tomorrow.
Please, my lords.
Tomorrow ಆಗಲ್ಲ, Monday. List is closed already. Yes, take an adjournment there.
My lord, serial number 113.
ಅಷ್ಟೇ, 113. ಏನ್ ಪೆರೋಲಾ?
Parole is a heart patient, my lord.
Heart patient.
Yeah, 65 years old. It's before center for decision.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಕಳಿಸಿದಾರಾ?
It's before center, my lord, for decision. For past 1.5 years.
Cabinet ಮುಂದೆ ಕಳಿಸಿದಾರಾ?
Cabinet, my lord. For 1.5 years, no decision has been taken, my lord.
Why do you do
Until
this?
further orders can be taken. The 30.
He's heart patient, sir. And 20 years ಆದ್ಮೇಲೆ he's been recommended for.
Lord, I press MOFA boys like until further orders in Supreme Court.
ಅದು ಕೊಡಿ. Extension of parole ಅದರಲ್ಲಿ.
113.
ಇನ್ಯಾವ್ದಿದೆ extension of parole? ಪ್ರದೀಪ್ ಪಾಟೀಲ್ ಯಾವ್ದು ಇದ್ದಾರೆ? ನೀವೇನಾ?
Only one, my lord.
Yes, ಅದು extension of parole ಇವತ್ತು ಮುಗಿಯುತ್ತಾ?
ಇವತ್ತಲ್ಲ, on 17th.
ಆಯ್ತು, ಸರಿ. List ಅದು extension of parole grant another 180 days ಕೊಡಿ. Or
until further orders ಕೊಡಿ.
Wait. ಅವ್ರು ಮಾಡೋದೇ ಇಲ್ಲ ಆಮೇಲೆ.
Serial number 111, my lord. This is the Paris Women's case, my lord. The matter may be heard and
Spurti.
disposed of, my lord.
1,26,000.
My lord, they have been postponing since forever, my lord.
ಒಂದ್ ನಿಮಿಷ, ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಏನ್ ಮೇಡಮ್?
111, my lord.
111 to 111 list on Monday. ಎಲ್ಲಿದೆ ಮೇಡಮ್ 111? ವಿಚ್ ಲಿಸ್ಟ್? ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಅಂತ ಮಾಡಿ ಮೇಡಮ್. ಅಷ್ಟೇ. ಎಸ್, 180 days ಅದನ್ನ ಹೇಳ್ತೀನಿ ಜೀವ ಈಗ. ದಟ್ಸ್ ಎನಫ್ ಸರ್, ನೋ ಮೋರ್ ಟೈಮ್. ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್ ಸರ್ ಮಾತ್ರ ಇರಿ. ಎಸ್, ವೈ ಆರ್ ಅದರ್ಸ್ ವೇಟಿಂಗ್?
37.
ಆಯ್ತು, ನಿಮ್ಗೆ ಹೇಳಿದ್ನಲ್ಲ,
One date maybe.
ಹೇಳಿದ್ನಲ್ಲ 37. ಎಸ್, ವೈ ಆರ್ ಅದರ್ಸ್ ವೇಟಿಂಗ್?
74
more dates. Yes, I have already given dates, no alteration.
Make one mention also.
No alteration.
ಇಲ್ಲ, 74
one ನಿಮಿಷ, wait. No more dates in any case.
ಇಲ್ಲ,
Why are you waiting?
74 ಅದೇ
I'll just wait.
ಅದು ತಾವು ಡೇಟ್ ಕೊಟ್ರೆ
Street light ಇದು serial number ಏನು ಸರ್? ಸೀತಾರಾಮರಾವ್ ಸರ್.
74 ಸ್ವಾಮಿ.
90?
74.
ಸೋಮವಾರ ತಗೊಂತೀನಿ.
ಆಯ್ತು. ಅಲ್ಲ, ಲಿಸ್ಟ್
Others need not wait. Yes, ಅವರು ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್. ಇನ್ನೊಂದು come. Yes.
Serial number 110, my lord. The slum matter, that which my lord had heard.
I have heard everything, sir. That's the problem. Yes. I should not hear so many things. Yes.
25th.
Next week. Yes.
May I please?
Yes, sir.
Not award passed by.
I did not see you.
Smart meter.
Smart, but I did not see you at all. Wait, I'll just clear up this.
The award passed by.
Others
MSME.
need not wait, please. No alteration in dates. Yes.
The award passed by MSME, my lord, was challenged before the commercial.
You are the judgment debtor.
Yes, my lord.
Correct?
Yes.
What do you want to withdraw?
They want to. I am filing a memo. Now the question of territorial jurisdiction was raised. The commercial court said that you have no jurisdiction, go to Kanpur. I have filed the 34 petition before the Kanpur court. Kanpur court has directed to deposit the 75% amount, which I have deposited here. In the meanwhile, the commercial court are ordered for execution. That is the reason I was before your lordship, and your lordship has stayed the proceedings in the execution petition.
I have stayed release of amount also now.
I don't want the release for
Then
myself.
what?
It is to be transferred to the Kanpur court.
Even that also. 1 ಕೋಟಿ ತಾನೇ ಇದೆ.
My lords,
this
it's
is the
31
issue.
lakhs.
No, is
1
this-
lakhs 500. I'll tell the exact amount, my lords.
No, where is the order, companion petition?
He has not served the writ papers to me.
Sir, the
My
paper.
lords, it's been served. Their signatures are there on
ಯಾರಿಗೆ serve
the
ಮಾಡಿ?
presentation form.
ಇದನ್ನ.
They are there.
ಇದೆಲ್ಲ ಮಾಡಿ.
My lords, and even the IAs, I have sent an email.
Yes, may make a
They have received that as
ಇಬ್ರು
well.
ಹೇಳ್ಬೇಡಿ, 1 ನಿಮಿಷ.
They have received, my lords had asked for the IAs.
ಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸಿದಾರಂತೆ.
I have,
Copy ಕೊಡಿ.
I will give the copies for the IA, my lords, for the.
You
writ
give
petition.
the copy of the entire set. Heavens are going to fall?
Yes, my lords.
Heavens are going to fall if you give it?
No, my lords.
Please keep.
Absolutely.
No, I have made an application, Lord, to withdraw the amount. That application was rejected by the commercial court, saying that you cannot withdraw it. File a petition before the territorial court. Now I have filed the 34 petition before the Kanpur court. Kanpur court has directed me to deposit this 70%. Thereafter, my lord, I have made one more application, bringing it to the notice of the commercial court that the order passed by the Kanpur court. Now an order is passed to release the amount to pay, to deposit before the Kanpur court. That is all, my lord.
ಆಯ್ತು ನೋಡಿ. Yes.
My lords,
ನಿಮ್
the
ನಿಮ್
IAs
petition ಕೊಡಿ, ಅವ್ರ ಕಾಪಿ ಕೊಡಿ ಅಲ್ಲ.
have given the.
Give a
IA
copy. List on Tuesday. Yes. Both the matters list on Tuesday. Entry matter subsisting, both the cases shall continue.
Much
Yes.
obliged.
We'll decide on Tuesday.
ಇಲ್ಲಾದ್ರೂ ಕಟ್ಟಬೇಕು, ಅಲ್ಲಾದ್ರೂ ಕಟ್ಟಬೇಕು.
ಅದು ಈ ತೀರ್ಮಾನ ಮಾಡ್ಬೇಡ.
No.
My lords, there is constructive
But the
res
problem
judicata
is-
to their estoppel also applies because they enjoyed the stay by depositing the amount
No.
here. It is only after the jurisdiction,
Yes.
or point of jurisdiction was answered that the execution was filed. 110 days of delay, my lords, filing it there.
It is for the Kanpur court to decide.
Right.
I had the benefit
That
of
is
it.
a separate question that needs to
No.
be answered
Ultimately,
before Kanpur courts.
Ultimately, I have to deposit before the Kanpur court, where he can make an application for withdrawing that amount. How he is prejudiced?
Well,
My lords, they
no, no,
have
that was-
obstructed the
that-
execution process.
That was of grave urgency moved the other day. So I have protected
I
both of
understand,
your
my lord.
interest.
Yes,
I'll
ma'am.
take it on
Allah,
Tuesday.
these are the facts. If
No,
they are-
see what senior says is correct. That what is the prejudice that would ensue if you go and take it from
My
the
lords,
there?
I will
not have any
tell
objection
the
for withdrawal of the amount
issue
to the
before, my
Kanpur
lords.
court.
Section 36(2) does not bar the execution proceedings to continue
Correct.
during the pendency
That
of
is not a
34.
bar.
That is settled.
Yes.
My lords, the second aspect is why they have been given the stay, my lords. My lords had perused through the orders the other day when I was
Yes,
appearing.
attachment.
Yes, attachment was passed. They said that the deposit is also there, but nevertheless the attachment is passed.
So how
Correct.
can the amount lying in a
That
wrong
was-
court
My lords.
can be attached?
My lords,
ಬಸವರಾಜ್ sir, ಯಾಕೆ ಒಂದ್ ನಿಮಿಷ.
my lords, I have made a full compilation of cases as well.
Give it.
Tie
Give-
upon.
You give
I
everything.
will give a
whatever
copy
you
to
want.
them
I'll take it on Tuesday.
and I will also
My problem
provide-
is before the Kanpur court, it is on 15th.
Today's 10th, my lords.
Either
Alla, here also, no, today is 10th, but next date is
There is
15th
time,
is
my
what
lords.
I'm telling.
I am neither here nor there. He is enforcing execution.
I will see, yes.
Well,
As
We'll
they
take
have
I will-
fraud the
I will
execution
become
as well.
remediless if,
14.
Bailiff report needs to be looked into.
14.
They have thwarted, my lords.
Why should he
And
make all this?
Monday.
I have not played any fraud.
my lords,
34 court said you are not here, you
if I
go
touch
there.
upon the statement
Immediately wants
on
to
the list
execute
of
the order.
events, my lords,
We'll take it on Monday, sir.
their conduct will be clearly visible. if I touch
Monday.
upon it. Yes, my lords.
What conduct you are.
Monday preliminary hearing.
Please.
Yes, both the matters. Yes. Now, yes, ಒಂದ್ ನಿಮಿಷ ಅದಕ್ಕೆ ಮುಂಚೆ ವೈಭವಿ ತೋಡೆ. ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
Yes, matter. My lords,
ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಮೇಡಮ್.
there are connected matters, my lords. There is already interim order against all
The
other.
tender ಮ್ಯಾಟ್ರಾ?
That is serial number.
Which is this trend? Which is this matter, Vibhav?
My lords, this is offense under 306 and 504, my lords.
3.3.
3.3 is the fresh.
Stay ಕೊಟ್ಟಿಲ್ವಾ?
Yes, against accused number 4, the fresh petition is filed, my lords.
There squash ಆಗಿದೆಯಾ?
A1 is cost, my lords. A2, A3, A5,
Yeah,
interim
who
order
is
is
there?
granted.
Girija madam is there?
She was there until 5.
ಕೊಡಿ.
Still number 1.
Still number 3.
Which is the petition that is quashing ಯಾವ್ದು?
3.3, my lords.
ಅದಲ್ಲ.
Uh,
ಬೇರೆಯವರು ಕ್ವಾಶ್ ಮಾಡೋದು ಯಾವ್ದು?
uh, My lords, that I've marked in my petition, 3.3.
3.3.
Yes, my lords.
ಯಾವ್ದು ಕೊಡಿ?
Page 202, my lords. Against A1, it is quashed.
3.3 A1 ಕ್ವಾಶ್ ಆಗಿದೆಯಾ?
Yes. My lords, 202, my lords, page number.
3.3 ಕೊಡಿ madam. There are 4 matters. What are these?
No, the offense is the matter is the only one, my lords. There are different petitions, my lords, filed by different petitioners in the same proceeding.
Oh, this is page 202 is accused number?
1, my lords.
A1. ಆಮೇಲೆ ಇವರೆಲ್ಲ ಯಾರು?
These are accused number 2, 3, 5 and
ಈಗ
4.
criminal petition 102287/24 accused number?
Accused number 4, my lords.
ಆಮೇಲೆ 3.1?
Looks like 3.1 accused, my lords, accused number 2, 3 and 5.
2, 3 and 5.
5.
3.2?
That is accused number 3, my lords.
3.1 is accused number 2, 3.2 is accused number 3, 3.3 is?
Accused number 4.
ಮೇಲ್ಗಡೆ A4 ಅಂತ ಹೇಳಿದ್ರೆ 3 ಗೆ.
My lords, I was referring to fresh petition 3.3, my lords.
Other
Apologies.
petitions are already there.
Yes, my lords.
What is the offense?
306 and 504, my lords.
That bank da idu?
Yes, my lords. He committed suicide, my lords.
Correct.
The column number 17 is at page 19, my lords.
I have quoted everything in the
Yes, my lords.
earlier order. Then same order will pass.
Yes, my lords.
You tell Girja madam if there is anything, then we'll have to recall it.
Yes, my lords.
You ask her, call her and tell her.
Yes, my lords.
We'll take it as disposed in terms of page 202 JY. Same order. Different accused. Adu ಯಾವ petition li ಯಾವ accused
Yes,
ಅಂತ
I'll
ಬರ್ಕೊಳ್ಳಿ.
write down, my lords.
Write down and give. Yes.
Obliged, my lords.
Yes, next. All 4.
Your Lordship, serial number 4.
Serial number 4. ಧಾರವಾಡದ? Yes, sir. ಇದು ಟೆಂಡರ್ ಅಲ್ಲೇ ಬರಲಿ. ಅದಾದ್ರೆ ಸಕ್ಸೆಸಿವ್ ರೇಟ್ ನಾನೇ ತಗೋಬೇಕು ಹೆಂಗಿದ್ರು ನಾವು. This release the matter from status of being part heard, post the matter before the bench having roster. Yes. Interim order, if any, shall continue till the next date of hearing.
Number 1,
Gauri Shankar Mott, admission. Next Friday, Haki. Already wait.
Yes.
Yes. Huh? Next Friday. Huh? 2, I'll take 1 night. Yes. ನಿಮ್ದು ಯಾವ್ದು?
62 Lordships. Serial number.
ಅದು ಡೇಟ್ ಕೊಟ್ಟಾಗಿದೆ. Yes. ಅದರಲ್ಲಿ ಏನು ನೋ ಚೇಂಜ್ ಇನ್ ಡೇಟ್?
No, Lordships. I prayed for opportunity where one clarification is required. That's all.
ಅದು ಅವತ್ತೇ ಬರಲಿ. Yes. Next. Take that. Abram, not today. ಇನ್ನೊಂದು ದಿನ ತಗೊಂಡು. Petitioner ಎಲ್ಲಿ? ಪರಮೇಶ್ವರ್ ಹೆಗ್ಡೆ.
You have sealed cover of charge. The sealed cover in the charge.
ಕೊಡಿ. ಜೈ ಬೈ.
serial number. Serial number.
430. The 8 volume of charge sheet, not I have separate, but it is only an index of the charge sheet.
ಅದು ಸಾಕು ಕೊಡಿ. 8 ವಾಲ್ಯೂಮ್ ಅನ್ನು ಬೇಡ. ಅಲ್ಲೇ ಇರಲಿ ಅದು.
ಕಂಪ್ಲೇನೆಂಟ್ ಗೆ ಎಲ್ಲ ಗೊತ್ತಿದೆ.
ಇಲ್ಲ,
ಅವ್ರಿಗೆ ಎಲ್ಲ ಗೊತ್ತಿದೆ.
8 volumes charge sheet and you want me to interfere?
No, it has been done when after my lord has given them a permission to go ahead with the investigation, but do not file a charge sheet with the prior permission.
ಇದು ಇಂಡೆಕ್ಸ್?
Yes. First order ತಾವು ನೋಡಬಹುದು ತಾವೇ ಅದರಲ್ಲಿ why the investigation is not completed. Then they have
raised some grounds. We'll answer those grounds. It will come. It will repeat from Tuesday. ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು?
Monday or Wednesday.
Monday ಆಗಲ್ಲ. Monday again same thing. Wednesday, yes.
At 2:30 Your Honor. I will not take
2:30
more than 11 minutes.
Come,
11.
why 11?
That's all.
Come at 4:30 then.
4:30. 11
You come at
minutes.
4:30.
I came today at 4 o'clock.
Oh, good.
I couldn't get inside.
That's fixed.
AG was able to somehow manage. He's
Come
learned
at-
the art of getting inside.
Getting out also.
Come at 4 o'clock.
Yes.
Yes.
Best.
Now, two matter, Giridhar, why are you waiting?
That's a matter for dictation, my lords, it was listed.
ಯಾವ್ದ್ರದ್ದು ಏನ್ Giridhar ಅದು?
120 CRP, my lords. Suit filed after 19 years. with
No, that's,
cancellation.
I would have reserved it, but pile up ಆಗುತ್ತೆ ಅಂತ ಸುಮ್ನೆ ಇದ್ದೀನಿ ಅಷ್ಟೇ.
ಆಯ್ತು.
Yes, ಇರ್ಲಿ
Any
ಅದೇ
day
ಸ್ಟೇಜ್,
to the
ಅದೇ ಸ್ಟೇಜ್
convenience.
ಅಲ್ಲಿ ಇರ್ಲಿ. It will come Tuesday, Wednesday we'll do it.
Great.
Yes. Yes, call that smart AG ಇದಲ್ಲ smart meter.
160.
115.
Names ಎಲ್ಲ ಇದೆಯಾ? Accused numbers.
Numbers are written.
Yes. ಇದಾದ್ಮೇಲೆ ತಗೊಂತೀನಿ. Be here. Yes.
May I?
ನೀವು ಯಾರಿಗೆ?
I appear for the connected.
Oh, you are there today. Yes.
After my Leonard.
Madam, adjourn ಮಾಡಿದೆ.
After my Leonard.
On 15th. All right. Yes.
After my Leonard completes, I'll just ask.
Your Lordship, on the last occasion, it
Sure.
ended with,
You can go.
it ended with the fact that two issues were raised by them, the respondent stating that it is not the cost of the meter, it's the billing. And the second point was that it is postpaid, not prepaid. Two issues they had raised. Your Lordships, and then they had also mentioned about iPhones, iPhone 10, iPhone 16. There's a huge difference.
Z Fold 7 and ಹೇಳಿಲ್ವಲ್ಲ.
Then they withdrew the Nokia, it went on to iPhone 10 and iPhone 16. Now you can't compare apples with oranges, at least those come under the same genus. This does not, this is a smart meter.
Not even the species.
Not even the species. Now with respect to a smart meter, Your Lordship, it has to pass the test of an IS. It is 16444
ಅಂದ್ರೆ
IS standards. 16444. In that, Your Lordship, the basic requirement, the qualification, the structure, the features, the specifications, all mentioned. Only if a smart meter is able to meet up with the IS 16444 standard, can it be even taken in or participate in any of the processes all over India. They also have a BIS certification. They have to cover all of that. Your Lordship, in a smart meter, it comes even in the IS certification, it comes under twofold. One is item 1 and 2. One deals with entirely commercial and industrial, and one deals with entirely residential smart meters, Your Lordship. Therefore, the question of it being, there are different smart meters. One could just be like an iPhone 10 or one could be having features of iPhone 16. It does not arise. All smart meters would have to meet to those standards. The only thing is that there would be different manufacturers. Different manufacturers have actually been suggested to apply with BESCOM earlier through one of their notifications stating that all of you can participate, and for 1 year, we would consider all of you. That is what came to be withdrawn when this tender came up. Your Lordship, the RDSS scheme, in the RDSS scheme.
That is the government of India.
That the government of India. In the RDSS scheme, all the smart meters are for 10 years. Now this, they have imposed upon the citizens of Bangalore is only for 5 years. Now, any product which has a 10-year warranty is always priced much more than a product with a 5-year warranty. And therefore, Your Lordship, the questioner stating that these smart meters are different, those smart meters are different will not arise. In fact, the very person who is part of the manufacturing here is the successful person in Rajasthan. Therefore, they cannot have any variations. I shall also come to the other states and explain. But in very brief, Your Lordship said it's 999 here. It's nearly 10,000 there. Now to explain that, Your Lordship, what happens is in some states, it's about, say, about 6,000 rupees, some states about 8,000 rupees. But what the respondent was only accurate in, the only thing that they were accurate with was 15% subsidy that the government gives, or 900 rupees.
That's a matter of record. They cannot vary it.
Yes, and that is why that
But
was
the
accurate. Your Lordship. Now, the way that goes and the difference here, Your Lordship, 900 rupees is what the central government is giving. So the 900 rupees is all that is paid for the smart meter. Now, assuming a smart meter is about 2,000 rupees, which is what Karnataka rates actually are, contrary to the 5,000 that they're charging. If a smart meter is, say, about 2,000 rupees and central government's giving about 900, round it off at 1,000. The balance 1,000 rupees, again, is not paid by the consumer all over India. The balance is collected from the pool. Now, the difference there is all over India, everybody is shifting completely to smart meters. Whereas in KERC, the regulation says it's not compulsory or mandatory, whereas the guidelines have made it mandatory and then differentiating between pre and post. Now, coming to this, what happens then is, say it is about, say, 8,000 rupees in Rajasthan, Your Lordship, about 1,000 rupees is being given by the government, 7,000 rupees remains. That is over a period of 10 years. Now, over a period of 10 years, meaning 700 rupees per year, Your Lordship, which would then mean divided by 12, maybe about 60 rupees is all that goes. This 60 rupees also, Your Lordship, is all the consumer probably pays. Even that goes from the ESCOM's pool, and that is the collection. And the difference also with the RDSS is whether it is with respect to maintenance or service or purchase, it's all inclusive. Contrary to here, where it's 5,000 rupees for a single phase, and there even a 3-phase, Your Lordship, here 3-phase is nearly 10,000 rupees and 13,000 rupees in one of them with the additional voltage. Now here, Your Lordship, what happens is that there is no question of paying even for maintenance or any such thing. But in BESCOM, what they have done is they make us pay 9,000 rupees for a purchase of a smart meter, which is not required anywhere in India. Secondly, they make us pay nearly 5,000 rupees or so for maintenance. For a 3-phase meter, it is nearly about 8,000 rupees or so. 14,000 rupees or so for maintenance, which would not even arise anywhere across the country. That is the small little difference, which it ends up that the consumer here in Karnataka is being completely fooled and is being made to pay, which nobody in the entire country pays. Now, coming back to the RDSS, yes, they have to have a nil balance for a state to take up RDSS. Therefore, BESCOM should have had nil receivables from everybody. There was about 50 crore due from BBMP, etc. All of that, Your Lordships, yes, there are some good officers.
All of that is serviced by this?
All of that, probably. But Your Lordship, here what I'm coming to is that BESCOM ultimately cleared all of that to apply for this RDSS scheme. But just before that, they conveniently came up with this tender. And now we have lost out on even applying for the RDSS because that subsidy with the central government would have to give us is gone. Therefore,
they will not insist on you taking smart meter at all.
That is all right, Your Lordship. Even if I don't take up a smart meter, as last time they said, affidavit could be filed.
Yes.
Then it comes down to, then why are all of those who are not taking a smart meter paying for that smart meter? That's what it comes down to,
That's
Your
the
Lordship.
clarification I will take.
That's it'll come down to. Your Lordship, might I take Your Lordships to the rejoinder?
Matte. Rejoinder.
Your Lordship.
Ah.
Your Lordship, page 52. Sorry.
Yes.
Page 52, Your Lordship may kindly see. This is the official memorandum of 12/6/2024. Page 53, sorry, Your Lordship. I'll get back to 52 after this, Your Lordship. Further, that's the second paragraph. Further, in view of KERC terms and conditions for green energy open access regulations of 2022 dated 12/1/2023, Reliance Jio Infocom Limited, vide letter dated cited under reference so-and-so, has issued conditional approval for installation of smart meters at 691 numbers of LT sites at various places, subject to certain conditions. One of them is the agency should approve vendor approval for smart meters from BESCOM by duly observing procedure. Now, Reliance was just one of them. So what they stated was whoever wished to could apply. Now, however, there's no vendor approval procedure in place of smart meters, which needs to be formulated. So KERC was required to formulate that, which hasn't happened. Next, Your Lordship may kindly see, next page at page 54, number 3. The smart meter specification, single phase, three phase, LT, three phase, CT operated and HT meters shall be specified by Central Electricity Authority, and Your Lordship may kindly see /IS. This is what is most important. We would have to require that
International-
IS 16444 standard
That is
specifications.
Indian standard.
Please. And that would be required. So the question of having different iPhones will not come into question over here.
iPhone.
iPhones.
Oh, all right.
REC under RDSS. Here again, Your Lordship may kindly see the RDSS, which is specifically mentioned here. Any deviation in specification shall be reported. Lordship may kindly see next paragraph 5. The validity of vendor approval shall be issued for 1 year or till finalization of smart meter tender, whichever is earlier. Therefore, Your Lordship may kindly see KERC on 12/6/2024 with number 5 was already getting ready for the RDSS. So it said the vendor approval will be issued for a year. So they asked all the vendors to actually come forth and apply. Therefore, there would have been a much more transparent system where directly the manufacturers would take part in this entire process. But this did not ultimately fructify. Your Lordship may kindly see page 52.
I'm there only.
No, Your Lordship.
I'm there, I said.
Page 51
You
is
read
deceased.
50, you read 53 and 54
54.
now.
Your Lordship, I'm going back to Central Electricity Authority notification.
It is
of
page
2022.
52.
51 and 52. In page 52, if Your Lordship sees number 3, this speaks of in regulation 4
All
of-
consumers in areas.
Your Lordship, this is very important because they have referred to a completely wrong regulation in their objections. In regulation 4 of the said regulations, in sub-regulation 1 for clause B, the following shall be substituted. Namely, it's not even saying that it will be amended with further, subsequent effect, prospective effect. Your Lordship, it says shall be substituted. This is of 2022. 2022. Now, what they have referred to in their objections, Your Lordship may kindly see their objections in R2 and R3's objections. Your Lordship, at paragraph
R2 and R3, that Panindra sir appears. Howda?
BESCOM.
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 Who represents BESCOM? Niven. Yes.
At page 6, Your Lordship, paragraph 15, 16. In Your Lordship has 12/9/87. Since they had given
Adralli?
their objections were switched. That's
We'll
why,
open
Your
this
Lordship.
like this.
Please, Your Lordship.
Both petitions.
Your Lordship, if Your Lordship has the same paragraph, because I think they had given ours in their matter.
In 12/9/87, what page number, madam?
Page 6, Your Lordship.
Averment in the petition.
No, their objection statement. Give us one more, please.
Objection of 2 and 3, is it?
Please.
Page?
Page 6. Your Lordship's copy has para 16 onwards, 15 onwards and page 6, Your Lordship.
Yes. Page 6, yes.
Page 6. Your Lordship may kindly see Para 16, it is submitted that owing to the advanced technology and convenience in using smart meters, the Central Electricity Authority amended the Central Electricity Authority installations and operations of meter regulations with CEA Regulations 2019. Wherein it directed all new consumer meters should be smart meters with prepayment feature. Now they are saying that due to these regulations, it was compulsory that it had to be smart meter with prepayment feature, and they extract 4.1.
All new consumer meters.
Please, Your Lordship, this is the old 2019. What I read to Your Lordship. Para 18, Your Lordship, that is
The relevant portion of the rule 4.1b. All consumers in areas with communication networks shall be supplied electricity with smart meters working in prepayment mode.
Your Lordship may kindly see, I had read page 52. That is the amended.
This is what was pointed out. This was the earlier rules. The para 18 is the present rules, what is produced. So therefore, my lord, we have stated all the facts there.
52.
Of the rejoinder.
52 of the rejoinder.
Your Lordship.
52 of the rejoinder.
52 of the rejoinder, Your Lordship.
All right.
This deals with.
What is stated?
Paragraph 18 deals with IS. I'm aware of that.
IS?
Your Lordship, what they stated in
IS.
paragraph 18 is with respect to all consumers in areas communication network.
Madam, Indian
shall-
standard ante helbidi. IS bada.
Please. Your Lordship may kindly see para 18 what they refer to, and what I'm reading at page 52 is of complete relevance in view of the fact that, Your Lordship, in regulation 4, that is at page 52 para 3, in regulation 4 of the regulations, all consumers in area with communication network shall be supplied electricity with smart meters working in prepayment mode, conforming to relevant IS within the timelines as specified by the central government, provided that all consumer connections having current capacity beyond specified and relevant shall be provided with having automatic remote, provided further that in areas which do not have communication network, so and so, so and so. Therefore, Your Lordship, this deals with two issues. One, there is no monopoly that any of the manufacturers could step in, whoever had the license under the IS 16444. And next, Your Lordship, at para 4, in regulation 6A, 6A says, consumer meters shall generally be owned by the licensee. Your Lordship. And next is, with the third line, Your Lordship, ownership of meters shall remain with advanced metering infrastructure service provider during the contract period. Therefore, Your Lordship, the question of us purchasing all of this does not arise. The ownership remains with them. Therefore, what happens is their investment is, for example, equivalent to Rajshri in any of the other states would be.
Rajshri?
That is the successful bidder. Yes. The equivalent in all other states
Successful
is.
bidder, yes.
Correct. So 1,000 rupees is paid by the central government. What they put in is balance around 1,000 rupees. How do they benefit with that? Over the period of 10 years, they get nearly 6,000 to 8,000 rupees. Not about
you
them.
should be worried about the tax on the consumer. How
Of the
much they get,
consumer.
why are you
That
worried?
is all. No, we are saying about how the
How much
payment
Rajashri will
goes.
get, why are you worried?
We are not, Your Lordship, we are talking
Consumer
about what the
tax
provision is.
ಎಷ್ಟಾಗುತ್ತೆ consumer ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅದು ಸರಿ.
Your Lordship, if that is the case, we do not have an issue with them at all. It's about the price. If the price is altered, they could continue with whoever they wish. It is not an issue about who's the successful tenderer. It's about the pricing. If I in Bangalore have to pay 10 times more than anybody all over India, it does not make sense. Secondly, nobody all over India pays for maintenance or service charge or anything because it is all inclusive. Whereas here, we have to continuously pay. If I may take Your Lordship towards what we are
Where
paying.
is that maintenance thing?
Please. Your Lordship, my petition.
Which petition I'm holding?
Writ petition 12,987. Page 77, 78, Your Lordship.
77?
Please. At 77, this is the contract award, Your Lordship. At page 77, On the left side, your lordship may kindly see. For a single phase, it's 4998. Lordship has that? Page 77.
That is the maintenance,
Maintenance is on page 78.
all
In
right.
77, it is only the cost of the smart meter.
Where is the maintenance here?
Upfront payment, your lordship may kindly see table 1. So single phase is 4998, three phase is 8880, and three phase with LT is 15,000, your lordship. And on the right hand side, if your lordship sees at page 78 with the respect to the maintenance, the last column, your lordship, at 2.4. Lordship may kindly see, for a single phase, we pay 9,000 rupees, which is besides the 5,000 rupees that we have paid.
I'm sorry for intervening, my lord. To be borne by the BESCOM, heading is to be borne by the BESCOM.
To be borne by respective BESCOMs of Karnataka.
Therefore, not by the
Nobody said
consumer.
anything. Your
Not by
lordship,
the
if you're going to
consumer.
have
Oh,
this
is
jack
it-
in the box kind of an argument, your lordship, then
No, not that, but it is, if it's to be borne by BESCOM, then
that
why?
is precisely what we have been saying. It goes from BESCOM to the successful provider. Where does it?
Successful?
To the successful tenderer.
Rajshri.
Please. Now that payment goes to them. How it goes is.
You're
seven-
worried about Rajshri getting more money or consumer tax getting taxed?
Your lordship seems to think so. I would be able to convince your lordship, as I think I have repeated myself several times. It's got absolutely
No,
nothing
that's
to do with
exactly,
it.
you have already said everything that you have said. I have made a note of all this. You give a complete notes of arguments, whatever you want to give.
Please.
We'll see what is the consumer hit by all this.
On this, your lordship may kindly see 9,000, 14,000 and again 14,000. This is separately paid. If now they
No, there's
claim.
9,000, 14,000, 160.
Yes.
And 14,160 is the cost that the BESCOM is going to bear.
BESCOM is bearing ultimately from which money, your lordship?
So from
Ultimately,
the
it is our
consumer's
money.
money is what you say.
If it
So
was,
not only buying is taxed on the consumer, even the maintenance is what you want to say.
correct. And it is not just that. In over here, it's not just the smart meter person who is paying it. All of us who have not
Consumers.
even taken a smart meter are
Correct.
paying for it.
Who are not smart also are to
Who are
pay.
not smart also
Yes.
are paying for it.
Yes.
Might have proceed further, your lordship. In
No,
the rejoinder,
got
there are
it, madam.
several other
Ashte.
points. Ashte illa, your lordship.
ಇನ್ನೂ ಇದೆ ಇದರಲ್ಲಿ.
In contravention with the central government rules.
That you have told already.
Your lordship said.
Ilva?
I
Yes,
shall
tell
add
me.
it up in my arguments if
No,
your
no,
lordship.
tell me. Yes. What is that in contravention? It's 6 o'clock alva ಅದಕ್ಕೆ ಹೇಳ್ದೆ.
I understand, your
Or,
lordship.
yes.
I don't,
Now tell me what is
we
it?
could
Yes.
have it tomorrow if you lordship.
ಮತ್ತೆ it gets repeated again at the same time. ಅದಕ್ಕೆ you tell
Mr.
me.
Navatgi also still has to argue.
Who?
And Mr. Navatgi is also,
Yeah, how long will you take, sir?
Management has substantially covered all the points. I do not propose to take any,
Not propose to argue at all.
not propose to take much time.
Much time.
5 to 10 minutes, not more. It is one compilation they have, the compilation, one second.
the rate.
There is a
in
compilation of
Karnataka.
the various smart meters installation in different states of the country.
That's what.
One ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. One judgment of the Supreme Court, I want to rely on locus standi. Only that's the, after my amendment completes.
Might, if your lordship bears with me for another 5.
No problem.
Your lordship, rejoinder, your lordship. Rejoinder page 244.
One minute.
Sorry? It starts from. It starts from 213. Your lordship, this is 213 is the common schedule. This is the Energy Department common schedule of rates for KPTCL ESCOMs 2023-2024 at 213.
And
Now the schedule for smart meter is at 244. Your lordship may kindly see serial number 408.
408, 411, 412.
Absolutely, your lordship.
Yes.
Please. So therefore, they have to only charge us 2,000. It's their own words. So they could not have charged us 5,000. If it was for the three phase, it's only 2,700. We're paying nearly 10,000 rupees, 9,000 rupees for it. So therefore, this they could not have gone against their very own document is what I'm trying to say, your lordship. Your Lordship, I shall take your Lordship to the comparative analysis of other states and complete it.
Ha, that's
Please.
right.
This is at page,
Where is that?
please. 276. 276 is Goa.
ನಿಮ್ದು ಆಗಿದೆಯಲ್ಲ
ನಮ್ದು ಆಗಿದೆ ನಮ್ದು.
ಆರ್ಗ್ಯುಮೆಂಟ್?
It's over then only.
ರಾಜಶ್ರೀ ಅವ್ರದ್ದು ಆಗಿದೆಯಲ್ಲ?
ಅವ್ರದ್ದು ಮೀಟರ್
ಅವ್ರದ್ದು ಮುಗಿದ್ರೆ ಮೀಟರ್ ಅಂತೂ ಓಡ್ತಾ ಇದೆ.
Smart
ಸ್ಮಾರ್ಟ್
meter.
ಮೀಟರ್ ಇಲ್ಲ ಎಲೆಕ್ಟ್ರೋಸ್ಟಾಟ್ ಮೀಟರ್ ಗೊತ್ತಿಲ್ಲ.
Yes.
Open and give me. Your Lordship, 263, Your Lordship.
Yes, I am there, madam.
Please, Your Lordship. This is the Rajasthan tender, Your Lordship.
Yes,
270 is the relevant portion.
yes.
At 270, Exhibit B. Your Lordship may kindly
Yes,
see
I'm there.
900, 900. Three-phase 900, three-phase CT 3,450.
Lump sum payment per unit is 900.
Yes, Your Lordship.
3 phases 900.
Please.
Single phase is 900.
That is all that is payable.
Maximum is about 3,450 here for industrial 3 phase.
That is commercial, Your Lordship.
The commercial.
There is a balance 8,000 something. It's written. The next one, Your Lordship, would be at,
ಇದು ಯಾವ state ಇದು?
that was Rajasthan.
All right.
276 is Goa.
Goa?
276, Your Lordship. 289 is the relevant portion.
ಅಲ್ಲೆಷ್ಟು?
900 and 900 rupees, Your Lordship.
West Bengal? 303?
1,800 in West Bengal.
Yes.
The variation is the amount, Your Lordship. They would, the misleading aspect is they'll say that is 8,000, this is 6,000. That's not the case. None of that amount comes from the consumer. So what happens is that 900 is paid by the central government. Balance is paid by whoever is the successful bidder there. He will put in his 1,000 rupees or so, which is the cost of a smart meter, which I showed Your Lordship with the KPTCL. So what they do is the 1,000 rupees that they put in, they get it by way of later on from the ESCOMs pay them monthly. So if it is 8,000, it's 7,000 rupees for the whole 10 years maintenance, all inclusive, along with the cost of the smart meter. It will come to 700 rupees per year, which will come to about 60 rupees per month. That is all that would be payable. And even that would go from the pool. And the pool, it is all right in other states, which is being collected from the consumers because all of them have opted for smart meter. Here is not such a case.
There is no choice here.
Correct. And all of us do not mind shifting to the RDSS scheme because all of us would move on to smart meters, which brings down, the entire purpose was to bring down the cost for the consumer, which is not happening over here, Your Lordship. Your Lordship, if Your Lordship wishes that I could convince Your Lordship even on the locus, which they have been going on
ಅಲ್ಲ
raising.
ಅವರೇ ಲೋಕಸ್ ಮೇಲೆ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ.
Please, they,
Division of labor.
tariff, Your Lordship, there is one issue of tariff. There is a tariff petition. Your Lordship, I shall put that in the written arguments. Any alteration or any increase in the rate or the tariff that a consumer has to pay, it has to be put forth before the committee for approval, which is not done. So any alteration to the pricing would have to go up. Tariff petition would have to be put forth, whether it's under central rules or whether it's under the Karnataka rules, it would have to go through. Those pages also I shall put forth, Your Lordship. With respect to the locus, Your Lordship, I have a series of judgments. Division bench of our Honorable High Court, one of Your Lordship's judgment also.
Division bench.
Please, Your Lordship. Division bench, Your Lordship, of our Honorable High Court. In fact, in that matter where they said there was a fraud
Which
and a
is mine,
signature.
locus?
Please,
Locus
can you
mine?
pass on? This is whose? Huh? ಇಲ್ಲ, ಇಲ್ಲ, ಇದು ಅವ್ರದ್ದಾ? Page 370 straight away, Your Lordship. After that, I'll go back to. Starts from. Starts from. 346, Your Lordship. 342 is the judgment.
Oh, this is that KDB.
342, please.
Huh.
Your Lordship, at page 370, Your Lordship would kindly see. Paragraph 19. In the aforesaid narrated facts, glaring enough they are, are noticed, what would emerge is that the board is silent on the alleged violation of its property
Gets
that was
blurred.
leased.
We'll see.
Please, Your Lordship.
Blurry vision.
Blur, yes, correct, Your Lordship. That gets blurred. And Your Lordship, Your Lordship, is in our division bench judgment, Your Lordship, says an argument to the contrary would do a lot of disservice to public interest in so much as no person other than a rival claimant can challenge the grant, and therefore even the grants that are otherwise unsustainable would go with impunity if the rival claimant takes refuge in silence. Writ courts, in a sense, being the custodians of public properties. Your Lordship, passed it on,
this
yes,
is-
please. This is at page 10, Your Lordship, of the judgment. It says that
Justice-
Nelson's eye, Your
Justice
Lordship.
Dixit.
Please,
Yes.
please. The words are very clear
Yes,
in
of
that, Your Lordship, and says that the idea, of course, in a different terminology, has animated view of the learned single judge, do have locus and locum. This is it. And Your Lordship, several other judgments with respect to guidelines having to be in conformity with the rules.
That comparative prices of different states, they have made it right. Now, lords, for the purpose of the convenience of the court, lords, we have made it into a tabular column.
Yes,
It is
it's-
supported by
it's correct,
documents.
yes.
If lordships could see the cost of smart meter in Karnataka, first page itself.
Yes, that is travels up to 9,000.
Yes, right. Now, lords, about, no, 13,998.
Yes, yes. Cost of
Maintenance.
single smart meter.
Gujarat, lords. is
Idu
the-
including maintenance. ಅದು?
including maintenance.
Gujarat is 900.
It comes 900. Outstanding amount payable for installation of Sadagu, that is the.
6,000 ಇದೆ ಇಲ್ಲೋ?
ಬರುತ್ತೆ. ಇದು ಒಂದೇ. This is the second highest, 6,663. That is over installments. Now kindly see Uttar Pradesh, no, next page.
2,706.
Then my lord, Madhya Pradesh.
1,770.
1,770.
2,718.
Delhi is 2,780.
5,760. 4,755.
That is Orissa is 5,760. Punjab is again 4,775. Now, my lord, it looks, my lords, on the face of it, that Karnataka seems to be not only the highest, but almost 3 times, 4 times than what is being paid.
Karnataka seems to be at the top.
Top.
Yes.
Not only top, but disproportionately, it looks like a higher
top ಅಂದ್ರೆ
price. That's fine.
at the
Now, my lord,
highest,
one
yes.
aspect, my lord, I must bring to lordship's notice, my lords. It is now, my lords, almost the court cannot sit as an expert to assess the price, etc. Is the one of the possible arguments the respondents are justified and entitled to make. For that, my lords, my answer would be, when on the face of
Only one request, though I'm not a party in his, since it has a bearing, if they can provide one copy.
Yeah, definitely.
Copy ನನ್ನ
Sure.
party ಇಲ್ಲ ಅಂತ
ಇದೇ
copy
ತಗೊಳ್ಳಿ.
ಕೊಡಲ್ಲ ಅಂತ. Copy ಕೊಡಲ್ಲ ಅಂತಾರೆ ಅವರು.
No, no.
Because it will have a bearing.
No, 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 no. How can?
You want to
how
say it,
can they
take
say
it.
not?
No, no, I am only requesting, I
No,
asked
Lord,
the
let
council.
Lord, let everybody
I am not a
assist.
party.
Madam, ಇದು ಕೊಡಿ. ನಾನು ನೋಡಾಯ್ತು ತಗೊಳ್ಳಿ.
No, no, they'll give.
I have scanned it through.
That is
Yes.
meant for the court.
No problem. I have scanned it through. You can take it. Yes.
So I am only trying to submit this before your lordship. On the face of it, when it is shown before the court, that the prices seems to be completely disproportionate to what is being.
So he is a successful tenderer.
Correct,
Rajashri, how can you not give him?
No, 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 I'm not, no, they will give. It should be. There is no question whether they are party or not. They must be given. Ultimately, everybody can assist your lordships to arrive at the correct analysis or the truth. Therefore, my lord, my submission before your lordship, notwithstanding the established theory that the court cannot sit as an expert, but on the face of it, when it is shown, the price does not have any foundation at all. What was the benchmark for them to start is something the state must explain before your lordships. The conspicuous absence of which, and when there was no benchmark itself, clearly shows tremendous amount of doubt in the way the entire thing has been conducted. Therefore, my lords, ultimately, but I am told, how many meters are there in the state of Karnataka? You said
2 crores 23 lakhs.
2 crores 23 lakhs is the total installation in the state of Karnataka.
State of Karnataka?
Yes.
The entire state, ಇದು? Not Bescom.
18,000.
Not that, ಅಷ್ಟೇ ಅಲ್ಲ.
One second, sir, one second. Electricity connection.
Electricity connection.
Correct,
Smart
no,
meter ಅಲ್ಲ.
no, smart meters eager. What I'm saying, ultimately bringing to lots.
2 crores.
No, it is 2 crore 23 lakhs, totally the electricity installation.
Electricity installation.
That's all
ಅದ್ರಲ್ಲಿ new, old ಎಲ್ಲ ಇರುತ್ತೆ.
No, if ultimately everybody opts for it, which is seem to be an advanced state of it, then the implication or the impact is huge, is what I want to support. Secondly, my lord, and it could turn out to be possibly one of the biggest financial, I won't use the word scam, I'm very conscious, but the way fallout will be something of huge consequence. Therefore, but that is something which we must bring to lordship's notice.
ಎಷ್ಟು electricity installation?
2 crore 23 lakhs
into 9,000.
ಹೌದು, ಅದು ಇಲ್ಲ, ಅದು 13,000.
Into 13,000.
13,698 rupees. It's huge. The numbers are huge. No, yesterday I calculated. I do not want to.
ಕೊಡಿ, ಮೆಮೊಲ್ ಕೊಡಿ.
What is the number? What was
ಇಲ್ಲ, ಅವ್ರಿಗೆ
the number?
ರಾಜಶ್ರೀ ಗೊತ್ತಾಗ್ಲಿ.
18,000 crores.
I will be more than happy if so much of money would come.
You have yesterday he told. Huge. The numbers are huge. I'll ask them to give the figures. If all the
difficult to count the zeros.
They have done it actually. If all the electricity installations in the state of Karnataka are ultimately, if everybody opts for that, then it has a huge implication.
So then it should be 900 only.
It has to be. It has to be the benchmark. This is not. They can't take people for a ride like this. I mean, this is something which is of tremendous public importance. Secondly, about this very argument that petitioner is only a consumer, we will either give him or not give him, is not an argument.
Problem, sir, as I've told madam also. Yes. Two things. One is your locus, and she has given some, madam has given some judgments, I will see. Division bench.
Honorable Supreme Court.
That's the.
No, I'm straight away citing before your lordship one principle which
there is no stay of anything in the division bench, right?
No, division bench.
Your lordships are inquiring about stay of tender or work.
Stay of tender or work in the PIL, nothing.
No, division bench may be examining this issue, but it's all right. I mean, nothing wrong in that. We are
before your lordship. Division bench is examining the same thing.
I don't know. I'm very.
That's division bench.
We are challenging the virus of it. There, even the tender is being raised, which we have not argued at all before your lordships. The tender.
No, the two primary issues would arise for your lordships.
That's the only thing.
The two primary issues. Number one, whether the insistence on all persons to seek for smart meter installation is permissible. Number one, in the light of the KRC guidelines, which has been argued.
So, you argue madidira, you argue madidira locus. Then division bench pending iddo, I take up.
No, but ultimately, nobody has made that submission before your lordship.
Yeah,
right? No, let them make that submission. No, but I will for my answer.
Single council pandinda the first answer madi adanne anta
heltira. I have a straight away. If they want, it would be embarrassing for them to come before your lordships and say something. Let them make their submission before the division bench.
As to what? I'm taking it.
No, but if the division bench are to make, if they are to make that submission before the division bench, but we will see what.
If you are suggesting that they should tell the division bench, the learned single judge is hearing the matter.
I did not. No.
They did mention, and it wasn't interfered with. They mentioned.
No, I'll put it across in this way.
And it wasn't interfered.
When lordships have heard the matter at length today, I mean, over a period of time, if they want this papers to be drawn, this matter to be drawn to the division bench, the proper method, appropriate method is not to mention that before the learned single judge, but to mention it before the division bench and let the division bench take a call is all I want to submit. Apart from that, today, what is that we have presented before your lordship?
No, I have no problem. Northeast is a beautiful place. Northeast is a beautiful place.
Anyway, I don't want to. No, I don't want to say anything more. But this will not be the forum or anything.
In this season, you know.
No, I don't want to say anything more on that. But on the question of locus standi. No, if one second, please. If the Advocate General's submission is that the lordship should not hear the matter. If that is the submission,
so he is not saying hear the matter.
No.
Matter is pending before the division.
No. If
he wants this court to reject the petition on this score,
then
matter is pending before that's his submission. He would never say that. Don't hear the matter.
In fact, he can't say. But I'll clear this issue. Something which is in air very clear. Let me be very clear. And it's not that we are trying to over anxiously seek lordships to decide something when the matter is division. Certainly not. I'll put it across in this one. If the learned Advocate General or the respondents feel that since the matter is pending before the division bench, Lordships should ultimately draw these matters to the division bench. Ultimately, in so petitioners are concerned, my lord, in so no, kindly
should
look at
draw?
our situation. Today, my lord, we have,
Division bench should draw this matter,
it
sir.
is for them. Therefore, my lord, the appropriate method for them is to mention before the division.
What's the
Learned
next?
friend says, they did mention, I do not know, I am not privy to that.
I'll mention Madadara.
They mentioned that the same thing is pending over there and verbatim the same thing. And nothing was interfered with. They just said file your objections and rejoinder if any. That's all your work.
My lord, our preliminary objection is, my lord, this is a sponsored litigation.
That's okay.
No, sponsored
No problem.
litigation. Pleadings in this writ petitions is.
Are verbatim similar to the PIL.
Therefore, no, then that's a good, that's
ಅದು
an
ಒಂದು
argument.
comparative chart ಹಾಕಿದ್ದಾರೆ. Comma, full stop.
But I am not, that's an argument by the respondents for lordships to reject this petition on the ground of it being not instituted bona fide. That's fine. I am not, so I take it normal. I take it and
No, that's why I told whether I examine bona fides or otherwise, as the judgment I have written, when this is projected of an action of a state under Article 12, who projects it gets blurred.
becomes
No,
messenger.
it gets blurred. So I am only examining it that so that the consumer,
Correct.
the citizen should not bear the brunt of what they are
So far as we are
wanting to
concerned,
do.
ultimately, my lord, insofar as I am concerned or my friend's client is concerned, we are all persons who are consumers who are before your lordships. Really, in that sense, my lord, as to whether the state has committed a scam or a fraud in awarding contract to XYZ is not our concern, because we are not party to that.
It's
We
not
are
the
not
concern
interested.
of this court, because I am not, the scope of this petition is not
That. We are only interested in to ensure that, my lords,
If I am convinced, yes, they have some justification in
certain
doing
lordship will
this,
dismiss the
then-
petition. But
then
still,
I'll leave everything
still
to
the
the
question
division
as to whether
bench.
tender was in accordance with the public procurement.
That is
Act,
before the
etc.,
division bench.
decided by the scope
See,
of the
tender is challenged before the division bench. I guess so. Yes. Readings may be the same, because tender is challenged before division. I only want justification of this,
Got the price.
of the pricing,
Yes.
that the consumer should not bear the brunt.
And Lord,
That's
I'm
all.
sure, Lord, now as I have understood the learned
That is
advocate
all
general,
that I want.
But even if I have understood the learned advocate general correctly, even they are saying
You
that
not
lordship-
understood him still?
If I have understood it correctly, it is not that they are saying that lordship should not hear the matter. They say kindly hear the matter on merits and decide it. That note should be taken on record. Now, lords, the last principle of locus standi, lords. Lord, the very well celebrated principle in Ramdas Shenoy's case is always we draw, where the question was, I'll just explain in a sentence before I take the lordship, only one paragraph. The question was whether a building license granted in a municipality, that is very famous Udupi municipality's case, any other person who was no way concerned could challenge it by way of a writ petition. Similar argument was advanced in 1974, saying, how are you concerned when the license is granted to somebody else in the same?
No, that is, if license is granted contrary to law.
Contrary to law, contrary to the legal obligation, contrary to the statutory duty, every ratepayer has a right. But kindly see now the relevant portion.
Every consumer has a right. That's what
Certainly.
told.
Kindly see, my lord, the telling sentence at paragraph 24 and then, my lords, 29. May I request lordships to kindly see 24, last few sentences commencing from the word the question. The question whether an individual who is one of a class or for whose benefit such an obligation is imposed can or cannot enforce performance by an action must depend on the purview of the legislature in the particular statute. Injury may be caused either by the fulfillment of the duty cast by the statute or by failure to carry it out or by negligence in its performance. Now kindly see para 29.
Yes.
The court enforces the performance of a statutory duty by public
1883.
Yes. Now, lords, ultimately,
Madison was the
yes, they have.
Courts of equity should not drive anybody away.
Yes. And today, my lord, what is that we are saying? There is Electricity Act, regulations framed up by the Karnataka Electricity Regulatory, this one. And in fact, there are several provisions in the Electricity Act. I do not want to, where, my lord, this whole level playing field of electricity, lordships are aware, changed post 2003 when an unbundling of this public sector in the form of KPTCL came to be, and they were all made into distribution companies. Generation of electricity became privatized without license. Transmission became privatized, etc. And therefore, it was thrown open as part of what they call as the third reform generation, third reforms, electricity, coal, etc. Therefore, my lord, there are several provisions today where they said price must be highly competitive, must be transparently fixed, and should be attractive to consumers.
No, it is competitive among tenderers.
In so no, as per and my lord, that whole act today is consumer centric. It is consumer centric, and these are the factors, my lord, when today, my lord, when we are speaking of electricity field, I don't think this concept of locus standi, etc., has been really, my lord, something which has not been. Every consumer, when in fact, my lord, I can share with lordships with a personal experience in the regulatory commission, my lord, most of the litigations are initiated by consumers by filing petition. I'm just bringing to lordships.
Article 226.
No, it's therefore it is much larger. What I'm trying to say is not the most of the litigations.
Courts would be loath to interfere unless
these are the things. Nothing much.
Yes, sir.
One no rejoin. Synopsis, lordships.
ಈ ಕಡೆ ಕೊಡಿ. ಅದು 5 o'clock ಆದ್ಮೇಲೆ ಎಂಟ್ರಿ ಒಂದೇ ಕಡೆ.
Other court officers.
Just take 2 minutes.
2 minutes.
Just 2 minutes. Apart from the fact of locus, my lords, and the issue that similar issue is pending before the division bench, my lords, what is actually thought to be done is challenge the operational guidelines, my lords. And first, insofar as operational guidelines, it is only an internal document for the department how to operate, my lords. What, in fact, your lordship had directed me to or sought to file an affidavit clarifying our.
Yes, that's what I wanted.
I'll just give it to the other person. In fact, only to satisfy your lordships on two most important aspects, my lords, with regard to the cost of smart meter, what was thought to be made out, my lords, is saying whether the consumers have been burdened. I pointed out your lordships, my lords, it is when was my learned friend was reading, it will be borne by the BESCOM. It will not be transferred from any pool fund. There's no concept of pool fund or any other fund which will be taken. I've stated that in the affidavit clearly, my lord, to say that.
We'll see. Continue.
That's all.
Already exhausted.
Please.
Aru kala.
So basically, what your lordship.
Well, we'll take it on Monday. Or inno arguments nimdu idiyalla innu.
If we can, because we just want to clarify on that cost factor.
Monday, Rahul. Abhishek, tell senior it's too late today.
Monday, your lordship.
Monday, we'll continue it on Monday. Let's see. Monday, 4 o'clock melene. Monday on half an hour.
Maximum.
Ibru seri.
Please.
But may I make one
Tuesday or
request?
Wednesday, lordship, I have Supreme Court.
Monday we'll close it. Monday you're not there?
Monday.
You finished anyway, colleagues are there.
We'll have a rejoinder.
Matte
sure.
rejoinder.
Then, my lord, rejoinder.
Sir, rejoinder.
It can't end then.
No, it's over. Clarification I'm asking with regard to this, this rejoinder, agle our submissions rejoinder ಆಯ್ತು ಎಲ್ಲ ಆಯ್ತು.
Your lordship, on the first date of hearing, your lordship had asked them
ಆಯ್ತು,
to
you want,
submit.
then I'll post it on Friday. Next Friday.
Wednesday, your lordship.
Wednesday. Next